Today, my niece's birthday, Norma, I don't want to touch this. What's today, the what?
Good morning, everyone. This is for whomever is asking somebody to please say something to test your audio.
Can you hear me?
Hello, can you hear me?
Good morning.
Morning.
Morning, Lori.
Morning,
Good
everybody.
morning, all.
Yes, sir.
Can you hear me?
Yes.
Okay.
All right, ladies and gentlemen, I was about to start court, but Adobe has for some reason decided to sign me out. So I have to go and sign back into Adobe. Give me a moment, please. I can't look at my dockets otherwise. Give the people who are joining right now a moment to get logged in. All right, I'm going to begin by calling the criminal and civil dockets. I'll ask for announcements from the attorneys. Anyone who's present who doesn't have an attorney or whose attorney is not online to answer for them, just make sure I know that you're here. Other than that, please keep the microphone on your device muted. State versus Sandy Ayala. Anyone?
Here.
Have you heard from your attorney?
No, he just told me to log in. I haven't heard from him since Friday.
All right, we'll check on Mr. Cabanas.
Okay, thank you.
State versus Adam Roberts.
Good morning, Your Honor. This is Doug Daniel. I saw Mr. Roberts logged in, and we just need to get a new date on this. Adriana Biggs and I are working on it. I saw that the 3/23 date was the reset date. We would just ask to be able to agree with that on with Ms. Biggs and then put that into a chat for confirmation.
That'll be fine. State versus Angel Pena, or Angel perhaps.
I believe it's Angel, Judge. I'm present on that. I have had no contact with Ms. Pena. And
Okay,
frankly,
mark note recall. State versus Ryan Garcia.
In custody, Your Honor.
Your Honor, he's in custody, and that is going to be a trial track case. I will. We're requesting the 3/23 date, and I'll type that in chat.
Jimmy Joe McBride.
Your Honor, this is Brian Powers. I'm present. I have Mr. McBride on cell phone with me. He wasn't able to figure out the Zoom.
All right, I'll mark you conferring.
Thank you.
Angel Espita Tovar.
Good morning, Your Honor. This is Doug Daniel again. Mr. Tovar is here in my office, and we're scheduled to do a plea on his motion to proceed or motion to adjudicate this morning. We're ready for that.
All right. Noel Rodriguez.
He's in jail, Judge.
Have we heard from Ms. Bush? Check on her. Jennifer.
We have no.
Ms. Hunsiker? All right, no show. Sean Griego. Mr. Gear. All right, no show. Gerald Fernandez.
Judge, that's my case. Me and Mr. Fernandez have already spoke this morning. We'd like to reset that to 3/23. That should be a trial.
Okay. Well, send that to me in chat.
Yes, sir.
That's what's going on.
Turn that down, would you?
Eva Mahia.
In fact, if you would just,
Eva Mahia, okay. No show, Frank Briones.
Good morning, Your Honor. Council's present. Mr. Briones is in my lobby, and I've got him here. I'd like to confer.
I'll mark you confirming, Mr. Campion. Abel Esquivel.
I'm present, Your Honor. He should be on. I'm not sure. He was gonna log on from his sister's laptop. And I have talked to him this morning.
All right, I'll mark him no show and I'll recall.
Okay, thank you.
Ryan Javier Garcia.
An announcement, Your Honor. I've already posted all the dates in chat.
All right, thank you. John Martinez.
Your Honor, I'm present for him. We will be resetting him. I believe he's Graciela Martinez.
Yeah, we're here.
He's present. So we're just going to reset him for the 3/23 date as well.
I don't mark you confirming for right now. Patricia Ann Davis.
What do you think?
Good morning, Judge. I'm present for Miss Davis. And Miss Davis, if you're online, if you'll just speak up. Thank you. Judge, we are conferring with the state, and there's a couple of things I want to talk to them about. If we can just remain on docket for that March 23rd setting.
Okay, and well, you'd have to send a reset in chat. Did she answer?
sir.
I didn't hear.
Who will I speak to about civil suit?
Patricia Davis.
Okay,
All right,
we'll get in touch with her. I thought I heard her speak up, but maybe not.
Mark her no show for right now. Justin. All right, Ms. Bush, I'm going to ask you to keep your computer muted. I'm getting back feedback. Justin Whitaker.
good morning, Your Honor. This is Doug Daniel. I'm here for Mr. Whitaker. He should be on, and if we could move that to the March 23rd date.
All right, Mr. Whitaker, are you online? All right, I'm going to mark him no show for the time being. Kendall.
I'll work on that, Judge.
Yes, this is Justin Whitaker. Can you hear me?
Yes, I'll mark you conferring.
Okay, thank you.
Thank you, Judge.
Kendall Hinnant. No show. Roland Martin. No show. Magdalena Aguirre.
Present, Your Honor, for Miss Aguirre, and Miss Aguirre, again, if you're here, please speak up. Our office will be in touch with her. We'll try to get her online, Judge.
Marker no show for the time being. Michael Bato or Batot.
I'm here for Mr. Bato, Your Honor. He is with us as well. He's identified as the phone number, the 512 area code ending in 140. But he is with us and we will confer.
Okay, thank you. Greg Martinez Jr.
Good morning, Your Honor. This is my case. Mr. Martinez is incarcerated. He's a trial case, Your Honor, so if I could have the next court date coming up.
Okay, that was probably posted before you were here. It's 3/23. If you'll send that to me in chat,
Yes, Your Honor.
You'll be excused if that's all you have.
Yes, Your Honor.
Brandon
Thank
Lee
you.
Brill.
Your Honor, that's my case, Clarissa Fernandez Pratt. The last word I got was that he was in custody. That was from his family as of yesterday.
All right. What says the state?
I'm checking our jail log right now, Your Honor. Give me one moment.
Rosa de la Garza.
Good morning, Judge. This is David Christian. I represent Ms. De La Garza. She is on the Zoom here. I see her. It says Juan's iPhone, but that is Rosie De La Garza there. She's on my second screen. Judge, if we can move it to the 323, I could send it in chat. That way I can get a chance to confer with the prosecutor on it.
Okay, and to remind the attorneys, when you do that, please send it in the cause
Yes.
number, name, date format, and just send that. We don't need extraneous chat. All right.
Your Honor, on the previous case, Brandon Brill, I've checked our jail census for this morning. I do not show Mr. Brill in custody, at least not in Atascosa.
Okay. I'll mark him no show for the time being.
Thank you.
Guadalupe Duran.
Your Honor, he's here and I'm here for him. Yeah, that's going to be a trial case. If we can keep it on for the 323 date, I'll post that in chat.
Okay, and where is here? He's with you, is he?
No, he's Mr. Guadalupe Miguel Duran.
Yes, sir.
Okay, all right,
there
thank
he
you.
is.
All right, mark you present. Send that to me in chat if that's what we're doing. Albert Martinez?
Good morning, Your Honor. This is Doug Daniel. Mr. Martinez should be present there. I believe I saw him earlier.
Present, Your Honor.
Yeah. Yeah, he's upstairs in in one of our other offices on, we'll just need to put that on the 323 docket and I will put that in chat for you.
All right, thank you. Ryan Garcia.
Your Honor, same announcement. I've already posted it in chat. He's in custody. And may I be excused?
That's all you have? Yes. On the add-ons, Tony Jean Guerra.
Yeah, but for some reason your camera's not working.
He's in jail, Your Honor.
Okay, does he have an attorney?
He does not, Judge. He needs to be interviewed by the public defender's office or probation, is what I was told.
I'll get our investigator on the line.
All right, thank you. All right, Julio Araujo III.
Morning, Your Honor. That is an old contested MTR. We're just waiting on the decision, the sentencing decision.
Oh, okay, okay. I'll get that out. All right, now. Ms. Bush, I'll mark you present on Noel Rodriguez. Is there anyone else who's appeared since their name was called on the docket or was here the whole time and their name?
Yes, Judge. Oh, good.
This is Lorraine Ephraim. My client is Abel Esquivel. He's on as M.E. Garcia 410. He's having trouble with his camera. Abel, can you unmute yourself and say, indicate you're here? Okay. He is here, Your Honor.
Yeah, yes, I'm here. Can you hear me?
Yes.
Can you hear me?
Yes.
Yes, I'm here.
Okay, and you want to turn on try your camera again, you can do that. Okay, anyone else? I see Angel Pena has arrived or appeared.
Yes, sir, for Rebecca Reyna. Lucinda Vickers is my attorney.
Oh, okay, hold on.
That we haven't called that case yet, Your Honor. That's from the civil docket.
Well, but I
Okay.
have Angel Marie Pena on the criminal docket also.
Okay.
In person? Is that the same Angel Marie Pena?
No, I don't have anybody by that name in the case on the civil docket for those people.
All right, I just hit
I'm
admit
confused.
to an Angel Pena. No, they may not have, here it is, still says connecting to audio. All right. Anybody else told to be here today on a criminal case only?
Yes, Your Honor. Patricia Davis is here. She was not able to get her sound to work, but she's on Motorola One. She's got some red hair and pigtails. Miss Davis, if you are able to unmute, go ahead and unmute for the judge. Miss Davis, can you raise your right hand and wave it?
Okay.
And again, Judge, if we can just remain on docket with that one for March 23rd.
Well, send me that in chat.
Yes, sir.
All right, then I'll release the attorneys who have no civil matters in the docket so they can confer. I'm going to make Ms. Riley the co-host, or the host rather, so that she can set up breakout rooms. Ask her to make me the co-host. The civil side.
Oh, Judge, excuse me, this is Luis Martinez.
Oh, yes, Mr. Martinez.
Judge, I'm late. I was in Bandera County first. I'm here on Kendall Hinnant. I don't see Mr. Hinnant on. I think he's having some technical issues, but I'm getting him on right now.
Okay, I'll mark you present, and yes, I have him as a no-show. All right.
Thank you, Judge.
Judge, I'm also here. I don't know if my name comes out. It comes out under Lupe Barba, but it's Horta, and I'm here on Miss Mejia.
Oh, okay. All right, Mr. Horta, Ms. Mejia did not answer.
Your Honor, probation has notified me that Miss Mejia's video and they can see her, but for some reason, I don't think she's responded to her audio.
Okay, well then I will mark you conferring.
Thank you, Judge.
Okay. Okay, Atascosa civil case. In the interest of Everett Ray Salasia, a child.
That's Zuleika, Your Honor, and that is my case with Mr. and Miss Raina and their daughter, and they're all under Rebecca Raina. And we're ready. The father has defaulted, as far as I know, unless he's here. Victorino Juarez III.
Okay, so it's just 5-10 minutes.
Yes.
I'll mark you number 1. In the interest of Elijah Lee Lopez, a child.
Respondent present, Your Honor.
Yes, Your Honor, I believe that is my case. And we're present. Mr. Finkel's on the other side.
And what do we have to hear this morning?
It's the merits.
How long do you expect for that?
It's an issue. The issue is the raising or keeping the same of child support and or whether expanded standard continues. So I don't know, 30 minutes maybe? Mr. Finkel?
That's not him.
That's probably about right, I think. Maybe 45, I don't know.
No, Your Honor.
I just have a couple witnesses.
That's what it says.
Okay.
That's him.
Roddy, could you make me the co-host so I can shut the chatter off? All right, I'll mark you 45 minutes in conferring. San Miguel versus Peeler. Motion to reconsider.
Your Honor, we have two motions set for today. One is the motion for summary judgment on all of San Miguel's causes of action.
Okay, I'm sorry, Ms. Whittle. All right, Ms. Riley? Can you make me the co-host?
Yeah, I'm trying to find your name, Judge.
I think it's the head with the most skin showing.
Got it.
Okay.
Your Honor, yes, Your Honor. We have two motions set for today. One is the motion for summary judgment on San Miguel's causes of actions filed by the Peelers. I expect that will take 2 hours. And then the other is a holdover from a previous hearing. It's the supplemental motion to exclude Gordon Johnson filed by Kiewit. And my argument is very short. I don't know how long Mr. Guthrie's is. I would suspect perhaps an hour of that.
Your Honor, Mark Guthrie, I believe that's accurate.
Okay.
Jennifer Friel for San Miguel, I agree. Those sound about right.
All right, I'll put 3.5 hours. Stephanie Jaksic versus Pedro Contreras et al.
That case has been dropped, Judge.
Maria Cornejo, next friend of Karina Espinoza versus Brian and Brooke Calhoun.
Judge Bart Brzezowski, I was appointed as the guardian ad litem for the minor. It's just a friendly suit, minor settlement prove up. We're doing by affidavit. I have e-filed the affidavit, my report, and the judgment that's been signed off by everyone.
All right, I'll mark you number 2. Amber Salas Martinez versus Maria Carrillo et al.
Hi, Judge. That's Anna Holdren and Robert Doggett for the plaintiffs. It's a TI hearing. 2 defendants, I believe, are on, and we would need about 30 to 45 minutes.
Okay, and who else is here on that case?
Good morning, Your Honor. Andy Moon, representing Roxborough Realty.
This is Patrick Yost. I anticipate filing an appearance on behalf of Roxborough. I haven't made an appearance yet, but I'm here also on that case.
Okay, and is anyone here for the individuals? Carrillo
Yes,
and
this is Daniel Botello. I am present, and Maria Carrillo is present too. She is sitting right across from me. She was unable to figure out the Zoom.
Okay, I will mark you conferring for the time being. Ask Ms. Riley to. Do you think it'd be better to have everyone in the breakout room, to have the attorneys confer initially?
Judge, we're happy to do that if the court would like. I haven't talked to Patrick, and it's been a couple of 3 years now on another case, so it's nice to see him.
Okay. All right. So I asked you to get with Ms. Here we go with Ms. Riley about that. Anyone else told to be here today at all that your case was not called?
Your Honor. Judge, my name is Magdalena Aguirre.
Okay.
I was unable to unmute my phone a little bit ago. I am sorry.
Okay, I'll mark you present. Thank you.
Thank you so much.
Judge TRLA has our investigator ready to interview the inmate.
There.
Hello?
All right.
Hello?
Yes.
I'm Angel Peña. I'm sorry, I didn't know how to work this, and then my phone is not, it keeps freezing. I'm present. I have a Richard Briggs is my court-appointed attorney.
Yes, ma'am.
That's correct.
I'm going to mute you, and I've marked you present.
Your Honor, I have a case on the docket. I believe it's a motion to modify.
Okay, who is I?
Sorry, Davis Morrow.
Okay, because it was a 210 area code number was put up a moment ago. All right, what's the client's name, Mr. Morrow?
My client is Heather Rodriguez.
Did I call that case?
No, I didn't hear it.
Yeah, I don't have a Heather on here. Okay.
It's a default
county or
modification.
Atascosa? Is it in Wilson or Atascosa?
Atascosa, Your Honor.
Okay, I will ask you to get with the district clerk or the DA's office, or Ms. Riley, in chat, in breakout rooms, and see if you can hunt that down, because they're not on my docket today. All
Okay,
right,
thank you.
anybody else?
Your Honor, this is Lorraine from May I Approach.
Yes.
On Abel Esquivel, I think he's still having trouble with his video, although he is connected by audio. Mr. Thornton and I have been conferring. We had a motion for to suppress that for today. We agree we're not ready on that and are asking to reset it. However, there is a discovery issue we would ask the court to take up at the court's convenience.
Okay, how long to hear that?
I was thinking 15 minutes or less. I haven't talked to Mr. Thornton about a time announcement.
I think that's probably right, but I would ask for a breakout room with Ms. Efron. Maybe we can work a few things out ahead of time.
Okay, yes, if you'll get with Ms. Riley about that, I'll mark you 15 minutes. Anyone else have anything before we start?
Judge, could I approach? Judge, this is Luis Martinez. Could I approach?
Yes, sir.
Judge, I'm back on Mr. Hennet's case.
Okay.
He knew to be here, Judge. We got a call from his mom about 10 minutes ago that he's having a diabetic episode. Could we keep him on the docket and give me a chance to get you some medical or some documentation to support that?
Sure.
Okay.
Okay.
Do I need to put that in the chat, Judge?
Yes, he's going to be going to 323 and just that medical information is to follow.
Yes.
And if you would send me your cell phone, I need to chat with you about something when we're not in court. It's not to do with court here at all.
Okay.
Just in chat, just send me your cell phone.
Thank you. I'd be happy to do that. Thank you.
Okay. Okay, I'll let everybody who needs to confer, and we'll start on the civil cases.
Judge, I'm sorry, I have one more.
Okay.
On the criminal docket, Magdalena Aguirre, she says she's phoned in, she got kicked out and she's back on. I'm not sure which phone number or Galaxy is hers. If we can just call her right quick to see. Miss Aguirre, if you can hear us, please unmute.
Hi, this is Magdalena Aguirre. I had just called in to the judge.
Okay.
All right, thank you, ma'am. I'll mark your name.
Thank you,
Thank
Your
you,
Honor.
sir.
Hello, this is Sean Grego. I just got my phone set up. Judge,
Yes, what sort of case do you have, sir?
I believe Robert Gears, my lawyer.
Your Honor, page 2.
It's an aggravated sexual assault of a child.
Okay, I see him. And have you heard from Mr. Gear?
I finally heard from him last night, and he told me that he was going to send me this Zoom thing, and I didn't get it, so I called the courthouse and they gave it to me, so I'm here.
Okay, well, I'll mark you present. Waiting on Mr. Gear.
Thank you, sir.
Judge, this is Doug Daniel. Is it your intention to hear the civil cases before you do the criminal cases? We have a plea on an MTR. I didn't know if you were going to.
I don't have any paperwork on a plea.
Oh,
so yes, I'm going to start the civil stuff. I'm not going to do the 3.5-hour peeler case first, but I don't have any paperwork on a plea. And whoever sends it to me, I'm going to ask you to make certain that it's complete with MTR. It's not as important, but with the regular pleas, if we have any of those, let's make sure that the state's exhibits and a copy of the indictment are all included so that we don't have to stop in the middle of it and get that resubmitted.
I'm doing that right now, Judge.
All right.
Judge of the Public Defender's Office can interview Tony Guerra.
Okay. Ms. Riley is in charge of breakout rooms right now, so if you need a breakout room to do that, please text her or message her in chat or
Thank you.
Whatever. All right.
Judge, can I interrupt just one moment? Karnes County District Clerk's Office is called and they want to know if you've had time to review the indictment list. Is that right, Norma?
I have, and I've sent them twice.
You sent them twice. Okay, I'll let them know.
Last week and once this morning.
Thank you, Judge.
Your Honor, just for your information, Mr. Gear is in district court in Wilson with Judge Ellison. I don't know if he gave you that information, but that's where he is.
I'm calling your case at this time.
All right.
Everett Ray Zulaika?
Yes.
All right. Do you need to have people sworn in?
Yes, Your Honor. I have 3 people. I have Mr. and Miss Reyna and Miss Zulaika, and I think they were all on the same Zoom window.
I believe so. All right. You raise your right hands. All right. And do each of you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God? Are they muted?
Yes, sir.
Yes, sir.
Okay. All right. Would you state your names, please?
Rebecca Reyna.
Doroteo Reyna.
Allison Zulaika.
All right. Go ahead, Ms. Vickers.
All right. I'm going to call Rebecca Reyna. Miss Reyna, would you state your full name, please?
Rebecca Vasquez Reyna.
And Miss Reyna, are you currently the temporary joint managing conservator along with your husband for Everett Ray Zulaika?
Yes, ma'am.
And how are you related to Everett?
He's my biological grandson.
And is your daughter his mother?
Yes, ma'am.
Okay. How long has Everett lived with you?
Going on 3 years.
And how old is
He's 8. He's 8.
All right. Now, we had a temporary order in this case. Do you remember that?
Yes, ma'am.
About how long ago was that entered?
About 3.5 years ago, 3 years.
All right. So it's been entered for some time. Is that correct?
Yes, ma'am.
And in that, you and your husband were appointed temporary joint managing conservators, and your daughter and Mr. Juarez were appointed as possessory conservators. Is that right?
Yes, ma'am.
All right. Now, your daughter is with you right there in the room. Is that correct?
Yes, ma'am.
And you and your husband and she have signed an order, which basically turns the temporary order into a final order. Is that right?
Yes, ma'am.
All right. Now, under the temporary order, have things been going well?
Yes, ma'am, they have.
All right. And is Everett doing well, and is he doing fine in school?
Yes, ma'am. He's adjusted and doing very well in school this year.
All right. Okay. So let me ask you about Mr. Juarez. Have you had any contact with Mr. Juarez since the temporary orders hearing?
No, ma'am.
Do you recall that he physically appeared sometime after court started on the day we had the temporary orders hearing?
Yes, ma'am.
And he appeared in court and signed the temporary order at that time. Do you recall that?
Yes, ma'am.
And have you seen him since?
No, ma'am.
Do you have any idea where he might be?
No, ma'am.
Has he made any attempt to contact you or Everett?
No attempt to contact me or Everett, and not even he hasn't even paid his child support, so we have no contact whatsoever.
All right. And he had a child support order prior to the temporary order, and then we also ordered him to continue that in the temporary order. Is that right?
Yes, ma'am.
And has he done that?
No, ma'am. He did maybe 3 payments and then haven't seen anything since.
All right. So is it your testimony that he's way behind in his child support obligation?
Yes, ma'am.
All right. And then Ms. Zulaika has used her visitation in her possession under the temporary order. Is that correct?
Yes, ma'am, she has.
All right. And do you believe that continuing the parents, the biological parents, as possessory conservators and having you and your husband as joint managing conservators and continuing the limited and supervised possession order that we had in the temporary orders for the parents, do you believe that that's in the child's best interest and you're asking the court to grant that?
Yes, ma'am. I believe it is in his best interest.
Okay. And you believe that particularly for Mr. Juarez, who has had no contact with this child for some time, you believe that the supervision is necessary?
Yes, ma'am, because he's
had no prior contact with Everett from day one.
All right, so Everett wouldn't recognize him if he walked up to him?
No, ma'am, he would not.
All right. I have no further questions of Ms. Reyna.
All right. I don't have any questions for it this time. Go ahead.
Okay. I'd like to call Mr. Reyna.
Yes, ma'am.
Mr. Reyna, would you state your full name, please?
Doroteo Reyna III.
And are you, you were here and heard Miss Reyna's testimony. Are you in agreement with what she's testified to?
Yes, ma'am.
Do you believe it's in this child's best interest for the temporary order to be turned into a permanent order along the lines that she testified to?
Yes, ma'am.
Okay. And so we're basically continuing the child support Mr. Reyna was paying in a prior court proceeding, and that was ordered in the temporary order. And we are asking that the visitation be supervised as set out in the temporary order. You believe that's in the child's best interest?
Yes, ma'am.
All right. Are you and Miss Reyna providing health insurance and dental insurance for the child?
Yes.
All right. And you're going to continue doing that?
Yes, ma'am.
All right. I have no further questions of Mr. Reyna.
All right. I have no questions for him. Anything?
All right. Miss Zuleika, are you there?
Yes.
All right. Would you state your full name, please?
Allison Marie Zuleika.
And have you heard the testimony of your parents?
Yes.
And are you in agreement with the order as they have testified to?
Yes, ma'am.
And you actually have already signed the proposed order that we have e-filed, is that right?
Yes, ma'am.
Do you have any contact with Mr. Juarez?
No, not anymore. He used to message me, but not anymore. He just like disappeared.
Okay. About how long ago was the last time you had any contact with him?
Last time I had contact with them was about 4 months ago.
All right. Did he give you any location information?
No, he did not. I do know that he does have 2 more child support cases as well for his other children.
All right.
That's the only thing I know.
All right. That's all the questions I have, Your Honor. Unless you have anything, I tried to send Mr. Juarez certified mail notice because he physically appeared at the temporary orders hearing. The only address we had was he at the time was working in the janitorial department at East Central ISD in San Antonio. And the certified letter came back. They then called us and told us he no longer worked there. But he gave no address when he appeared in court, except that he was working here. And I have no other place to notify him of today's proceedings. He has not updated the court or given an address to the court.
Okay, I will take judicial notice of the contents of the file, including the signature from the biological father who did appear at the temporary orders hearing and agreed to the entry of them. And I'll find that he's made a post-answer default and that it's in the best interest of the child to convert the temporary orders into permanent orders. And I will sign that whenever it gets to me.
All right, I think we e-filed it on Friday, Your Honor, so it should be available for you to sign.
Well, it's not in my queue at this moment, so I'll look at it when I get.
Okay, we'll check on it.
I just hit refresh and it's not there.
All right.
Okay.
That's all we have, Your Honor, for that.
All right, then you're excused in this case.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
All right. Cornejo versus Calhoun. Do you need to actually have any sort of a hearing on that, or you just want me to look at the affidavits whenever they come in?
Yes, Your Honor. I've done a report for the court, so the affidavit's been e-filed, my report was e-filed, and the judgment signed by everyone has been e-filed. So
all right. Well, like
limits
I said,
were paid. Sorry?
I just hit, again, refresh, and it's not in my judge's queue, but I'll look at it when it gets there.
Okay, I don't need to email it anywhere, just e-filing is sufficient?
Well, that will get to me eventually. If you have all of those documents and you want to send them to me in chat, you're welcome to do that.
Okay, I'll see if my paralegal can do that.
Okay.
Judge, I'm going to attempt to do that.
All right.
My paralegal's emailing them to me, and then we're going to see if we can accomplish that. Okay?
All right.
Thank you, Judge.
State versus Angel Espitia Tovar.
Yes, Judge, sorry about that. Do you have the paperwork yet?
Yes.
All right.
And where's
He's present here in my office, Judge.
Okay, and this is an open plea?
It is, Judge.
And
And we're going to reset it for sentencing, Judge. We're going to be looking, I think, to set it for the date. I was looking at the calendar here in February. I try to set it on the 7th. I think that's the date.
adult probation to see if that's enough time for them to.
No, I didn't, Judge. If we need to push it out a little bit further.
That's not one of the reset dates either.
Oh, okay.
Sorry.
Would it be able to do it for the 17th?
Yeah, we can do the 17th.
Okay, and who's going to represent the state?
Should be Kenny Lamb, Judge.
Kenny Lamb is in a breakout room if you need me to go get him.
All right, Ms. Biggs.
I'm sorry. I'll get with Kenny. I don't have access to that.
It's just an open plea on a first degree.
I'll go get him from the room, Judge.
Mhm.
Can you see on there? Okay, have you got it? Are you
Your Honor.
Yes, sir.
On that.
It's true. It's true.
All right, Mr. Daniel.
Yes, Your Honor.
Yes, Your Honor.
All right, it sounds like you've got two different computers within hearing distance.
We do, Judge. How about if we just cut the one off that he's on and he can use mine?
That's fine. You've got to have just one down, just one within hearing distance. All right, calling State versus Angel Especia Tovar. Are both sides ready?
State's ready.
We're ready, Your Honor. Just have a seat.
Okay. Are you Angel Especia Tovar?
Yes, sir.
And are you the same individual who on or about July the 5th, 2019 was placed on deferred adjudication probation for the first-degree felony offense of manufacture or delivery of a controlled substance?
Yes, sir.
And you understand that on that day, the judge found there was enough evidence to say you were guilty, but the judge did not do so. Instead, the judge deferred or put off a finding of guilt and placed you on deferred adjudication probation.
Yes, sir.
And if you successfully complete that deferred adjudication probation, the case against you will be dismissed and you'll have no conviction. But the state has alleged that you've broken the rules of your deferred adjudication. And if they can show that is true, then you could be found guilty. You could be, and then sentenced to anything legal sentence for a first-degree felony. That means not less than 5 and not more than 99 years or life in prison, and a fine up to $10,000.
Yes, sir.
Okay, I couldn't hear you.
Yes, sir.
Okay. Now, specifically, the state is alleging that you have violated rule number 17 of your deferred adjudication probation in that they claim that you failed to complete community service restitution hours in the months of July through December of 2019 and January through March of 2020. So do you understand what it is the state is alleging that you did incorrectly or did wrong?
Yes.
And are you able to speak, read, and write the English language?
Yes, sir.
All right, I want to show you some documents that appear to have your signature. All right, they're titled Written Waiver and Consent to Stipulation of Testimony, Motion to Revoke or Adjudicate. Let me go down to page 3 and ask, is this your signature in the middle of page 3?
Yes, sir.
All right. And do you swear or affirm that everything that appears above your signature in the middle of page 3 is true and correct?
Yes, sir.
All right. And did you also sign where it says plea bargain agreement?
Yes, sir.
On page 2 of the written waiver of time to file motion for new trial?
Was there a question, Judge? Are you asking him if that's
Yes,
his?
did you also sign on page 2 of the written waiver of time to file motion for new trial?
Yes, sir.
Okay. And on the trial court's certification of the defendant's right to appeal?
Yes, sir.
All right, sir. Did you read these documents yourself or did your attorney, Mr. Daniel, read them to you?
Yes, sir.
All right. Did you understand these documents before you signed them?
Yes, sir.
And are you satisfied with the work that Mr. Daniel has done for you?
Yes, sir.
Okay. And let me ask the attorneys, I believe this is to be an open plea, you said?
Yes, Your Honor.
Yes, Your Honor.
Okay. And you understand, sir, that an open plea means that you will plead true to the alleged violation of your community service requirements. And you don't have any agreement with the state as to what the disposition of this case will be. And that means that I would have the right to do anything the law allows in a situation like that. And the law would allow me to do anything from saying, don't do it again, leaving you on deferred adjudication. It would allow me to end your deferred adjudication, but convert it to a regular probation where you would have a sentence of not more than 10 years in prison and not a fine of not more than $10,000. And then you would have to be placed on probation and you would not actually go to prison if you successfully completed that probation. And subject also to, if the estate alleges you broke the rules of that probation, being brought back to court as you've been brought back to court on your deferred adjudication. Or I could find you guilty and send you to the penitentiary for any period of time of not less than 5 years and not more than 99 years or life. And I could match that with a fine of up to $10,000. So it's anything in that list. Do you understand that?
Yes, sir.
And that's what you're wanting to do.
Yes, sir.
All right. Mr. Daniel, do you believe that your client understands the nature of the rights he's giving up, the stipulations of evidence he's making, and the consequences of his plea bargain?
I do, Your Honor.
All right, sir. I will find that you've made your waivers of right and your stipulations of evidence knowingly, intelligently, and voluntarily, and I will approve them. And I'll ask you, to the allegation that you violated rule number 17 of your deferred adjudication probation by failing to perform community service hours, is that true or not true?
True.
All right. I'll accept your plea of true and ask what evidence the state has.
State tender states Exhibit 1, it's attachment A.
We have no objection, Your Honor.
All right. Without objection, State's Exhibit 1 is attachment A are admitted into evidence. Do both sides rest and close at this stage?
State rest and close.
We do, Your Honor.
All right. I will find there is enough evidence to substantiate the fact that there's been a violation of the deferred adjudication probation, and I also find that a change needs to be made in the disposition on this case. And it's my understanding that there's going to be a long-form pre-sentence investigation.
Yes, sir.
And that we're going to be back here on the 17th of February.
That is correct, Your Honor.
All right. All right, sir. You understand that the probation office is going to interview you and make up a report about you, your background, and what you've been doing while you were on deferred adjudication, and the circumstances of the offense that you've been found guilty of?
Yes, sir.
All right. You understand, sir, that you can't go back and change anything that you've done or failed to do. The past is past, but you can't influence my understanding of how you are likely to behave in the future. About half the time, whenever I do this and we set somebody for a long pre-sentence investigation, it seems that that person does not cooperate with the probation officer. They don't show up at all. They show up and leave. They basically just do nothing to help their attorney make a case for themselves. I'm going to suggest you don't want to put Mr. Daniel in the position of coming back here in about 3 weeks and you didn't cooperate with the probation officer and he has no argument to make to me as to why you would be a good candidate for either probation or for a minimal sentence. So I will, if I didn't say that on the record already, I'll find you guilty of the underlying offense of a first-degree felony of possession of a controlled substance with intent to distribute or manufacture. And I will reset this case for sentencing on the 17th of February. And on that date, you need to be not in Mr. Daniel's office, you understand, sir, but at the probation office or the court building in Atascosa County in Jerdenton?
Yes, sir.
All right, I'll see you then.
Very well, Your Honor. May we be excused then?
Yes. All right, and Ms. Hunsinger, I saw that you appeared.
Yes, Your Honor. I apologize. Mr. Hancock and I were with our client. We were sent a Zoom link for Judge Ellison's court.
Oh, you were over in. All right.
Yes, sir. And Ms. Biggs helped me to get that resolved. And we're requesting the 3/24 reset date.
I believe it's 3/23.
3/23? Okay.
Oh, all right. All right then.
And our client is present, Your Honor, Ms. Goodwill.
I see she's present. Okay, I will ask you to send that to me in chat. You send me cause number, name, and date. No extraneous information. And after that, you are excused.
Thank you, Your Honor. Appreciate it. Sorry for the mix-up.
That's fine.
Thank you.
All right, and on our motion the evidentiary motion, is that still needing a hearing? I don't see.
Are you talking? This is Lorraine Efron on Abel Esquivel. Is that
Yes.
what you're? We just need about 5 minutes, Judge.
Okay, and who's going to represent the state on that?
That's me, Your Honor.
Okay. All right, and all right, State versus Abel Esquivel. Where's Mr. Esquivel?
Yes, sir.
All right, and is there a written motion I need to look at?
There is, let me see if I can figure out how to screen share that. There,
The easiest way, if you have it in a PDF, is just to post it to me in chat.
Oh, all right.
And I'm going to see if I can pull it up online.
It's a motion for discovery filed December 18th. Let me see.
All right, it's a motion for discovery filed when?
December 18th. And I think I have sent it in chat, Your Honor, directly to you.
Oh, okay.
And we do have some agreements on that, and then a matter, or two for you to decide for us.
All right, let me. Okay. All right, I've got it up on my screen.
Okay. So if I may, Your Honor, we're asking for the personnel and disciplinary records of Sergeant Investigator Jesse Martinez. And we received a Brady notice on him. Mr. Thornton and I have discussed that, and I think I'm stating this correctly. He's agreed to produce them to the court for an in-camera inspection to make a determination as to what is releasable to the defense.
Okay.
And
Yes, Your Honor. There's also a second officer she's requesting, Chief Deputy of the Animal Control, Henry Dominguez, which is something that the court may be familiar with the Brian Matu trial we had about a year and a half ago.
Yes.
And so those records also will need to be reviewed. And I believe the court has done that one time and may be familiar with them.
Okay, so what do we need a hearing on?
okay, so on Deputy or Investigator Martinez's Brady notice, there was an deputy involved in the incident that led to some disciplinary action or separation from the department. I wanted the personnel records of that deputy, and I think Mr. Thornton has some information on that. So in the Brady notice, he wasn't identified by name, so I'm asking for his name and his personnel records. That's one. And then the other is I've asked for an in-camera inspection of all the personnel records of all the officers involved, and I have them listed in my motion.
All right. Exactly would you be looking for?
Okay, so Jesse Martinez is the primary investigator on this case, and he's an affiant on 3 search warrants. 3 separate search warrants. He's the affiant to, and so that's one reason why we have a motion to suppress that we've agreed to reset. And so I need this information in order to prepare for the motion to suppress and to secure his presence there, and also to make sure I have all the information and all the players involved in the incident for which he was disciplined. And I'm not sure if it was the cause of his separation. It was an incident on February 2nd, 2020. So I'm not entirely clear on the Brady notice if the incident that's subject of the Brady notice was the cause for the separation, or if there was some other incident after that that was the cause for the separation. So, and especially since it's a murder case and he's the affiant on 3 separate affidavits for 3 separate search warrants, I believe it's, obvious, exculpatory, and we're asking for all of it and for all of the individuals involved in the incidents that were subject to the Brady notice.
Okay, and you understand I haven't seen the Brady notice, so I have no idea what you're referring to.
Do you have that available, Mr. Thornton?
I do, Judge, it's on another computer, so I can't post it in chat, but I can email it to you if you'd like.
All right, let me, and when was the Brady notice given, or was that filed with the district clerk?
I believe I did file it, but I'm not 100% sure. I usually do.
It was, it looks like it was served in August, at the beginning of August. And then I will tell the court that, Mr. Thornton and I have been working on discovery. We have met in Atascosa County to review evidence. We have a second meeting scheduled for February 5th to review evidence. But when I met with
the cast video, excuse me, on the video with all.
All right, go ahead, ma'am.
Okay. So the Brady notice wasn't clear as to what the disciplinary action was on investigator Martinez, but when Mr. Thornton and I met, it was made clear to me that he's now separated from the department. So anyway, we have been working hard to get on discovery. I will say that. Just a lot here, I guess.
Your Honor, I just sent you the Brady notice, but what I'll say is we have no problem the personnel file of Jesse Martinez to the court to review in camera to determine what is appropriate for release. The deputy who was also involved in the disciplinary incident that led to Jesse Martinez's issue is not involved in this case at all. And so we would object to any really that deputy's disciplinary file, because I don't believe it's connected to this case or relevant to any issue that Jesse Martinez had that might come up. The second is in terms of all the other officers, she's asking for the personnel file of every officer that's involved in the case at all. And I don't believe that is appropriate unless there's some particular showing that there may be something that is material to the case. And so, Your Honor, I don't believe there has been any such showing. And I don't believe Michael Morton Act necessarily provides for that release unless it is material. And so we would object to the personnel files of every officer because then we would just have a precedent of going on a fishing expedition and every officer's personnel file in every case, and that would be overburdensome and unnecessary. And so we would object to that. But we have no problem with releasing the personnel file to the court for an in-camera review on both Jesse Martinez and the chief, Henry Dominguez.
In Your Honor, if I may respond,
Yes.
the reason why I think it's necessary at the very least for these items to be turned over to the court for in camera is that if the court sees the Brady notice, it's an incident where Sergeant Martinez sort of enlisted an assistance of a deputy to engage in improper behavior. And he was the lead investigator in this case. And he, again, was the affiant on 3 separate affidavits for search warrants. And if he had a history or this wasn't the first time he enlisted a colleague or to assist him in some sort of improper behavior, that's something that would be exculpatory, and we would be asking the court to review.
Okay, and how would looking through the Texas Rangers personnel file lead to that sort of evidence?
I guess my argument pertains to the individuals employed by the Atascosa County Sheriff's Department who were the working directly with Jesse Martinez on this case.
Okay. I'll take all the additional motions under advisement until I've had a chance to look at whatever's turned over to me in camera and see what needs to be produced to the defense. And I would not expect it would be granted at this time, but I'll wait and see what's in the reports.
Okay.
See what's in the personnel files and disciplinary history that I look at. And I'm not sure I was altogether clear. So has Investigator Martinez been discharged from the Sheriff's Department?
Yeah, well, he has resigned. Yes, Your Honor.
Okay, he's departed in any event.
Yes.
So one concern I have, since my motion to suppress is based on a warrant situation, is that it's my burden to get the officers there. And I definitely need information as to where Jesse Martinez's whereabouts are, where he can be served with the subpoena. And Mr. Thornton and I may be able to work that out, but that's definitely, also an issue.
Okay, I mean, does he still have his peace officer's license?
Not 100% sure on that. I know he's not currently working as a peace officer.
I was gonna say, if his license is being carried anywhere, I'm not sure how long you have to go without, then you can get that from the state.
But I think we certainly should be able to work out that scenario.
Yes.
Without a problem until it becomes a problem.
Okay.
All right, then. I will wait for that stuff to appear to me.
So, Your Honor, I would just ask. I'm going to ask Ms. Efron to prepare a motion based on our agreement or an order that the court can sign, so I can provide that to the sheriff's office, and then once that order is signed, I'll get that to the court as soon as possible.
Sounds good.
All
Okay.
right, thank you.
What do you think a reasonable time is, Mr. Thornton, to get that to the court?
Probably within a week of the order.
Okay, 7 to 10 days, something. Okay.
Yes.
Okay.
All right, thank you.
Okay, thank you. And then otherwise, we're asking for the March 23rd reset.
Okay, and what you need to do on that is just send me a message in chat with cause number, name, date.
Okay.
Nothing else.
Okay, the motion to suppress, I don't know if the court will want to set that separately or specially. We would be asking for an in-person hearing on that, but maybe we should just handle these discovery matters now, and I can.
Okay, so you know that you can do it before we set it. Sounds good.
Okay, thank you, Judge.
Yes, ma'am.
May we be excused?
Yes.
Okay.
Your Honor?
Yes.
Davis Moore here. I'm sorry to interrupt. I had a case that I was told was on the docket, but it wasn't called, and you were gonna send me to a breakout room. I just didn't get an invite for that.
All right, please contact Ms. Riley about that.
Okay. Okay, I'll call her.
I
Thank you.
mean, she's on the screen also.
Okay, thank you.
Okay, I'm going to post this to Tovar case to Chris.
Okay, Judge.
Actually, let me do that again. I'm not sure I'd sent you the saved version. All right, where do we stand on Amelia Martinez versus Carrillo, Botello, and Roxborough property? All right. Anybody hear me?
Yes, we can hear.
All right, because everybody stopped moving and I couldn't. Mine was jammed up or everybody else's was. Okay. Martinez versus Carrillo, Botello, and Roxborough Realty. Are they conferring or we have an announcement on time? Anyone?
Judge, I didn't hear you. I'm sorry.
I'm not sure where the issue is. I talk and then everybody's email picture will freeze. On that Martinez versus Carrillo, Botello, and Roxborough, are they still conferring? Andy Moon was one of the attorneys.
Amelia Martinez, you never joined breakout room 4 that you were invited to. I'm not sure if I was muted, Judge, but they're in breakout room 4.
Okay, that's fine. And are you still the host?
I think, let me double check.
You have access to breakout rooms?
Yes, I'm in there. I mean, I can look at them.
Okay, because I can too.
Your voice went out again.
So now we can both have access to breakout rooms. It wasn't that way last week.
I don't know. They've done some changes with Zoom lately, so.
Right.
And just FYI, Judge, on that indictment with Karnes County, they said it wasn't signed. And there was a case with Mr. Morrow. That case should have been set on the docket, but it was a county court at law judge, or county court at law case that didn't post on our docket, and I apologize for that, but it should be on the docket today. But it's titled CCL case, so that's why it didn't post on the docket. I didn't catch that. But it's supposed to be on the docket today.
Okay. All right, Mr. Morrow, what needs to happen in your case?
Your Honor, this is a default modification. So I just need probably 10 minutes with the record. Opposing party is Stephen Drotti. I assume he's not here today.
And is this a district court case or a county court at law case?
District court case.
All right.
It's actually a county court at law case, actually, but I don't think Judge Brendel can hear it because it's a former, I think, AG case. Is that correct, Mr. Morrow?
Yes, that's correct.
All right, give me just a moment.
Come in.
Okay, what is the cause number?
It's 0803-0215 CVA.
0803-0215.
Yes, Your Honor.
All right, let me see if I can find that in the district clerk's records.
Thank you.
And I believe there's a final order to modify judge in the queue.
Okay. LGS is running very slowly this morning, so give me a minute. Okay, so there was a motion to modify filed in 2019,
Yes, Your Honor.
and Stephen Drotti is the respondent.
Yes, Your Honor.
You look at the return. All right, I'll take judicial notice that the return of citations in the proper format. Been on file for more than 10 days. All right, go ahead, sir.
I'd like to call Heather Rodriguez.
All right, ma'am. Would you raise your right hand? Do you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. Go ahead, sir.
Thank you. Will you state your name for the record, please?
Heather Rodriguez?
And are you the petitioner in this case?
Yes.
And what are you asking the court to modify?
I just need to be able to get the children passports without permission from Stephen.
Okay, and why are you requesting this modification?
My husband has a government job that could take us overseas.
Okay, and have you, is the respondent Steve Andrade?
Yes,
And have you asked him to sign off on or otherwise help obtain passports?
I did, yes.
Okay, and what was his response?
He refused.
Okay, and when was the last time you asked him?
Oh gosh, it must have been 2017 or 2018. My grandpa wanted to take my son on a trip to Germany and he refused
Okay,
to help get him a passport.
okay, and when was the last time Steve Andrade had any contact with your children?
November of 2016.
Okay, and what's his current involvement with the children?
He doesn't have any involvement.
Okay. And are you asking the court to modify child support?
No,
Okay, and you're not asking the court to modify the visitation schedule?
no,
Okay, you're just asking for the exclusive right to apply for and maintain passports for the children.
yes,
And do you think that that request is in the best interest of the children?
yes.
Okay, thank you. Judge, that's all I have.
All right, I'll take judicial notice of the entire contents of the file, including the return, the military service affidavit, and the certificate of last known address, and I'll find that it's been shown that it's in the best interest of the children to remove the prohibition against the issuance of a passport unless both parents agree, and I'll allow Heather Rodriguez to have the exclusive right to apply for a passport and or authorize overseas travel for the children.
Thank
Do you
you.
have a proposed order, sir? Or you said it was in the chat, or even in the judge's queue?
We filed it. It's been signed by us and by Ms. Rodriguez, and e-filed it.
Okay. I have nothing in my e-file queue since.
It's in the coordinator queue, Judge.
Okay. All right. Mr., do you have a copy of the signed order on your computer? If you can just post it to me in chat as a PDF.
Okay, yes, Your Honor. Give me one moment, please. Okay, I believe I've posted it.
Yes, I see. And you're representing to me that the only thing that you're changing is the passport language?
Yes, Your Honor.
Okay, I just posted that to Ms. Benavides, and also I sent a copy to you, Mr. Morrow.
Thank you very much. That we be excused?
Yes.
Thank you.
Thank you, Judge.
All right, I think next would be the Elijah Lee Lopez case. Have the parties had a chance to confer on that?
Judge, I'm present and ready, subject to my one witness being able to log on, a second witness.
All right, who's that witness?
Her name is Letty Carrasco.
Okay. Do you want to go ahead and get her on?
She was attempting to get on earlier. Let me see.
Mr. Thornton, can you join breakout room number 6 with Mr. Orta, please?
I'm here. Can y'all hear me?
Mr. I'll get Mr. Thornton.
All right, ma'am, what is your name?
Leticia Carrasco. Can you hear me?
Yes, ma'am, I'm sorry.
Okay, I'm sorry. I'm just new at this, so I didn't know if you could hear me or not.
Yes, I could. I was just changing your name.
It's okay. Thank you.
All right. Ms. Vickers, do you have witnesses?
Yes, Your Honor. I have my client, Eric Alaquines.
All right, so let me write all this down. And who is the mover?
Your Honor, I believe we are the original petitioner in this case.
And Judge, my other witness is my client, Ms. Christy Salinas.
Okay, Christy Salinas?
Yes.
Is she on?
Yes, I'm here.
Okay. All right, and someone has two electronic devices going where they can interfere with each other. All right, Ms. Salinas, I'm asking you to start your video. Okay. All right, and Ms. Carrasco?
Yes, sir.
And are you able to start your video?
No, I'm just over the speaker. That's it.
Okay, yeah, it does not show there's a video there. Okay, so let me ask both the parties, Mr. Alaquines, Ms. Salinas, and also the witness, Ms. Carrasco, would you all raise your right hands?
Yes, sir.
Okay, and Ms. Salinas, unmute. Do each of you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes. Yes, sir. I swear.
All right, Ms. Salinas?
Yes.
All right, Mr. Alaquines?
Yes.
All right, Mr. Alaquines?
Yes, Your Honor. Yes, sir.
Okay. All right. Go ahead, Ms. Vickers.
All right, Your Honor. As a brief opening statement / summary, we had a contested temporary orders hearing in this matter before you on June 28th, I think 2020, and then we continued it on July 27th of 2020. And the big issue at that time was whether my client was going to have expanded standard or regular standard or something less. You gave him, in that order, you gave him, there was a summer possession issue. We had an exchange being at the Pleasanton Police Department, and he got expanded standard at that time, and you reserved whether or not he was going to continue to have expanded for the final hearing. You also asked for the parties to keep a log of who had the child which night, overnight. You asked for a log for each parent to keep when they had the child overnight. I have that available. Now the issue has been, and I think it came up, although there was no ruling at the time, that because Ms. Salinas's concern was whether or not my client was physically present for the entire visitation period, his testimony will show that he actually ended up switching his entire job situation. He works for the same employer, but he has a whole different schedule and therefore makes less money. So he is asking you to now consider lowering his child support, because in order to address the concerns, he changed his job schedule to be absolutely sure there were no issues, and now he makes less money. And so we're asking that his child support be lowered and that he continue to have his expanded standard schedule. So those are the issues before the court this morning. And I have his paycheck stubs through, I think the latest one I may have is November, the end of October. He changed his job in, I think, August, I want to say August the 11th, and the first paycheck I have is August 13th, showing his lower amount of pay. So I have that and his logs available when we get to the evidentiary part of the hearing.
Mr. Finkel?
Your Honor, that is accurate as far as the history is concerned. The only issue that I have with Ms. Baker's opening statement is I don't believe there's been, unless I'm missing it, a request in her pleadings for a modification of child support.
Well, Your Honor, Mr. Finkel's pleadings engage the issue of child support because that's what he asked for in his petition. So once child support in family law pleadings, once that's pled, you don't have to file a counter petition to plead for child support. It's the issue is engaged and confronted. And so that's what we're asking for. Certainly if the court feels like we need a pleading, then I guess we could reset this case and I could plead to lower the child support. But in my opinion, that issue is before this court.
Mr. Finkel?
But I mean, I still think it needs to be pled for because, you know, my client, if she pled for it, she could drop that issue if she wanted to and not press that issue. But if it's not pled for, I don't think that, you know, she should be able to ask for it if she doesn't plead for it.
Okay. All right. So I don't want it to cause a bunch of unnecessary legal work and filing like a whole new petition or motions to reconsider and then add new pleadings in there. And I don't want to force Mr. Finkel to show up and litigate an issue that he didn't believe was before the court. So I'm going to ask the two of you to confer just briefly in a breakout room and see if you can agree that we're going to go ahead today, or agree to a very brief window, not 42 days or anything out, to give Ms. Vickers a chance to file whatever amended petition or counter petition she needs to file to make sure that Mr. Finkel has an opportunity to be able to respond to the evidence.
Well, Your Honor, I just want to point out before we do that we did order child support in the temporary order. So we did a child support order in the temporary order. So that issue's already been tried, and simply asking to modify it is not, but I'm just going to point that out, Your Honor. We tried that issue at temporary orders based on Mr. Finkel's pleading. And I have
was there a change made in the
my understanding was yes. I can go back and verify that, but we did have a court order ordering child support. I can go back and look at
And are you asking to have child support changed to, or based on the new job, to be less than it was before the temporary orders modification?
It would be,
Hello?
let's see.
And I don't believe the temporary orders had a modification of the child support. I think it just reiterated what the child support was.
Did it? I didn't go back and look.
Okay, well, I'm going to put the two of you in a breakout room for right now and ask you to.
Oh, actually, my client was not ordered. I believe my client was not ordered to pay child support at the time of the temporary order prior to that in the child support order, because the parties at that time were living together. So when the Attorney General ordered it, there is no child support. So yes, the temporary order contained a child support order, which was a lot different than zero, because 900 and some odd dollars in the temporary order. So yes, Your Honor, we did order child support.
Okay, all right, then we're going to proceed. So anything else on your opening statement?
No, Your Honor.
All right, and both of sides have had a chance. Your first witness?
Yes, Your Honor, I'd like to call Mr. Alakinis.
Go ahead.
I'm here.
All right, Mr. Alakinis, would you state your name for the record?
Eric H. Alakinas.
And Mr. Alakinis, you are the father of Elijah Lopez, also known as Elijah Alakinis. Is that right?
Yes, ma'am.
All right. And you recall that we were in court in the summer of 2020, and you were given a certain visitation order. Do you remember that?
Yes, ma'am.
At that time, did you have a different work schedule and a different pay rate than what you have now?
Absolutely.
Okay. Now, what you do recall that Miss Salinas, the child's mother, had a problem because she believed you were not present for most or all of your visitations. Do you recall that?
Yes, ma'am.
And so you remember that the court allowed you or told you, ordered you to keep a log of the times that you were present when you were home overnight with Elijah. Do you remember that?
Yes, ma'am.
Did you keep such a log?
Yes, ma'am.
And you have given me a copy of the log. Is that right?
Yes, ma'am. I sure did.
Your Honor, do you want us to do our exhibits through chat?
I would appreciate that, yes.
All right. Well, then what I'm going to do is, let me go to chat and I'm going to open Mr. Alakinis's log. Now, Mr. Alakinis, when you did the log, you started it, and how you did it was you signed your name and then you put a date, a time, and a place, and you hand wrote all of this yourself. Is that right?
Yes, ma'am.
Okay, so if I open that,
is a truck driver?
Yes.
he was a long distance truck driver, and now that job has changed. And I'm going to get to
I
that.
just wanted to make sure I was recalling the correct case. Go ahead, ma'am.
That is correct, Your Honor. He modified that position. Let me try to get to the, hang on. I got to get to the network because it's on the front of my other computer. Hang on. Sorry, Your Honor, it's taking me a while to find it.
Go ahead.
Okay. I just saw it a few minutes ago, so I know it's in here. There it is. All right. E-logs. Okay. All right, Your Honor, I put it on the chat, his logs. Do you want to open that in screen share, or how do you want to do it?
I'll let you screen share. Let me
That's
just,
still loading.
and it hasn't come through.
It's still loading, if you'll hang on. Do you see it now?
Yes, one new message.
Okay. Whoops. Okay, Your Honor, so
All right. Mr. Finkel, were you able to download that?
No, Judge, I don't think it was sent to me on the chat.
It says to everyone, so it should have gone through.
yeah, I just posted it to everyone.
Let me see. I don't see anything.
It should be E. Alakinis Logs PDF in the chat. It's posted from me to everyone, Mike.
All right, I'm looking in chat right now and I don't see anything. The last thing I see is somebody's reset.
I have nothing myself.
I can see it on mine.
You can or cannot, Chris?
I can.
I see it as well.
I don't know why, but I'm still not seeing anything.
Good morning. Good.
Can you send it directly to me?
I can certainly scan and hang on. Let me just ask Brooke to, she scanned it. I'll just have her email it to you directly, Mike, okay? Hang on.
Or on chat, just directly to me?
All right, what kind of machine are you on? Are you on a phone, Mr. Finkel?
Who? Oh, yes, I'm on a phone.
All right, I don't think you can get attachments on a phone.
Yeah, I don't think you
Oh.
can either. Do you want me to just email it to you, Mr. Finkel?
You can, yes.
All right, let me have my secretary just directly email to Mr. Finkel. And I'm also going to email his pay stubs that I'd sent you previously. Do you want me to email you those for reference here in a few minutes, or do you have
That's
those
fine.
available?
I mean, I have the ones that you sent me earlier. I don't know if you have more since then.
I just have the ones through November, I think it was, that I had sent you before. Do you want me to send you those again?
Yes, all I have is through October.
Oh, I think maybe it was the end of October. Okay, if that's all you have, that's all I have. I don't want to waste your time emailing those if you've already got those.
Okay. Yeah, I've got them through October.
Hang on. Would you email Mike the logs? Yeah, just the logs. You can. He's already gotten those. All right, we're emailing those to Mr. Finkel. The log.
More.
Tell me when you've done it. Okay. Finkel, have you received them through your email? My secretary's already emailed them to you.
Let me look. Not yet. Nothing's come through yet, but I don't know if you want to keep questioning or.
We sent it to you at 10:45 a.m. You still haven't gotten it?
No, ma'am.
Well, Your Honor, do you want me,
Go ahead and.
Do we want to, do you want to screen share it? I don't know exactly how you want.
That's fine. You may go ahead and screen share.
All right.
All right, Ms. Walters, have I received an affidavit? There was a person in custody that I believe TRLA was doing the affidavit for.
So Judge, you should have, or Lori should have, or it might have gotten sent to Miss Poppy. I'm not sure. Let me try to figure out what Roland did with that affidavit. I do know he completed it.
Okay.
But not on TextShare yet because we're learning how to use TextShare tomorrow. And so it'll be just a regular affidavit. Do you think you're going to want Ryan in here for that? Or do I just need to find where it is and you'll give it to somebody else?
I just need to look at it.
Okay. Let me troubleshoot and find where it is.
I've had single men with no dependents who make $100,000 a year drive a Corvette, ask for a court-appointed attorney. So I always want to look at them.
Right. I mean, if he qualifies, will you need Ryan or are you appointing local counsel?
No, I'll appoint y'all.
Okay. Then let me find out what happened to it. Thank you, Judge.
Okay. And if nobody else is using it, if we can get a breakout room, that's fine. Or if you need a breakout room with him, with a defendant.
Okay.
And were you going to share that?
Sure. Hang on, I don't have it up.
I've got it, Cindy. It came through email.
You got it?
I think so. Yeah, it came through email. Whatever you sent through emails, I got it.
All right. I'm not very good at sharing. All right, hang on.
All right, Mr. Moon, you should have received an invitation to breakout room 4.
Where is? Okay. Can you see that, Your Honor?
Yes, and I have it pulled up also.
Okay. All right. Are we ready to proceed?
Go ahead.
All right. Mr. Alakinas, is this the log that you prepared?
Yes, ma'am.
And in this log, you can see that you have, as you've described, you can sign you've signed your name, you put a date, you put a time and a place of pickup and a time and a place of drop off. Is that right?
Yes, ma'am.
And this is a true and correct copy of your handwritten log that you kept.
Yes, ma'am.
And it reflects all the way from the beginning. Let's see, the first I think was September the 10th. And then it goes all the way through 12/7. Is that right?
Yes, ma'am.
Okay, now do these indicate all the dates that your son spent the night with you?
Yes, every day that he was at the house and I was with him.
Okay. And were there ever any nights during all of this time that you were not there overnight while he was at your home?
Yes, ma'am. There was one on page 2, line 10 on 12/3. He was picked up from daycare at 3:45. And I made a note, was not home, needed to finish load. I had a small breakdown and that was the only day of all the 3 months, 4 months, whatever that is, of time that I had with him. But I did make a note on the day I was not home.
Okay, and where was that, did you say?
It was on page 2 on line 10.
Okay, yeah, let me go back to that. Page 2, line 10. Okay, there it is. And so your testimony is that every single night that you have visitation, this accurately reflects that you were home with your child, except for the one that you've indicated right here on line 10.
Yes, ma'am.
All right, now I asked that petitioner's exhibit 1, I didn't label it, but petitioner's exhibit 1, which is his log, be admitted into evidence, Your Honor.
Mr. Finkel? Mr. Finkel?
Did we lose Mr. Finkel?
You may have lost him along the way. Here he is.
Oh, here I am. I'm sorry. Well, Judge, you asked the parties to prepare it, so whether I object or not, I don't think it matters.
I mean, it's just demonstrative. I'll admit it into evidence. Again, it's just demonstrative. Go ahead, ma'am.
Right. All right. Now, Mr. Alakinas, did you change your job situation from the time of the last hearing between then and now?
From the time we did the temporary hearing till now, yes.
All right. What was your prior position at the time of the temporary orders hearing?
Prior to what I'm doing now, I was over the road. I had told her, Elijah's mother, Christy, that I was going to do 2 years over the road. We saw it before I decided to do local. 2 years over the road gives you all the experience needed to find a local job. But I found a local job within my same company that catered to me and opened up a new route up in June, which I took up in July. I've been doing this route now since July, but prior to this, I was over the road for 2 years.
All right. Now, when you did a local job, does that mean, what does that mean, local job?
Locally, our warehouse is in San Antonio. That's where our home base warehouse is. My scheduling there, since it's local, is we get a load on a Monday, come back on Tuesday, leave on Wednesday, come back on Thursday, leave Friday, come back on Saturday on the weeks that I don't have Elijah. But that is basically the schedule for that route, is because we always have to come back to the home base. We pick up at the home in San Antonio and we come back to the home base in San Antonio.
All right. And so was your employer able to arrange that? So when you have Elijah, you are not doing anything that requires you to be gone?
Yeah, my logs show it, ma'am. My logs show the proof that I'm home on all the days that Elijah comes home. I'm there.
Okay. Now, when you change jobs, did that require a subsequent change in income level?
Oh, absolutely.
Okay. Did your income level go up or down?
Down.
All right. Now, Your Honor.
Yes, ma'am.
I need to, now I need to get to, hang on. I have some paycheck stubs that I need to enter into evidence. So I guess I need to stop. Let me go back up here. I'm going to have to do a new, do you want me to just share, or do you want me to go back to the chat and submit the paycheck stubs?
Okay, I don't want to go through that again. Let's just share them in for right now. Okay. If we need hard copies, we can do that later.
All right, Your Honor, let me go find. Okay, hang on. Hang on just a second. I'm gonna have to go. It's not letting me. I'm sorry, Your Honor, my ability to do this is. I'm gonna have to. I may have to load it from chat so that I can do this correctly. So give me a second. Where did it go? Okay. I'm just going to load this into chat and then hopefully I can share it from there.
Go ahead.
So it's loading, sorry. Okay,
Well, I haven't.
okay. Now, if I go back. Hopefully then it'll share. There. Okay. All right, now, Mr. Alakinas, you provided me with paycheck stubs beginning August 13th, and the ones I have go from August 13th through 10/29 of 2020. Is that right?
Yes, ma'am.
All right, and since the end of October to now, are your paycheck stubs exactly the same as these?
Yes, ma'am, they're the same.
Okay, so nothing's changed. We just have these from August through October, the end of
Yes, ma'am.
October.
It's the same route, same. You'll see 1 week is higher than the other. The 1 week where it's higher is usually when I don't have Elijah. Only on that Thursday. I come home that Thursday and then I leave again Friday, Saturday. And the second week or the following week will usually be a lot smaller because that's when I'm home for Elijah's care. So I'm off Thursday, Friday, Saturday, Sunday, and I don't return back to work till I drop him off. So he's dropped off in daycare Monday.
All right, so that pattern is in these paycheck stubs and then has continued to today.
Yes, ma'am.
All right, and so your paycheck stubs come from Drivers Management LLC,
Yes, ma'am.
and you recognize these paycheck stubs and they are true and correct copies of the stubs that you personally receive for your employment through this company.
That's exactly what I receive.
All right, and if we go down the page, you've got August. You get these weekly.
Yes, ma'am.
All right, and it goes all the way in consecutive order through the end of October. There's October. And you recognize these, and these are your paycheck stubs.
Yes, ma'am.
All right, Your Honor, I ask that these paycheck stubs be admitted into evidence as
Mr. Finkel?
Petitioner's Exhibit 2.
No objection.
Without objection, admitted into evidence as petitioners too.
All right, let me go back to the beginning. And Mr. Alakinas, do you have any other children, biological children for which you are responsible?
Yes, ma'am. 2.
2, and do they live with you, or are they live with another parent and you're paying child support?
No, they live here with me.
Okay. And so there are 2 other children that are not before this court for whom you are financially responsible that live in your home.
Yes, ma'am.
Okay. All right, Your Honor. And so you're asking the court to allow your child support to be based on these paycheck stubs and lower your child support. You are also providing health and dental insurance for all of these children. Is that right?
Yes, ma'am.
All right. And you want to continue to do that and then pay guideline child support based on your current income.
Yes, ma'am.
And you want to continue to have your expanded standard visitation order, which you've been exercising since our temporary orders hearing.
Yes, ma'am, since August.
All right. I pass the witness, Your Honor.
Go ahead, Mr. Finkel.
Thank you, Your Honor. Mr. Alakinas, as far as your job changing, what does it take to change your job?
A phone call.
Okay, so you just have to tell them what routes you want to take and when you want to take them?
No, not like that. I put in a request that I have a situation. I would see if there's a route that can accommodate it.
All right, so it would be just as easy for you to make a phone call and start doing over the road routes again. Is that true?
Yeah, if I decided to do that, I mean, I'm not going to say no. It's like I said, it's about a phone call.
All right, and you didn't actually change your routes until after the temporary orders hearing, correct?
I changed my route after my 2 years were completed in over the road.
And when was that?
In July, I believe. I actually started in August.
Okay. And then so regardless,
just for the record, my
wait, objection, Your Honor.
Right, sir, if Ms. Vickers thinks there's something that you need to follow up with, she will ask you that shortly.
Okay.
And in changing your position, I know you're saying that your income is different, but did your rate of pay change?
Of course.
What did it change from and what did it change to?
It changed from 38 cents a mile to 50 cents a mile with less miles.
Okay, so I'm looking at your paychecks of the ones that have been entered, and it looks like you're making 49 cents per mile on all of these.
Yeah, because it's all the same. It doesn't change.
Okay, so you get paid 49 cents per mile.
Yes.
All right, and as of October 29th, your year-to-date total gross earnings was $71,433.13, correct?
Probably, yes.
All right. And as far as what they take out for your pay, you mentioned that you pay health insurance and dental insurance. Is that for all your children?
Yes.
Okay. And the two that you mentioned earlier that live with you, are those your biological children?
Yes.
All right. And so they're included in the expense for the healthcare?
Yes.
I see that you also have funds taken out for a 401k savings plan and a 401k repay, about $100 per paycheck. Is that correct?
Not correct on both of them. The one, it just depends on what I make. It's a percentage of whatever is made that week. So
okay, but
it's not correct to say $100 for each because it varies.
Okay, so I agree. I mean, it's not $100 exactly each paycheck, but an amount. And I'm looking at the 1029 one, which for that one, it happens to be, and that one's over like almost 120. But be that as it may, you do have money taken out for 401k savings and 401k repay.
Yes, there's money being taken out for 401k.
All right. And do you intend on changing your jobs back to over the road at any time soon?
Not anytime soon.
And who takes your child to daycare on Mondays and Fridays?
My wife. My wife works 3 miles away, so she drops him off at daycare before she goes into work at 8.
Okay, and who picks him up from daycare?
All three of us. Me, myself, my wife, and my mom.
You mean all three of you at the same time, or between the three of you, one of the three of you picks them up?
One of three of us pick us up.
Okay, how often have you picked them up?
I'd say at least half the time. A quarter of the time. I'd say at least a third of the time I've picked them up.
Okay.
My mom picks them up a lot as well because she's always going to Pleasanton. So because I live 15 miles away from the daycare, if she's in town and I'm at home, it's just easy for her to pick him up. She's got a car seat and she'll grab him. He loves his grandma just like he does myself.
All right. Do you use a car seat when you transport him?
Yes, sir. We got a car seat in each vehicle.
And you always use it?
Yes, sir.
Okay. What does your son call his mother?
His mother?
Uh-huh.
I would hope to call her mom.
Do you encourage that?
I don't reference his mom when I have Elijah. I don't speak of his mom. It's not in my thought to speak of his mother when he's with me. My concern is for him to enjoy his time with me and with my family here.
Okay. Does your family talk about his mother?
Nope.
Your Honor, I'm going to object to the relevance of this. We're talking about whether my client gets expanded standard, and then we're talking about child support.
Well,
Ms. Vickers, I lost you. All I had was you're on. I'm going to object.
All right, can you hear me?
Now I can.
All right, I'm objecting to the relevance of these questions because we're talking about my client getting expanded or not and changing his child support. So I don't feel like this line of question is relevant.
Okay, everybody's still here? Okay, all right. I blipped completely out of Zoom. The last thing I heard was the question, does your family talk about his mom? So I don't know what is then. What is, okay, so you want to start over at that point? Because I didn't hear anything to know what the objection was to.
That Ms. Vickers objected to that question, I believe.
Yes, if you heard that question, Your Honor, I objected as to the relevance of inquiries regarding how my client refers to Miss Salinas and how his family refers to him and whether they encourage that. All that line of questioning is irrelevant to what we have before the court today, which is whether my client gets expanded and what happens to the child support. So I objected.
Mr. Finkel?
And Your Honor, I'd say that it goes to the best interest. There'll be testimony, or the evidence will show that there's possible parental alienation going on, and so it goes to the best interest of the child.
I'll overrule the objection.
So, Mr. Alaquinez, does your family talk to your son about his mother?
No.
What does your son call your current wife?
Mom.
Okay, and I'm sure your son talks about his mother when he's at your house.
No.
How does he? He doesn't talk about home at all?
No, sir. The only time that Elijah brings up his home is when I have him call, or if she calls, then he'll say, Mom's calling or my Christy's calling. That's what he'll say. But no, he doesn't. He does not talk about his mother's home whatsoever.
Okay. But you just said he'll refer to her as my Christy?
Yeah, that's what he says.
Okay. And how does he know, or why does he refer to her as my Christy?
Your Honor, I'm going to object. That's all speculation. It's hearsay.
Mr. Finkel?
Well, again, he testified that that's what his son says and refers to his mother as. And so I'm asking why that is.
I'll allow this one more question. Overrule the objection.
You might ask Christy, because when I've spoken to Christy, she said, well, it's okay for Elijah to know our name, because when I call over there, he says, oh, Eric's calling. So to me, Miss Christy is teaching him that her name is Christy and her boyfriend's name is Joe and my name is Eric. And my wife's name is Paola. So for him to be coached to be called her Paola, then she's teaching people names. And to me, it's supposed to be okay to do that, because that's what Christy said she's doing.
Okay, so you're saying that that's what you're doing. You're trying to teach your son everybody's names?
I said Christy is doing that, not me.
Oh, okay. Okay, I'll pass the witness.
I have no further questions, Your Honor. I've sent figures to Mr. Finkel. I don't know if he disputes my math, but I set the actual computations for child support. We have health insurance from the temporary order that I included, and I can give those figures as part of my final argument.
Go ahead. So you're resting?
Yes.
All right, Mr. Finkel?
Okay, Judge, I'd like to call Letitia Carrasco.
All right, go ahead.
Carrasco, are you still there? Ms. Carrasco, are you still there?
Yes, sir, I'm here.
Thank you. Would you state your name and for the record?
Leticia Carrasco,
And Ms. Carrasco, how are you employed?
childcare, the daycare.
And are you familiar with the child, Elijah?
Yes, sir.
Now, is he in your classroom or how do you know him?
Yes, sir. He's in my classroom.
All right. And do you know Elijah's parents?
Yes, I know Eric and the family.
Okay.
I mean, I don't associate. I know who they are. I mean, you know, it's a small town, but yes, I do take care of Elijah.
Okay. And do you know Miss Christy Salinas as well?
Yes, sir. And I'm not taking sides.
And,
I'm just out in the middle of this. Go ahead.
No, I understand. I'm not asking you to pick
No,
sides or anything like that.
No. Yeah.
I'm just asking, have you noticed a change?
I couldn't hear you. You broke out. Sorry.
I said, have you noticed a change in Elijah's behavior there at the daycare since he has been spending more time with his father and specifically on times where he's come to the daycare after visiting with his father?
Elijah is Elijah. He's a really good kid. I don't have any problems with Elijah. And no, it's not any different when he comes with his dad. I mean, the only time that he gets upset, it's when he doesn't get what he wants. But for me to say that he's bad when he comes, no.
Okay, and what types of things does he do when he doesn't get what he wants?
He starts yelling and he starts throwing his fits and he just sits there and starts crying, and I have to tell him that we have to share his toys, or I mean, I just try to comfort him, but he's okay after that.
Okay, and is that something that he's always done?
He doesn't do it every day. He does it once in a great while. You know, but I usually let them, you know, they know when to share. Like one has, you know, usually we have a couple of toys, but, you know, we don't have, you know, so many of them. So I tell them, you know, this is you're going to play with this right now, but you're going to have, you know, we're going to have to share this. And then he calms down. But I mean, he's a really good kid. I don't have any problems with Elijah. I mean, I don't even remember the last time, maybe a couple of weeks ago, that he, you know, got mad, but other than that, he's been good. I don't have any problems with him.
Okay. And what about any things, any incidents of fighting or hitting other kids at the daycare?
No. I mean, it's you know, they're playing outside and they play tag, and you know, sometimes they think that they're pushing each other, but it's not. You know, I tell them that it's, you know, they don't push. They have to just, you know, they tag, and you know, I just stand with them and, you know, explain to them so they're okay, and then they start running. You know, he starts running, but even that, I mean, he's, you know, he's a really good kid.
Are you present in the mornings when Elijah's dropped off, or in the afternoons when he's picked up?
Yes. Most of the time, yes. It just depends what time we come in.
Okay, and how often?
But the majority, but the majority of the time that he gets dropped off is before 8 o'clock, and around maybe 3:30, close to 4, he's picked up. So I'm usually here, but it just depends. I'm off one day out of the week.
All right. And how often have you seen Mr. Eric Alaquinez either drop off or pick up his son?
Usually in the morning, not very much, but in the afternoon, sometimes.
Would you say like 25% of the time, 50% of the time? How often?
Okay, and I'm going to ask Mr. Finkel, just so I understand what testimony I'm hearing, 25% of the time overall, or 25% of the time when Mr. Alaquinez is scheduled to have possession of the child?
Well, I think most of the time.
Okay, ma'am, hold on. Mr. Finkel needs to answer the question first.
Okay, I'm sorry.
Well, I was
I'm not sure what the question.
I was referring to the time that Mr. Alaquinez is supposed to have him. I'm not sure if Ms. Carrasco would know that, would know when that is, but.
Yeah, well, I know because usually like on Thursdays, he picks them up like every Thursday, and then it's every other weekend he picks him up. So the majority of the time that he picks them up, it's his mom picking them up.
Okay. And same thing, taking him in the mornings?
His wife brings them in the morning.
Okay. And when Miss Salinas has Elijah, do you know if she does dropping off and picking up, or?
She does leave mostly in the morning, or he does, her boyfriend, and he picks them up in the afternoons most of the time because she works. It just depends on her schedule at work.
All right. And have you ever had to call either of the parents to discuss Elijah's behavior at all?
No, sir.
Okay. Have you had any issues with Elijah's use of bad words there at the daycare? His language?
No.
Okay.
Maybe one time, but I mean, it's been a while.
Okay. Do you recall what that one time was?
It's been months ago. Like I said, I mean, he's a really good kid. I don't recall that. I mean, I remember one time I had to sit with him and tell him that wasn't right. But even that, I mean, he's good.
Okay. Do you recall what it was that he said or what wasn't right?
No, I don't recall that, but I do remember him saying this word. But I just can't remember right now.
Okay.
Yeah, but either that, he's never said any ugly words. Not even. I mean, he's never said "shut up" or nothing like that.
Okay. And can you do you know how he refers to his mother and father when he's talking about them?
Your Honor, I'm going to object. This is going to be hearsay.
Well, he's come around.
Ma'am,
wait.
There's been an objection. You need to wait for the attorney's night to finish. Yes, Mr. Finkel.
As far as the objection is concerned, it goes to his motive, what he's calling his parents.
That's still hearsay.
Well, okay. I'm not sure it's relevant, but I don't think it's hearsay. What he calls his parents is a fact. All right. So I'm going to ask you to unmute your computer, ma'am, or your phone. Ms. Carrasco?
Yes, sir. Yes, sir.
All right. You may answer the question.
Okay. In the beginning, when he used to come, he did call her Christy. And I would correct him because, I told him, no, that's mommy. That's not Christy. And he would, he'd just pick up his eyes and say, Christy? And I said, no. I said, mommy. He said, mommy. And I said, yes, that's mommy. That's not Christy. And he said, okay. So he would leave it like that. But several times that he would do that. And I would correct him, say, no, that's mommy. And then, of course, the way I see it, it's two homes, you know. I mean, I don't know if, I mean, he hasn't said that in a good while either. So, but he has called, which is Eric's wife, mom, you know. And so it's like, I mean, I don't want to feel like I have to correct him, you know, on that, because it's like he's in both homes. So it's, maybe he's just comfortable with that. I don't know. I mean, I just correct him and tell him that Christy is his mom.
Okay, thank you. I'll pass the witness.
Okay.
I have no questions of Ms. Carrasco.
All right, so may this witness be excused?
Yes.
All right, Ms. Carrasco, you're free to go. Thank you for being available.
Thank you, Ms.
Thank you,
Carrasco.
sir. Thank you. Thank you. Thank you very much. Thanks.
All right, your next witness.
Christy Salinas.
All right, ma'am, there you are. Go ahead, sir.
Could you state your name for the record, please?
Christy Marie Salinas.
And Ms. Salinas, you're the respondent in this matter, and you are the mother of Elijah, is that correct?
Yes.
Now, since the temporary orders have been put in place, can you describe for the court how things have been going?
They've been pretty interesting. I don't know if the back and forth, how it affects him. He comes back differently. I've had some issues with him, as in his behavior, acting out.
Okay, can you describe for the court any specific incidents that you're referring to?
Yes, one time he came back and they were all playing, and out of nowhere he just yelled, "What the?" I don't know if I can say that.
Well, Your Honor, I'm going to object to anything the child said, because again, that's hearsay.
That would be an excited.
It's not for the truth of the matter asserted. It's for, how old is this child?
He's 3.
All right, Ms. Vickers, it's like if you teach a parrot a word, and I mean, I've got kids, you're not reciting what the parrot said to show that the parrot meant that word, but simply that the parrot must have heard it somewhere. All right, so go ahead, ma'am.
Of course I got after him. I let him know that that was an ugly word, that we don't talk like that. You know, I tell him, you know, I ask him if he hears it at daycare or where he hears it from, and he'll respond, you know, he'll say from his dad's house, he'll say one of the kids or whatever. And there's times that I've messaged his father, or I've asked his father, you know, hey, does Elijah talk like this, or have you heard him say whatever at your house? And he'll usually respond, no, he doesn't do that over here. Also, when he comes back, if he does not get his way, he throws a fit. He will throw himself on the floor and he will cry because his dad takes him to Walmart and buys him a toy, or that's how he'll tell me, my daddy buys it for me, or my daddy says, yes, I can have this. And I tell him, well, okay, well, what you do at your daddy's house is at daddy's house. This is mommy's house. And you can't act like that here. We don't get everything we want. We're not going to just drive to Walmart just because you want a toy. You know, you have to eat your food. We're not going to go buy you McDonald's just because you want McDonald's. So just things of that nature. That's what he does. He also comes back and he'll call me Christy. And I tell him, why are you calling me Christy? I'm mommy. You know, I'm mommy. Yes, my name is Christy, but I'm mommy. And he'll tell me, no, you're not mommy. You're Christy, Paola's mommy. And I say, no, Paola's stepmommy, but I'm mommy. And he'll say, no, you're Christy. They say you're Christy and Paola's mommy.
So, and is that something that he used to do before the temporary orders were put into place?
No, he's never done that to me.
Have there been other concerns that you've had as far as Elijah's anger or getting along with other kids?
I mean, he's always been fine. But like lately, he's rough. He's rough. Also, when he comes back, he is terrified. I don't know. He tells me that he's scared. He's scared. I don't know if like the other kids over there just play around with him, but he'll tell me things like his sister scared him or things like of that sort. But he'll walk down my hallway and he puts his hands over his eyes and he will not move his hands. And I'm like, Elijah, what's wrong with you? And he'll say, I'm scared. I'm scared. I said, what are you scared of? There's nothing to be scared of. And he'll just say like, oh, Eric scared me, which is he has a brother named Eric as well. Just things of that. And I tell him, okay, well, tell him he can't play with you like that. He can't scare you because it's not okay. And I don't, I'm not saying that he's doing it, to be malicious or anything, but he does come back scared.
All right. And again, with as far as the language, you don't use curse words in your house for him to hear?
Oh, I'm not going to say that I've never said, oh shit, or like of that, every once in a while. But no, we try really hard. We, to tell all of my kids, I have teenagers and they're not even allowed to use bad words. They get in trouble for saying hell. So yeah, I don't allow that.
Have you had any concerns about Elijah's father's use of a car seat with Elijah?
I don't have any concerns. But the one time that he said that I was seeing things or whatever, I saw his wife pick him up and I saw her put him in. I saw her put the seatbelt over the car seat instead of the car seat being buckled up the way it was. But he told me I was seeing things. As far as I know that they have car seats, I pray they use them. But when he does come back, he'll fight me. He does not want to go in his car seat. He'll fight me. He'll fight me. He'll tell me, no, I don't want to be in there. I want to sit. Like he cries to go sit in like the regular seat. And I tell him, no, you're too little. You're supposed to be in a car seat. And he will scream his head off, which is, I don't understand why, because he's always in a car seat with us and he knows the rules.
Okay, and does he say anything about it as far as whether he?
He'll say things like that he gets to sit with Erica, or or he'll sit with which is his sister over there. He'll say things like that.
All right, and let's see. Do you think that it's in Elijah's best interest that that the orders that were in place before the temporary orders, do you think that those should be modified and that Elijah's father should have the extended standard visitation? Do you think that's in Elijah's best interest?
I don't know. As his mom, I'm gonna say no. When he leaves, he cries. I tell him, okay, it's your dad's turn to pick you up. He's gonna pick you up from daycare, or grandma's gonna pick you up, because she's the one who usually picks him up. He'll tell me things like, I'm sorry, Mom, I won't be a bad boy no more. He thinks that I'm sending him off because he's being a bad boy. And I tell him, no, that's not it, baby. It's their turn to be, for you to go spend time with them. I mean, I'm not saying that he doesn't enjoy it over there when he's over there. I'm sure they give him whatever he needs over there. But there are some concerns, when I call him and I talk to him on the phone, there's times where he'll ask me if he can come home.
Your Honor, we've allowed a lot of hearsay in. I continue to object to hearsay. This is more hearsay.
I'll sustain that objection.
Okay, so as far as your time with him, has there been any time that you have had him that you haven't stayed with him?
No, I work for the school district, so my schedule is on his, I have the same schedule as him. As far as, dropping off at daycare, there'll be two, my spouse, he works for the Toyota company, so he works 2 weeks mornings, 2 weeks evenings. So on the weeks that he works morning, I usually drop off and he'll be off by 3:30. So he'll usually pick up from daycare. So that way I can just come straight home and wait for the kids to get off the bus. On the other, 2 weeks, he'll drop off and I'll pick up. So, I mean, as far as, he's always with us. There's never a time that he's not with us.
Okay. And I know prior to this modification, Mr. Alacanez was not ordered to pay child support. Is that correct?
That's correct.
When did he move out, or it was stated by his attorney that the reason he wasn't paying child support was because y'all lived together? Is that accurate?
No, we've never lived together. We were seeing each other, so I just, I didn't have him on child support. He did the insurance, medical and dental, and that was it. But whenever we, cut things off, he helped me. He sent money a couple of times, and then that was it. So then I went and I filed for child support.
Okay, so when was that you finally went to ask for child support? Like when did he move out, or when?
I think it wasn't until, I don't know if it was the end of 2019 or January of 2020 that I went to Attorney General's office. But me and him had stopped talking since before then, and I waited a whole maybe 6 months before I even went and put him on child support.
Okay. So, okay. Is there anything else you think the court needs to know in helping make a decision?
No, I think I pretty much said everything. I mean, everything I can say is just, they're going to say, oh, she is not saying whatever because Elijah's the one who tells me things, or he'll make comments, but that's about it. He's all I care about. That's all that matters to me.
All right, and so you're asking the court to deny Mr. Alacanez's request to modify the visitation, and you're asking that he pay child support. Is that correct?
Yes.
Thank you. I'll pass the witness.
Ms. Salinas, is there any other Attorney General order after the one that's dated June 18th of 2018?
Whenever I went back to ask for child support, this was I don't know if it was December of 2019 or January of 2020. I'm not too sure.
All right, but you did not have a court order in child support court other than the one that already existed?
No, whenever I went and I asked for child support, whenever we had stopped talking, me and Eric, I went to go modify so he can pay child support, and then that's whenever he got a lawyer and this all happened.
All right. I have no further questions of Ms. Salinas, Your Honor.
All right, your next witness.
No further witnesses, Your Honor. Rest.
All right, give me just a moment. I'm just looking at the clerk's records, trying to. Okay, so who filed the first motion to modify?
That would be my client, Your Honor. In the current proceedings, yes, that would be my client. And I believe before that, the last court order is the AG order from June of 2018. And that's the one that's got 0 child support in it.
And then there was a motion filed by your client in May of 2020.
I believe that is correct. And then we had the temporary orders over the summer of 2020. And at that time, my client was ordered to pay, I want to say it was 9. Hang on.
And then there was a cross petition filed in June, it looks like. Okay.
Yes.
All right, argument.
Yes, Your Honor. You ordered expanded standard under the temporary orders and then deferred the continuation of it to the final hearing. Under the family code, unless it's not in the child's best interest, my client's entitled to expanded standard. I've heard nothing here today. There's been no evidence presented that it's not in the child's best interest. The kind of testimony we have had is fairly standard for a 3-year-old, whether his parents are separated or not, and certainly not uncommon for separated parents. So there's been nothing presented. My client provided the log that you ordered us to provide. I didn't see a log from Ms. Salinas, but my client provided the log. I have provided you with the paycheck stubs for his new job, because obviously the big concern was that he wasn't there. So he rearranged his schedule to guarantee that there would be no issues with that. And as far as I can tell, there haven't been any issues. But of course, that lowered his pay, which is not an unexpected thing. If you are not going over the road, staying out and gone for more hours, then your pay is going to decrease, your total pay, because you're on the road less, because you're home more, overnights, etc. So based on the paycheck stubs that I provided, and I already provided these calculations to Mr. Finkel, using the child support charts, his child support with 2 other children for which he must provide outside of the court, and the one before the court, his child support would be $684.70 a month. He pays health insurance for all of his children. And I determined his amount for this child, which I believe are the numbers that are in the temporary order, was $105.26 for this child's health insurance and $7.22 a month for this child's dental insurance. Those numbers were used to calculate his net income to give me child support of $684.70. And we're asking you to lower the child support and order it at $684.70 based on his having to change his work schedule to comply with this court and Ms. Salinas' concerns about his unavailability. I mean, you can't have your cake and eat it too. It's one or lower pay comes with the change of schedule. So that's what we're asking this court to do. Give him expanded standard and have him pay $684.70 a month. You can begin that February 1, and he provides the health insurance as he's been providing and the dental insurance.
All right, Mr. Finkel.
Thank you, Your Honor. Your Honor, I'd ask that first of all, the child support be based on his year-to-date total from that October 29th pay stub, which at that time was $71,433.13. But there wasn't, when Ms. Vickers figured the child support, she didn't add in, there were deductions for the 401k savings plan and 401k repay out of each weekly paycheck. Like I said, in that last one of 1029, the amounts were $68.98 and $53.06. And so he's taking money out every paycheck, every week to go towards his 401k. And And I think that should be added back in order to figure out the child support. And if you do that, then the child support's going to be higher than 684.70. As far as the modification of visitation, I believe, Your Honor, that Mr. Alequinez specifically changed his routes just for this court because this modification was pending. I don't see any reason why he's not going to go back and change it to what he was doing before, which was working the longer routes and getting paid more, and then letting his family have his visitation time. And so since he has been visiting more, the testimony shows that Elijah has been having more behavior problems, been throwing tantrums when he doesn't get his way, saying bad words, cussing, and calling his mother by her first name instead of calling her mom, which just goes to show that, when he's over at his dad's house, it may not be his dad alienating mom, but somebody is. And so we'd ask that the request to modify the visitation be denied, and that the standard visitation remain in place at this time.
Your Honor, can I address the question about the pay briefly? What I did was I took the gross. What I did is, because he changed jobs, the paycheck stubs that I've provided to you, he changed jobs in the middle of the year. So I took the year-to-date figure is almost entirely for 8/13. That was almost entirely his old rate of pay. So then I subtracted the new rate of pay. I subtracted the old rate of pay and the new rate of pay. I used the gross. I didn't take out anything for 401k or anything like that. The numbers that I provided were based on the pay during his period when he had the lower paying job. I started from 8/13 to the end of October. So yes, I did use year to date because that didn't make any sense. The whole idea was he changed his job in August. I think it was on August the 11th, and the paycheck was August 13th. So it was almost entirely that period that's what I used, because that was almost entirely his new rate of pay. So yes, the year to date is somewhat misleading because a lot of that included his higher rate of pay. I just used the lower rate of pay that is reflected on those things. And I used the gross pay. I didn't deduct anything for 401k as far as I can recall. I'm looking at my calculations and it appears that I did not take out anything for that. And that's what gave me 684.70.
Well, and I will say, Your Honor, his rate of pay hasn't changed.
Okay, I'll just say, I'll let the attorneys look at the numbers. Obviously, the 401k and the 401k repayment where he's got a loan against his 401k, those deductions should not be removed from his gross income when calculating child support. And if they have been, Mr. Finkel, you can run the numbers and you and Ms. Vickers can settle that, or we can have just a 30-second hearing on that, but they should not be included. So if you give you a chance to run the numbers and make sure that you believe that it was based on the right gross income.
Well, and Your Honor, just based on the year to date, I mean, I think that number is accurate as far as
all right.
Because his rate, I'm sorry.
All right, Mr. Finkel, I've had enough there. Okay, I have recollected this case quite a bit. I have listened to the testimony today. I certainly have heard nothing that leads me to believe that the young man would be endangered or harmed by continuing to have the extended visitation with his father, or possession of periods by his father. I don't know the testimony from Ms. Carrasco. I don't know what I thought it was that there had not been a big change since they had this change take place, and not big change in the child since the change in the periods of possession. So I will allow that to continue. I also will recollect that there was a great deal of concern, and I think that I thought there was some reason for concern that Mr. Alacanese was not using a whole lot of his actual periods of possession. And I mean, obviously a child's not supposed to be chained to you 24/7 whenever they're in your possession. And Salinas' husband, drops him off at daycare or picks him up quite a lot. And that's all perfectly part of living. But I think Mr. Alacanese took action to address the concerns that Christy Salinas had raised. And I will find that that was an appropriate action to take to stop being an over-the-road truck driver. And I know that's hard. I had friends whose dads were over-the-road truck drivers when I was a kid, and I know that it was hard on them, having dad gone for a week or 10 days at a time. And I don't think Mr. Alacanese was gone that long, but it was hard on them. So I will set the child support on his pay with his new job. I will caution him that if there's further proceedings in the future, and it turns out that this was just kind of a smokescreen where you run out and start being an over-the-road truck driver again, that's not going to reflect well, sir, if there's future litigation in this. I'll also say, as far as what they call folks, whatever the other spouse, whatever the other parent wants to be called, within reason, is what each of you should support. So Miss Christy Salinas, what do you want is Elijah to call you? How should he address you?
I'm his mother. I think he should address me as his mom.
Absolutely. All right. Mr. Alacanese, I don't feel it's appropriate. And let me ask the parties, how should he address Mr. Alacanese's? Is it wife or girlfriend or?
His wife.
His wife. How should he address her, sir?
Oh, he sometimes calls her Paula, but he'll call her mom as well. Just like he calls Christy's boyfriend dad and her ex-husband dad. He's got two dads coming from Christy's side, but I don't encourage him not to call them dad or Joey or Joe or anything, because her ex-husband's Joey, her boyfriend is Joe. He comes and says, "Oh, my daddy Joe."
So what could he call your wife other than mom that would be appropriate?
Paula, by her name. I mean, it can only be one of the two, Paula or mom. And he doesn't. He doesn't repeatedly call her mommy, mommy, mommy. But yeah, he does call her mom and he does call her Paula. So I mean, whichever direction he feels he needs to. But the biggest to me.
Okay, that's enough. That's enough. Ms. Salinas.
Can I say something? It doesn't bother me. If he wants to call her mom, that's not what bothers me. What bothers me is when he comes home and tells me, "Oh, you're not mom, you're Christy." That's what bothers me. He goes over there and I let him know, "Oh yes, that's your stepmommy. That's it doesn't bother me. When he's here, I let him know, okay."
All right, ma'am. All right, so I'm going to instruct Ms. Vickers. Are you doing the order I take in?
Yes.
All right, I'm going to instruct you to put a paragraph in there and see if the attorneys can agree on it that just says that you will encourage the child to address step parents or step relations as X. I don't care what that is, as long as you can agree on it, and that you will not encourage him to address, if that's what y'all want, not encourage him to address his mother as Christy or his father as Eric, if that's what y'all want. But let's just have it clear what's supposed to happen so we're not confusing a little 3-year-old boy.
Just some kind of loving and caring order as
I
well?
can tell you that, I'm sorry?
Just a loving and caring order? Do you want to go to that extent, or?
Certainly.
That's.
Mr. Alacanese, I can tell you that I would not be, I'd be a hypocrite if I was sitting here casting stones at you for using rough language in front of your children. I will tell you, though, you need to watch that. I mean, it's not the end of the world. I have a niece who graduated from Cornell Law School last year. And I can remember her father, my brother-in-law, being called up to daycare when she was about 3 or 4 years old because of her language and some of the stuff that she said in front of the kids. So the other kids there. And he had to sit there and hang his head whenever they asked him where she picked up those words. So, sir, I mean, it's not just a joke. If you can there's a time and a place for language like that, and there's a time where it's not appropriate, and with around a 3-year-old is not appropriate. I know none of us would, I certainly didn't keep that in mind the whole time when I had little ones, but work on that, please. All right, how long do we need before we have an entry date?
I mean, I could probably have this order ready in 3 weeks or so, 2 or 3 weeks, something like that.
Okay, let me look at the calendar.
I don't know what, yeah, I don't know what you've got on your calendar.
I don't either.
Judge, can I make an announcement that the parties in the Martinez case have reached an agreement?
All right, now let's get this one finished first, and I'll get to y'all. I'm going to take announcements, and then we're going to have a break.
Yes, Your Honor.
Aaron.
Sorry.
Okay, calendar. Let's see, next month.
February 17th is available. That'd be about 3.5 weeks away. Or the 10th.
All right, is the 17th good, Ms. Vickers? Is that too soon?
Yes, just for an entry, yeah, I could do the 17th. I could also do the 10th. I'm already in court on the 10th, but we can do the 17th.
All right. So let me put 217 entry, and Ms. Salinas, Mr. Alacanese, I'll tell you that if I can make this work, okay. Ms. Vickers is going to draft an order, which she believes is what I've ordered today. Mr. Finkel will have a chance to look at it. If the two of you, and especially you, Ms. Salinas, if you're in agreement, not with what the order says, but if you're in agreement that what the order says is what I have ordered, then please go ahead and let your attorney know. If you're not in agreement and Mr. Finkel and Ms. Vickers cannot get that sorted out, then we'll be back here on the 17th of February for me to have a hearing on that. Okay, so is there anything we need to do in the Elijah Alacanese case?
No, Your Honor, I think that's it. May we be excused?
That's all I have, Your Honor.
Yes. Okay. All right. You had an announcement in the Martinez case.
Yes, Your Honor. Speaking for the plaintiff, Anna Holder and myself representing the plaintiff in the matter, and the defendant, Roxborough Realty, represented by Andy Moon, who is also here with his client, Anthony Cortez, and two pro se parties, Mr. Daniel Botello and Ms. Maria Carrillo, and my apologies if I didn't properly pronounce those names. They're all here today, and we have been conferring in the breakout room and have reached an agreement on our motion or application for a temporary injunction. The court, I put in the chat the language that's been reviewed by these parties, and we believe it's a fair way to maintain the status quo while we try to resolve the disputes before us.
Okay. All right, I'm downloading that right now, and let me ask, Mr. Moon, have you all signed off on this? Is it signed? Is it just?
It's we didn't put any signatures on it, but we're all in agreement on it. We were hoping to get the two pro se defendants to chime in as well, and due to technology reasons, none of us actually signed it, but we're in agreement. All
right. And let me ask Mr. Botello, is this your agreement, the document that I've been sent?
Yes, Your Honor, we are in an agreement.
And Ms. Carrillo, you also?
Yes, Your Honor, I'm in agreement.
All right, and it says the trial is set. Do we need a trial date right now?
Well, Your Honor, I believe the cases are without a temporary injunction, without a trial date, the order is void.
Okay.
I remember being on one of those cases long ago, and it was an agreement, and the court still found that it was void without a trial date. I'm not requesting one, truthfully, but without it, the order, I think, is void.
That's great. You may be interested to know that you cannot waive citation in a case by a Rule 11 agreement. I had a case where it was done and it was agreed And the guy trying to overturn the default stipulated, or the client did, that he had done that with the intention of allowing the default to be taken and then having it set aside later. The fourth court overruled me when I wouldn't let him set it aside. So they followed the exact letter. The exact letter says waiver of citation by an attorney has to be notarized just like it does by a client. And so that's fine. All right, so when do we want to set this? Let's just make a day up. Let me look at my calendar.
Your Honor, I'm thankful just to let us have this entered before the break. So thank you for any date that you would like.
All right, we'll put April 14th. And then y'all can get that reset later.
Yes, Your Honor.
All right, then I will sign off on this. And is there anything else we need to take up before I come back? Are there any other criminal hearings we need to have?
Judge, if I can, on that affidavit situation, you have it in the chat at this point.
Yes,
I
I've
haven't-
downloaded it. I have not looked at it.
Okay, then I can just have Ryan come back after lunch on that.
No, I'll look at it in just a moment, but anything.
Oh, okay.
Your Honor, can we be excused in the Martinez case at this point?
Yes, absolutely. And I'm going to save this and post it to the district clerk right now.
Thank you, Your Honor, very much. And be sure to give Minu a hard time as much as possible on my behalf.
Oh, and I can't do that.
Thank you, Your Honor. Have a good day.
Thank you.
You too.
Thank you all.
Judge, that's our executive director. When I saw him
Oh, I didn't know
in
who he-
here, he's the executive director of TRLA, so he's the top of us. And so when I saw him in here, I was like, man, they spot check us at that level.
Oh, okay. Yeah, no, he's not here to spy on you. Okay, let me ask, what other announcements do we have? Because I need to take about a 30-minute break. I don't usually break for lunch.
Your Honor, I just had one. I didn't know if I needed to announce or if I just needed for Julio Araujo. Do we want to do that sometime this evening at 3?
Okay, what's going on with him?
We had a contested NTA back on December 13th, 14th, and we were just waiting on the results.
Okay, no, I'll get that to you. We don't need to.
Okay, after lunch.
Excuse for right now. Okay.
Yes, Your Honor.
All right. Let me look at the affidavit. Okay. Are you still there, Ms. Walters?
I am.
All right. Well, actually, hold on. I got 2 copies of this Antonio Guerra affidavit. Let's see if I can open this one.
I sent one too, Judge.
Oh, I can open this one. Never mind. Actually, Ms. Walters is the one I think I opened, but one of them would not open. All right. So if it's all blank, am I to assume that there are zeros in there?
Yeah, it's zeros. Apparently he's been in custody for 4 years, and so he won't have anything.
Not on this case, I hope.
I don't know the situation. That's just something Roland sent me in the email when he sent that, when he forwarded it.
Okay.
This case is 900 days old.
This is one of the cases that's on the add-on docket, right?
Yes.
All right, let me load this or post this. I wouldn't typically send a financial statement to everyone in chat, but it has no numbers on it, so it's nothing confidential there. All right, I've sent that back. I appointed TRLA. What else do we need to do before we take a break?
That's all, Judge, from us. Thank you.
Your Honor, I have a quick question on page 5. It's going to be the first case, Brandon Lee Brill.
Yes.
I know Ms. Pratt had asked a question earlier today about
whether he was in custody.
One, whether or not he's in custody, but two, whether or not she was the attorney. She had stated that I guess Mr. Brill's family may have said that another attorney, I think Eric Reynolds was the one that was hired on there. But I don't have any substitution of counsel or anything like that on our end.
Yes, no, she's the attorney until that substitution of counsel appears.
Okay, and I just wanted to make sure that you didn't have anything that would.
I haven't looked up in the district clerk's records, but no, I have nothing.
Okay.
Your Honor, and they may be a little confused because he had a misdemeanor case as well. That might be his attorney for the misdemeanor case.
Okay, that could be.
Somebody said he was in Wilson County Jail too. I'm not 100% on that, but that's what somebody posted in the chat.
Okay.
Okay.
All right. So is there anything else we need to do on the criminal side?
No, sir.
All right. And hopefully we've got everybody. Ms. Cavazos, I'll excuse you. We'll be back at, call it 12:45. And let me just go over the docket with criminal docket, make sure we have that. First case on the docket.
Judge?
Yes,
Is the Peter case the only one left?
I believe so.
Okay. I'll see you at 12:45.
All right. All right. Sandy Ayala, 2-8.
Yes, sir.
Roberts, 323.
Yes, sir.
Angel Pena is still here. Do we have anything, Mr. Briggs?
Yes, Judge, I've just posted to chat a reset to February 22nd.
222, okay.
May we be excused?
Yes, sir. The next
Thank
two,
you.
323, Tovar, 217. Page 2, 323 for everything. All right. Page 3, did Eva Mahia ever appear?
Yes, Your Honor. I've seen her, and Mr. Orta had also appeared. At
Yes,
least-
he was late.
I have a reset to 323, Judge.
Okay. And what reset date did we get on Esquivel?
I have 323.
I was in a breakout room, Judge. I'm not sure.
It is, it's on the chat.
On that one, we're just remaining on the docket. I think it's already set on 320.
Okay.
I didn't have anything for Frank Briones, Judge. What did you have for that one, please?
323.
323.
All right, Ryan Garcia.
The 323, Judge. It's the same as the first page.
Okay. Martinez, 323. Patricia Ann Davis, she appeared late at 323.
Yes.
All right, page 4. Let me get to it. Did Justin Whitaker ever appear? I've got a reset for 323, but I don't remember ever seeing him.
I have a check mark by him, Judge.
Your Honor, he appeared on the phone without video, but he.
All right, Kendall Hennett did not appear, but he's supposed to be getting us information that he's in the ER with diabetic issue.
Yes.
323. Martin?
Your Honor, I filed the dismissal in that case. The defendant is deceased.
Oh, okay. Has that already been signed?
I just recently filed that. I was notified by Lori that
Okay.
there was a recent obituary.
All right, and the rest of the page is 323?
Yes.
Brandon Lee Brill, did we ever track him down?
Supposedly he's in custody in Wilson County, Your Honor. I'd ask for a short reset to next week. If we could put him on the docket for next week, and I'll check with Wilson County and see if he's there. And if he is,
What day?
yes, Your Honor. 2/2, I think is the next. Yes, Your Honor, 2/2.
2/2, okay. De La Garza, 323.
Yes, Judge.
And Ryan Garcia, that's 323.
Yes, Judge.
All right. So that whole page is, the rest of the page after Brill is 323.
Yes.
Okay. And on the add-ons, Guerra, I have nothing. Oh, I just appointed the TRO represent him. What do you want? Do we have 2/17? Is that a date or some date for a first appearance?
Yes, Your Honor. Well, that's a jury docket call day. But Minu, you having a 2/17?
22?
Actually, so Kenny, can we just confer with you about it before we decide what to do? Are you coming back after lunch or no? Or maybe we can just break out, or I can break out with you real quick?
Yeah, that's fine. And then we can, if we're going to have a reset date, Judge, we can just post it in that.
Okay. All right, that's fine. And give me just a moment.
Thank you, Laurie.
I pointed out a breakout room 8.
Thanks,
Small
Lori.
room.
Can you include Ryan Boyer in there as well, please?
Yes, I can.
Thank you.
All right, any other announcements?
Judge, on the friendly suit, I just wanted to confirm that you were able to get my documents
Off.
over chat.
All right, I'm sorry, Mr. Borzowski, I had the speakers off. You were saying?
I was just confirming that you had been able to get the documents I forwarded via chat, the judgment, the report of guardian ad litem, and the affidavit of the next friend.
No, sir, I saw them. They were here. If you may recall, I came back a few minutes ago during the family law hearing and said that I had been blipped out of Zoom. And when you get blipped out of Zoom, anything that you haven't downloaded goes away. So if you want to email those or just wait until they show up in my judge's queue, I have to go pick a son up who's just been quarantined. So I've got to pack my stuff up and go pick him up and start conducting court from the house. So I'm going to call it,
What email address could I send it to, Judge?
but just to the coordinators is fine.
Coordinator. Okay.
All right. So I'll call it.
All right.
1:30 and
I'll do that.
be in recess till 1:30, and I'll be back live from my house at 1:30.
1:30. Okay, thank you, Judge.
Thank you, Judge.
Okay, I'm finally back. I knew how long it takes to check in and check your kid out. I did not factor in how long it would take to stand in line while a whole bunch of other people did that. I apologize for being late. Give me just a moment. All right, I've clicked on the, let me try Vincent and Elkins link, and I've also copied it and pasted it, and I can't get it to open up.
I can put it back into chat and see if that helps.
Thank you. Yeah, I tried it in Explorer as well as Chrome, and it's not opening it up. And it pops right up.
Your Honor, I'm also putting in the chat a chart that Ms. Whittle is probably going to refer to during her argument today.
Okay, and all right, I'm at the house and not at the courthouse. So this is downloading very slowly. Let me go and make sure, let me get my son off the internet. He's probably playing video games. I'll be right back.
Lori. Yes. Judge Wilson?
Yes.
I just wanted to double check. I know that we went through almost all of the criminal docket. I think Arguijo is just the last thing that's set with Mr. Lambert.
Yes, y'all don't need to hang around.
Yes, Judge. All right. Thank you very much. Have a good one.
Okay. All right, well, let me try doing this again because my son was not on the internet at all. All right. Well, somebody try posting the 1A to me in chat. I know it's big, but I don't know if it's my internet connection, if it's Mr. Nelson's server.
I'm sorry?
I'll go to the clerk's office.
Okay.
Deliver these and then I'll go to lunch.
Okay.
Because it's just crawling. Still says 6 minutes left on the first thing I'm trying to download.
I can put it in chat.
And Your Honor, while Ms. Friel's doing that, last week, the Peelers and KMG were able to resolve a couple of their MSJs via Rule 11 agreements. So I have a proposed, an agreed motion and proposed order for those. So I can submit those in the chat while this is going on too.
Okay, excellent.
Your Honor, did you want all of the briefs or just the initial motion for the?
Well, let me see if I can get it downloaded first of all and see if it's going to come across any faster than the ones that I'm trying to get from Benson and Elkins.
Judge, do we know if anyone is still at the county jail? Mr. Guerra?
If they're not online, I don't expect them online.
They're still on there, Judge.
Okay. All right. I've got this minimized. Okay, JL, is anybody there?
Yes, sir.
Okay, what do you need, a breakout room?
Yes, Judge, breakout room.
I'll take care of that.
Thank you.
Actually, if you can make me host, Judge, I'm not the host any longer.
No, it's anything that was making it worse, so.
Philip Lambert and Adriana Biggs, I assigned y'all to breakout room 2 along with the Atascosa County Jail. Is that what you needed?
I don't think Miss Biggs needed me.
Oh, okay.
I'm here for Julio Araguijo.
He's in jail though?
He is in jail, yes. Okay.
Okay.
All right, ladies and gentlemen.
I need jail. I need jail if possible.
Mr. Boyer with Julio Arguijo, or who do you need?
With Tony Guerra add-on.
Oh, Guerra, okay. Philip Lambert's in there, so I'm gonna add you in there and then you can ask Mr. Lambert to get out, okay?
Okay.
All right, it has now downloaded 1C because that was the one on top. That was 7 megs. It took the number of minutes y'all just watched. There's more than 50 megs in the additional documents.
Your Honor, I'm attempting to compress the Peeler's motion to try to get it smaller, and I will, if I'm able to, it's still working on it, but if I'm able to, I will post the compressed version to chat. It's down to 7 megabytes now.
All right. Okay, that's good. You can't usually compress a PDF that much, I don't think. You didn't used to be able to. All right, in the meantime, I'm going to sign off and I will come back in. I want to see if it makes any difference if I'm not using bandwidth for Zoom. I don't know where the issue is. I assume it's on my end because it was slow downloading it across Zoom too. So I shall be back. Let me see if it makes a difference. No difference at all. Mr. Carruth, if you will repost those documents to me, I didn't download them before I exited.
I just submitted those in chat. I was going to be e-filing them right now, but I'm assuming to have some trouble with the e-filing system, but I'll put them on e-file this afternoon too.
Okay. Okay, in the Peeler's 1A motion, it says that 10 hours left.
Your Honor, were you able to download it from chat, the 7 megabyte version? Or would you like me to put that smaller version on the box link?
No, put it back to me in chat.
Okay.
Please.
We're
I don't
gonna
think much. Go ahead.
we're gonna try to compress our response as well, but I don't think it's quite as long.
Okay, the opening motion should be in chat now. And then it sounded like, Your Honor, you were able to download the reply. Is that correct? 1C?
Sure, I think that was it because that was the first one. Let me see. Yes. Okay.
I can also send you the brief without the exhibits.
That might work. I'm not able to download Mr. Karud's documents at this time. It says network disconnect. I mean, we watch TV here on 3 different televisions at the same time, so I usually have pretty good internet. I don't know if there's problems in the area or what.
All right, I've posted it without the exhibits, Your Honor.
Miss Riley, I'm done in the jail. Thank you.
Thank you, Mr. Lambert.
All right. I'm going to pause the 1A. It now says 7 hours left and went down to less than 10 minutes. And this is actually working. Okay, finally. I have the motion without exhibits, the response without exhibits, and I believe the reply. Yes. All right, so
Right.
go ahead.
Would you like us to repost the chart as well, Your Honor?
Yes. Right, Mr. Carruth, it's not allowing me to download the first agreed order on joint and several. That's the one that timed out, but I downloaded the second one and
I can try, Grand, Your Honor. I'll add the chart. Oh, Ms. Whittle added the chart. I'll add in the motion. And did you say you already got the order that went with it?
I received the second one on the, well, you sent two, right?
Well, there's a motion, there's an agreed motion and an agreed order that went with it. So,
okay, I must have gotten an order then. If it's agreed, I'll sign it without seeing the motion because there was a signature block on.
okay.
All right. So after all this, are we ready to start?
Yes, Your Honor.
Judge, I don't mean to interrupt, but I'm only going to download whatever you put on there.
That's fine. I just sent the agreed order to everyone so they have a chance.
Okay. I just want to make sure that I don't miss or that I don't download something I'm supposed to, but thank you.
All right, go ahead now.
Okay, I'm going to start my presentation. Okay. All right, Your Honor, San Miguel initiated this lawsuit when it sued the Peelers, claiming, number one, the right to a declaratory judgment that San Miguel has ongoing rights to unfettered use of the Peeler lease premises. Number two, a permanent injunction barring the Peelers from impeding San Miguel's use of the Peeler lease premises. And number three, breach of contract. Discovery is closed, and based on the evidence in the record, San Miguel cannot establish any of its claims as a matter of law. Your Honor, this is a table with San Miguel's causes of action against the Peelers and a short statement of why we believe the court should rule in the Peelers' favor as a matter of law on each of them. This chart is also available on that box link, and we've placed it in chat for you as well. On June 20th, 2018, the Peelers notified San Miguel by letter that they would no longer accept any further delay rental payments purporting to extend the mineral lease, and that the lease term had ended. The mineral lease granted a right to explore and produce lignite coal. San Miguel ceased producing lignite from the Peeler Ranch in January 2004, and the last royalty payment pursuant to the mineral lease was paid by San Miguel to the Peelers in February 2005. On August 10th, 2018, Counsel for Peelers sent Counsel for San Miguel a letter restating the Peelers' position that the mineral lease term had ended many years prior, and that San Miguel's status as a periodic tenant or bare licensee would end on August 14th, 2018. The letter also informed San Miguel that the Peelers intended to begin a thorough site investigation of the contamination caused by the mine and the plant operations, starting August 20th, 2018. The Peelers never threatened to lock San Miguel out of the plant or the buffer zone lease acreage, which were not mentioned in the letter at all. The Peelers also never threatened to block access to San Miguel's water wells or to any recorded easement, such as the dragline easement. And the letter expressly recognized the ongoing easement to use the Hall Road and any other roads for ingress or egress for which rentals are paid. San Miguel sued the Peelers almost immediately without attempting to confer, despite the express invitation to discuss by phone. The Peelers are entitled to summary judgment dismissing each of San Miguel's claims. The mineral lease terminated under its own habendum clause when mining ended in 2004, and San Miguel has no evidence demonstrating any right to a declaration that would extend its former mining rights into perpetuity, or grant San Miguel new rights that were never included in the mineral lease or any other agreement. San Miguel cannot establish the right to injunctive relief because it cannot prove any of the 4 required elements. Number 1, a wrongful act. Number 2, imminent harm. Number 3, an irreparable injury. Or number 4, the absence of an adequate remedy at law. As to element 1, wrongful act, there is nothing wrongful about the peelers accurately informing San Miguel through counsel that the mineral lease had terminated and setting an end date to San Miguel's possession of the premises as a periodic tenant or bare licensee. As San Miguel's general manager admitted, the peelers never threatened to impede San Miguel's access to any land or facilities other than the mineral lease premises. And San Miguel maintains separate easements for the facilities it claims it needs to run the plant, including its 4 water wells, the dragline erection site, the 64 kilovolt transmission line for the dragline walkway path, and the haul road. And the Reclamation and Surveying Office is located on one of the 1-acre tracts San Miguel owns under the separate water well deed and easement. I will show you a map shortly that shows where all of those facilities are located, and San Miguel provided with its application for temporary restraining order all of the separate deeds and easements for those facilities, so they are in the record. At no time was San Miguel being denied access to those, and San Miguel has offered no evidence that it was. San Miguel's misplaced or overwrought fear is not a basis for concluding that the peelers engaged in a wrongful act by sending a letter. San Miguel never picked up the phone to confer and simply fired off a lawsuit. And at the very first hearing in this case, I explained to the court that the peelers were not locking San Miguel out of any of those facilities. At the time, the court asked that we produce a chart at any subsequent hearing on a temporary injunction, listing the facilities and the peelers' position on lockout for each. That hearing never happened, but I have that chart today for the court and we'll go through it shortly. San Miguel cannot demonstrate elements 2 or 3 for injunctive relief, imminent harm and irreparable injury from loss of the mineral lease premises because, number 1, the mineral lease premises were mined to exhaustion over a decade ago. Number 2, San Miguel does not need the mineral lease premises to keep the plant in operation. Number 3, the court cannot conclude based on the record evidence that terminating San Miguel's possession of the peeler lease premises would cause rolling blackouts in the state of Texas. And number 4, to the extent loss of the mineral lease premises impedes San Miguel's regulatory compliance, any injury to San Miguel is attributable not to the peelers, but instead to San Miguel's unilateral decision to delay reclamation. San Miguel's own testimony confirms reclamation can be completed in much less time than has elapsed since mining ended on the Peeler Ranch. Finally, San Miguel cannot demonstrate element 4 that damages would be inadequate to remedy any harm because the expense to buy replacement coal for the plant or to pay fines for regulatory violations are all easily monetizable. San Miguel also has no evidence that the peelers breached any contract. The record reflects no evidence or even any allegation that the peelers failed to perform all of their obligations under both the buffer zone lease and the mineral lease during the terms of those agreements. The peelers informing San Miguel that the mineral lease had already terminated is not a repudiation as a matter of law. And even if it were, San Miguel forfeited its rights to assert repudiation when it chose to treat the mineral lease as ongoing by suing to enforce purported ongoing contractual rights and maintaining possession of the leased premises. Finally, damages are an essential element of breach of contract. But San Miguel has never averred any damages sustained from any alleged peeler breach of contract. San Miguel dropped its breach of contract causes of action against the individual peelers and also admitted that it cannot maintain a claim of attorney's fees against the LLC, meaning there isn't even a claim for attorney's fees remaining. So now San Miguel is left to rely on a new claim for nominal damages only, $1. This is a new damages theory, not pled and not disclosed under the scheduling order. The first time we learned of this nominal damages assertion was 1 week ago when we received San Miguel's response to our motion. Texas law is clear that where nominal damages were not pled, the The fact that they are available for breach of contract does not create a fact issue on the essential element of damages on summary judgment. In addition, Your Honor, we ask the court to dismiss San Miguel's alternate plea and condemnation. San Miguel is pursuing condemnation of the very same property in separate proceedings, and a full special commissioner's hearing was had and awards were made. The property code and Texas law disfavors multiple condemnation proceedings for the same property. Your Honor, this is the declaratory judgment San Miguel is asking for. It is very broad. I've highlighted the language that is actually included in the granting clause of the mineral lease and bracketed words that are in the mineral lease but excluded from the declaratory judgment. San Miguel is asking for a declaratory judgment that expands on rights granted in the mineral lease, specifically unfettered access and use, including reclamation, monitoring and regulatory compliance activities, which are not found in the lease anywhere. San Miguel is also asking for additional mining rights that are not granted in the mineral lease and purports to add all minerals, even though the lease explicitly excluded oil and gas. And San Miguel is asking for the additional right to dispose of any and all coal combustion residuals, which is found nowhere in the mineral lease. In fact, the court has already implicitly denied this cause of action by granting the Peeler's motion for summary judgment regarding ash disposal rights. That by itself is sufficient to grant our motion for summary judgment on San Miguel's declaratory judgment cause of action. The Peeler's additional motion for summary judgment on the term of the mineral lease is currently pending before the court and was heard on June 5th. And the San Antonio Court of Appeals issued 2 decisions this summer that support our construction of the lease, one of which was affirmed in November, which I will show the court in a moment. The granting clause of the mineral lease sets forth San Miguel's rights to the property. The term of the mineral lease ended by operation of its habendum clause when the lignite was mined to exhaustion in 2004. San Miguel admits it has no plan to return to mine the Peeler Ranch lease areas because there is nothing more to mine. When the lease terminated, all of the granted rights to mine on the premises expired. This court already has held that the mining lease never allowed disposal of ash generated from lignite mined off premises or water production rights. San Miguel has no evidence supporting any right to a declaration that extends its former mining rights into perpetuity, nor can San Miguel demonstrate entitlement to new rights that were never included in the mineral lease or any other agreement. Any rights San Miguel retains at this point allow only restoration pursuant to San Miguel's unfinished lease obligations and easements for access to adjoining properties, which is the only lessee right which expressly survives the lease's termination. Other than the expired mineral lease, all of San Miguel's purported support for a declaratory judgment are based on facilities that are not relevant to any actual dispute. The Peelers never threatened to deny access to San Miguel's water wells, the plant, the power line, the drag line, or the roads for which San Miguel maintains an easement. I explained that to the court at the very first hearing in this case when San Miguel complained it was being denied access to certain facilities for which it maintains separate easements. Because San Miguel's rights under these other deeds and agreements are not disputed, any declaratory judgment regarding them would be an impermissible advisory opinion. Notably, the requested declaratory judgment doesn't say anything about those facilities, the water wells, the plants, or the power line. And we all agree that San Miguel maintains access to the roads for ingress and egress for which it pays rentals, even after the term of the lease expires. So the supposed harm that requires the declaratory judgment isn't tied to the requested language in the judgment at all. Because San Miguel has no evidence that it is entitled to its requested declaratory judgment, the court should grant summary judgment in favor of the Peelers and dismiss San Miguel's first cause of action. This, Your Honor, is the actual granting clause in the mineral lease. And I just asked the court to compare the granting clause at paragraph 2 of the mineral lease to what San Miguel is asking the court to declare in the declaratory judgment. They're asking the court to expand on rights that never existed under the lease. Your Honor, it is black letter law in Texas that a lease's habendum clause defines the mineral estate's duration. And if the habendum clause ceases to be satisfied, the lease terminates automatically unless rescued by a savings clause such as a shut-in, gas well clause, drilling operations clause, or continuous operations clause. The Peeler's motion for summary judgment on the term of the mineral lease presents the court with a single straightforward question of law. Can the lessee sustain the Peeler mining lease by making annual rental payments after the lease premises minerals are mined to exhaustion? The Peeler's prior briefing and oral argument demonstrate that the answer is no. The lease terminated as a matter of law when lignite production ceased because, by the lease's own terms and under Texas common law, the only payments which can hold the lease absent production are delay rentals that cannot be made after mineral production is established. San Miguel has never provided any Texas law or language from the parties' agreements supporting its novel claim that a mineral estate rental payments may be resurrected to hold the lease after all of the leased premises minerals are exhausted. Instead, San Miguel introduced diversionary arguments, including proposing that the rentals provided for in the original 1953 lease are in fact something other than delay rentals as understood by Texas law. They also argued the lease was held by some different type of rental payments added in later lease amendments. And they argued rather than the plain language in the lease defining the lease's duration, its habendum clause determining when the lease terminates, the lessee is somehow able to perpetuate the lease indefinitely so long as it has mining-related activities to perform. But two separate Fourth Court of Appeals decisions interpreting a lease materially identical to the Peelers definitively identify the rentals which can maintain the lease absent production as delay rentals. Both cases involve San Miguel and the Wheeler lease, that's WHEELER, which is substantially identical to the Peeler lease and signed in the same time frame with the same habendum clause and same delay rental provision. So the Fourth Circuit has held definitively that the payments which can sustain the lease are the standard delay rentals under Texas law. Further, in sworn testimony, San Miguel's corporate representative expressly clarified that the $2 per acre annual payments, the rentals defined in the original 1953 lease, are the exclusive rentals which San Miguel asserts held the lease after production, meaning San Miguel has disavowed its counsel's prior claims that some later added type of rental held the lease. And the Fourth Court of Appeals, again interpreting a lease materially identical to the Peelers, confirmed that the plain text of the lease, specifically its habendum clause, defines the lease's duration, and that the habendum clause's meaning is properly interpreted as a matter of law. That holding rebuts San Miguel's claims that some special feature of a no-term lease allows the lease to survive so long as San Miguel continues mining-related activities or still has reclamation regulatory obligations to perform. San Miguel's counsel argued the rental provision is not a rental provision. He stated at the hearing, nor interestingly, Your Honor, does the word delay appear at all in the lease. There is no use of a delay rental in the agreement between these parties. But the Fourth Court of Appeals has flatly rejected this interpretation twice when considering a lease materially identical to the Peelers in two related lawsuits, both involving San Miguel. Both times, the Fourth Court of Appeals unequivocally confirmed that the rentals the Peeler habendum clause requires to sustain the lease absent production are delay rentals. The Fourth Court's decisive interpretation of the lease language disposes of San Miguel's position and mandates a ruling for the Peelers on both the motion for summary judgment and all of San Miguel's causes of action against the Peelers. The dispositive Fourth Court of Appeals opinions both address the Wheeler lease, whose habendum clause is word for word identical to the Peelers, and whose rental provision is materially identical. Executed in 1954, the Wheeler lease is one of several similar leases covering land located in Atascosa and McMullen counties, entered into at approximately the same time as the 1953 Peeler lease. San Miguel is the successor in interest to the lessee under both the Wheeler and Peeler leases. The key difference between the Peeler and Wheeler cases is that, unlike on the Peeler Ranch, mining on the Wheeler premises has not yet begun. The Wheeler lease has been held exclusively by payment of delay rentals since the lease's inception in 1954. In Wheeler, the current lessor challenged San Miguel's rights to continue to hold the Wheeler lease on various grounds, including alleging that rentals had not been properly paid and that San Miguel had forfeited the lease by waiting an unreasonable amount of time to develop the lease. In the Fourth Court's other recent decision interpreting the Wheeler lease, DCP, San Miguel challenged the presence of a pipeline installed across the Wheeler lease premises pursuant to an easement granted to the pipeline operator jointly by the lessors and the surface estate owner. Though neither case presented the question of resuming rental payments post-production, in each opinion, the Fourth Court of Appeals left no doubt that the rentals referred to in the Habendum Clause must be understood as delay rentals. Each case was heard by a separate set of justices, but throughout both opinions, each Fourth Court panel consistently named the payments that could sustain the lease not just as rentals, but specifically as delay rentals. The Wheeler opinion used the term delay rentals 21 times to describe the only payments which could sustain the lease absent production. DCP referred specifically to delay rentals each of the 5 times its discussion mentioned rental payments. The Fourth Court of Appeals left no room for argument. The only rentals which can sustain the Peeler lease are delay rentals. San Miguel's arguments to the contrary must fail, and according to established Texas law, there was no production left to delay once the Peeler Ranch was mined out 16 years ago, and thus no payments could hold the lease thereafter. Because the Fourth Court confirmed that the rentals referenced in the Peeler lease's Habendum Clause unequivocally are delay rentals, they cannot be resumed post-production, and the Peeler lease must have terminated at the end of production in 2004. The Fourth Court of Appeals in Wheeler also squarely rejected San Miguel's attempt to distinguish no-term leases from established Texas mineral law. Interpreting a lease materially identical to the Peeler lease, the Fourth Court directly held that the plain language of the lease's express provisions addressing duration, specifically the Habendum Clause, determines when the lease expires as a matter of law. So, Your Honor, the Peeler mineral lease term ended when production ceased, and that is because, number one, any failure to continuously satisfy the terms of the lease's Habendum Clause automatically terminate the lease. Number two, the Habendum Clause requires either production or payment of the rentals hereinafter provided for at all times. Number three, the parties now agree that the only payments that might satisfy the Habendum Clause absent production are the rentals detailed in the original 1953 lease. Number four, the Fourth Court has confirmed that these are delay rentals. Number five, the Fourth Court has confirmed that the standard Texas mineral law applies to determine the duration of the Peeler lease. And number six, under settled Texas law, delay rentals can be made only before production is established. San Miguel's additional argument that the Peelers waived their right to terminate the lease should be rejected. A 2019 Texas Court of Appeals case squarely established that a landlord who accepted tendered rental payments after the natural end of a lease does not waive the right to later claim that the lease ended. In Subsea 7 Port Isabel versus Port Isabel Logistical Offshore Terminal at 593 Southwest 3rd, 859, the Corpus Christi Court of Appeals considered a case where a tenant submitted a lease renewal request after the contractual deadline to renew. So the lease expired under its own terms. The landlord did not notify the tenant that its request to renew had been rejected and continued to accept the tenant's tendered rent. Nevertheless, the Court of Appeals held that the landlord had not waived its right to later assert that the lease had terminated. because the landlord's acceptance of payments was consistent with the tenant having become a holdover tenant and thus did not establish that the lease had been renewed. There's no material distinction between sub C7 and the Peelers case. The Peelers' acceptance of San Miguel's tendered $2 per acre annual payments from 2004 through 2017 is perfectly consistent with San Miguel having become a licensee or holdover tenant in 2004 when mining ceased. The acceptance of payments cannot establish that the Peelers have waived any rights regarding termination of the lease. Sub C7's holding that there can be no waiver of lease termination when the landlord's actions are consistent both with the former tenant's status as a holdover or a licensee and with the extension of the lease is far from novel. It is black letter law that to establish waiver by conduct, that conduct must be unequivocally inconsistent with claiming a known right. Because all of the Peelers' actions were consistent with allowing San Miguel to remain on the premises under an at-will relationship, rather than extending the lease, Texas law does not allow the conclusion that by accepting San Miguel's annual payments from 2004 to 2017, the Peelers waive their right to assert that the lease terminated under its own terms in 2004. Remarkably, in response to our motion, San Miguel has revived a claim it previously denied to the court. San Miguel's original petition also sought a temporary restraining order on the basis that the Peelers purportedly had committed 2 purported violations of San Miguel's rights, one of which was the Peelers' notification to the water district that San Miguel did not have water rights for which did not have water rights for the land subject to the mineral lease. The court issued this requested TRO. The Peelers filed their motion for partial summary judgment as to water production and related communication rights on January 10th, 2020. That motion specifically sought a declaratory judgment regarding San Miguel's water production rights under the mineral lease, arguing that the unambiguous language of the Second Amendment of the mineral lease conclusively bars San Miguel from claiming any such rights absent written consent, which was never granted as to the leased land. The motion also sought a declaratory judgment as to the Peelers' rights to communicate with the Evergreen Underground Water Conservation District. The court granted the Peelers' summary judgment motion on its first issue. With regard to the Peelers' communication rights under the lease, the court formally denied the Peelers' motion for partial summary judgment on this point, but importantly, expressly ruled that, quote, to the extent, if any Peeler parties are presently enjoined or restrained by written order of this court from communicating with anyone about any matter, save pursuant to a protective order, such injunction or restraint is lifted. This ruling is critical because the court previously had granted San Miguel a TRO based in part on San Miguel's allegations that the Peelers had wrongfully communicated with the water district. In light of San Miguel's allegations and the ongoing TRO, the Peelers' motion was necessary to secure the court's judgment declaring that the Peelers in fact are not enjoined from communicating with the underground water district. At the time, counsel for San Miguel argued we were asking for an advisory opinion because San Miguel wasn't basing any claims on the Peelers' communications with the water district. And I'll just point out some of the argument, Your Honor. Counsel for San Miguel argued, and San Miguel is not asking for a fact finder to find that the Peelers have not violated and would not in the future violate any contractual obligation by communicating freely with the water district. It's simply not a controversy in this lawsuit that will be taken to the fact finder. And again, with regard to the mineral lease, everyone agrees we're getting water from those 1 acre tracts. That is certainly undisputed and nothing will change except perhaps for them using the court's order as ammunition in the water district board if there was a declaratory judgment saying the mineral lease somehow has some other provision that no one is arguing about. And then several times during the hearing, counsel for San Miguel claimed that we were laying a trap. This whole thing feels like a trap, she said. Are the peelers asking for this court to enter some kind of declaratory judgment so they can run to the water board? Maybe, I don't know. But what I do know is this isn't a controversy in this lawsuit. Everyone agrees that the water is coming from those 1 acre tracts, and this whole idea about communications with the water district is just simply something that the peelers are taking factual assertions and our complaints about that lockout letter and turning it into a cause of action which isn't there. There are a lot of real issues in this lawsuit. But now, Your Honor, San Miguel has reversed course. In its response to our motion, San Miguel argued with respect to the declaratory judgment. In particular, while the peelers now claim that they never threatened to deny San Miguel access to its water wells, the lockout letter takes the position that San Miguel's lack of control over the leasehold acreage, quote, may impact San Miguel's groundwater production rights. Given that San Miguel needs groundwater to produce power, this implied threat warrants the request for a judicial declaration that the peelers cannot, quote, impact those rights. So counsel previously claimed that our need for a declaratory judgment on the issue of the peelers' rights to communicate with the groundwater district was a trap, and that we were seeking an advisory opinion because the peelers' right to communicate with the underground water district was not in dispute. But in its response, San Miguel is saying something very different. And let's look at the actual lockout letter that purportedly threatens San Miguel's water rights. Your Honor, this is the paragraph here that's at issue. It says, please be aware that we have notified the Evergreen Underground Water Conservation District that as of August 15th, San Miguel no longer has legal control over the leasehold language, which may impact San Miguel's groundwater production rights. And it's, as we've explained to the court before, that's because your groundwater production rights are based on the number of acres that you own or lease. Now, it's worth noting that since the court issued the order that did away with any restraint on the peelers' communications rights, they have continued to communicate their concerns to the underground water district. And as far as I know, nothing has happened to San Miguel's ability to obtain all of its needed water. San Miguel certainly has not presented the court with any evidence to the contrary. So it's clear the peelers' communications with the underground water district have been lawful, are not wrongful, have not caused any harm to San Miguel, and cannot be the basis for the requested relief in this lawsuit. Moreover, the requested declaratory judgment does not say anything about water rights. Here, they're claiming they need a judicial declaration that the peelers cannot impact those water rights. But Your Honor, the requested declaratory judgment says nothing about water rights at all. So for all these reasons, the court should grant summary judgment in favor of the peelers on San Miguel's first cause of action for declaratory judgment, and San Miguel should take nothing. San Miguel's second cause of action for injunctive relief requests that the court enjoin the peelers, their family members, agents, servants, employees, representatives, and all other persons or entities in active concert or participation with them, including the Atascosa County Sheriff's Office, from refusing to allow San Miguel and its representatives, agents, employees, invitees, contractors, and subcontractors to use the peeler lease premises for the purposes of coal and lignite exploration, development, drilling, mining, production, reclamation, and related activities, interfering or attempting to interfere with the free and uninterrupted use of or access to the peeler lease premises by San Miguel, placing or attempting to place any gates or obstructions upon the peeler lease premises which would interfere with San Miguel and its invitees' access, and placing or attempting to place any locks or obstructions upon the gates on the peeler lease premises. And I'll just note, this is a very broad request for injunction that would also increase the rights that San Miguel has under the peeler mineral lease. But San Miguel cannot meet the test for injunctive relief. To be entitled to a permanent injunction, a party must prove a wrongful act, imminent harm, an irreparable injury, and the absence of an adequate remedy at law. San Miguel bears the burden to prove each of these elements. Discovery is closed, and based on the evidence in the record, San Miguel cannot establish any of the elements for the test of permanent injunction as a matter of law. I will start with wrongful conduct. In its response, San Miguel claims the wrongful act was the peeler's attempt to unilaterally terminate the mineral lease and threaten criminal liability. A threatened lockout from leased premises which San Miguel no longer had a lawful right to possess is not a wrongful act. And any criminal acts that open San Miguel to criminal liability would be entirely its own and cannot be attributed to the peeler's determination that San Miguel's term as a periodic tenant or bear licensee was over as of August 14th, 2018. Moreover, the harm that San Miguel identifies is a threatened lack of access to facilities for which San Miguel had other specific easements like water wells, the dragline erection site, the dragline power line, and roads for ingress or egress for which San Miguel paid rentals like the Hall Road. The peelers never threatened to impede San Miguel's access to any land or facilities other than the mineral lease premises. And the peelers never repudiated any easement that they had previously granted San Miguel. San Miguel has put forward no evidence that any such repudiation ever occurred. Next, imminent harm. The imminent harm San Miguel asserts is the possibility of rolling blackouts in the state of Texas. But San Miguel has no evidence for this assertion. The court excluded San Miguel's expert, Kenneth Donahue, and his opinions on grid reliability. So this is a completely unsupported assertion. In fact, San Miguel has put forward no evidence that San Miguel needs the mineral lease premises to keep the plant in operation. It already has all the easements it needs for the facilities it has identified as necessary for the plant. And I'll go through those now, Your Honor. So these are the easements, or these are the facilities that San Miguel claims it needs. The 69 kilovolt power line for the drag line, for which they have an easement, which is recorded in Atascosa County, and that was provided at record. It's exhibit number, or exhibit letter I to the Kazar affidavit, which was attached to San Miguel's petition and application for temporary restraining order. The 5 water wells, these are 1 acre sites where San Miguel has drilled water wells and for which they have a deed and easement for those water well sites. Again, that is attached at Exhibit J to the Kazar affidavit in San Miguel's original petition. The dragline erection site, that is also recorded of record, and they have an explicit easement for that. That was attached as Exhibit K to the Kazar affidavit to the petition and TRO request. And then the dragline walkway path, there does not appear to be any easement for this. And based on Mr. Burris's testimony, he's San Miguel's current fuels manager, it appears that the dragline walkway path is actually located on the Harrison Ranch, and I'll go through that. But he also testified that it's not needed until 2026 or 2027, which is clearly not imminent. And furthermore, if this is an ingress or egress for which San Miguel needs, they can pay rentals under the mineral lease for access to that area. The Reclamation and Surveying Office, again, Mr. Burris testified that that is completely located on the site of water well number 4. And so that is something that San Miguel has an easement to access and owns the property. So the end of the mineral lease term and lockout would not block access to any of these facilities because they already have easements for each of these, or the need is something they could pay rentals for and wouldn't, it certainly isn't imminent. Here, Your Honor, one of the exhibits, which is attached to the reply, and I will zoom in areas in next slides, shows where the easements are
Honor.
actually located.
Your Honor, we're going to object to this exhibit. It wasn't produced 21 days before today's hearing. And sorry to interrupt, but it is not competent summary judgment evidence.
Actually, Your Honor, it was produced with Mary Sitton's expert report and part of her disclosures. And because San Miguel alleged in its response that it doesn't have access to these facilities, but provided no locations for them, we're just trying to provide, Your Honor, a notice of where these locations actually are based on the recorded deeds.
Council could have reset this hearing for 20 days, 1 day out. We got this yesterday afternoon. It was not part of the original motion. We continue to object to its use.
Well, Your Honor, I think it's San Miguel's burden to prove that these facilities are actually something that they can't access, and
I'll sustain the objection. Go ahead, ma'am.
Okay, so I'm just gonna, I have to skip through the next 2 slides since you sustained the objection, so I'll just pass through those. So, Your Honor, Mr. Burris testified that the dragline walkway is shown on Exhibit 139, which is a part of their permit. And he also testified that they don't need that dragline until 2026, 2027, which is obviously not imminent. And San Miguel has provided no evidence that this is actually on the Pila Ranch. Their Exhibit 139 shows the dragline walkway here, Your Honor, which is off the Pila Ranch. For demonstrative purposes, I'll compare, Your Honor. This is the floodway easement, which is on the Pila Ranch. And this yellow line here is the Pila Ranch boundary. That runs approximately here, and the dragline walkway is here on the Harrison property. So the evidence in the record shows that this is actually not even located on the Pila Ranch. Continuing with the imminent harm prong, San Miguel's general manager has confirmed that the peelers never threatened to block access to the buffer zone premises or the plant. The peeler premises do not fuel the plant because they were mined out in 2004, and the mine permit does not require reclamation of the peeler premises until after the plant is scheduled to be closed in 2037. So a failure to reclaim the peeler premises could not jeopardize San Miguel's ability to mine until after the plant is scheduled to close anyway. Furthermore, San Miguel's mining permit is not necessary to keep the plant operating. Instead of doing its own mining, San Miguel could purchase coal to fire the plant. Because San Miguel does not have to mine its own coal to provide electricity to the Texas grid, there is no causal connection between a purported threat to San Miguel's ability to mine and any impact on the Texas power grid. Finally, even if the plant ceased operation, the court cannot conclude based on the record evidence that rolling blackouts would result. Even if it were true that the plant cannot keep operating without access to the peeler premises, the peeler expert, Bob Fagan, testified that, quote, closure of the San Miguel plant would not present a risk of reliability of the Texas grid. He further testified that, quote, transmission security is not a problem if the San Miguel coal mine was to be offline. As Mr. Fagan explained, quote, whether or not San Miguel operates at a higher average annual capacity factor as a traditional baseload resource might be, or whether or not it operates as a lower average annual capacity factor as more of an intermediate resource or even a peaking resource, regardless, it's not necessary to keep the system reliable. The court cannot accept San Miguel's entirely unsupported declaration that taking the plant out of operation would cause imminent rolling blackouts in the face of analyses demonstrating that the plant is not necessary to support the Texas power grid. San Miguel also argues that it faces imminent harm because if it cannot maintain possession of the peeler mineral lease premises indefinitely, then San Miguel will be unable to comply with ongoing regulatory obligations related to unfinished reclamation on the premises. First, San Miguel has not provided any evidence to suggest it has a right to extend its possession of the premises based on its own unfulfilled regulatory obligations. Being denied possession of land to which one has no legal right is not a legally cognizable harm. Second, San Miguel's own testimony establishes that it has already had more than sufficient time to complete reclamation and permanently discharge its associated regulatory duties. So the only reason that San Miguel still has regulatory obligations on the Peeler premises is San Miguel's own unilateral delay in completing reclamation because it wanted to use the Peeler Ranch for coal ash disposal. Moreover, San Miguel admits that it's unlikely their mine permit would be jeopardized. Its corporate representative testified, quote, "I don't know if taking away a permit away from somebody is really a mechanism they would employ or threaten to employ," end quote. Indeed, San Miguel sought to seize the Peeler premises through condemnation proceedings, another remedy at law. If loss of access to the Peeler premises genuinely posed San Miguel imminent harm, San Miguel could protect itself by depositing $38 million in the court registry, but it has not. San Miguel cannot effect an end run around the requirement to compensate the Peelers for taking their property by securing an injunction from this court based on a purported need to use the land to avoid regulatory violations. As a matter of law, San Miguel is unable to meet its burden to establish imminent harm from the Peeler's threat to exclude San Miguel from the Peeler mineral lease premises. Turning to irreparable injury, San Miguel offers no evidence that loss of access to the mineral lease premises would cause irreparable injury. There is no lignite left to mine on the premises. This court has ruled that San Miguel is not entitled to use the premises to dispose of the plant's waste. And to the extent loss of the Peeler premises impedes San Miguel's regulatory compliance, any injury to San Miguel is attributable to its own delay, not the Peelers. Finally, San Miguel's claim that loss of access to the premises jeopardizes its mine permit, which thereby will cause the plant to close, and then rolling blackouts in the state of Texas also is unfounded. San Miguel's permit allows more than 35 years after final coal removal to achieve final grade on the Peeler Ranch, which is after the plant is set to close. So loss of access to the Peeler premises cannot threaten the plant's operation or reliability of the Texas grid. But even if it did, San Miguel could keep the plant in operation by purchasing coal instead of mining its own, which arguably would be less expensive than its current efforts to generate fuel. That is a commonplace solution, and there is no reason San Miguel could not purchase coal to run the plant. Thus, San Miguel cannot demonstrate irreparable harm from losing access to the Peeler mineral lease premises as a matter of law. Finally, San Miguel cannot establish that damages are inadequate to remedy any harm from loss of access to the Peeler mineral lease premises. Even if San Miguel could establish that the Peelers' threatened lockout would cause San Miguel to lose access to fuel needed to generate power, it has an adequate legal remedy. Monetary damages would compensate San Miguel for any additional cost of purchasing fuel instead of mining lignite itself. Similarly, any fines or other expenses related to the regulatory violations San Miguel alleges would result from its loss of the Peeler mineral lease premises, if determined to be due to a wrongful lockout by the Peelers, could be remedied with monetary damages. The fact that San Miguel has not attempted to identify any monetary damages as a result of the threatened lockout does not mean damages could not be calculated. San Miguel's response argues that the damages suffered include potential individual criminal penalties for San Miguel personnel should there be a dispute about the specifics of access going forward, and reputational harm from regulatory violations. Let's look at those two purported harms for which damages would be an inadequate remedy. This is the testimony that San Miguel attached from Mr. Peeler's deposition. The question was, did you intend to inform the sheriff if they went on the property? Answer, I didn't. Yes and no. Question, why yes and no? Answer, all right, I called the sheriff, I did, and he sat down and talked to me. I said, David, I said, nothing going on, but if anything goes on, anything happens, you'll know what it is and you can act accordingly. But I don't know. Question, and you said, David, what is the sheriff's name? Answer, David Soward. Question, is he a friend of yours? Answer, yes. Question, did you understand the sheriff was ready to go out there? Answer, I didn't time to come to perform a duty, or so to speak, but I was just informing him that there may be a problem. Your Honor, Mr. Peeler's conversation cannot serve as the basis for the alleged harm because no San Miguel personnel would face criminal penalties for lawful acts. And if San Miguel's employees were breaking the law, any irreparable harm would be attributable to their own law breaking, not to any action on Mr. Peeler's part. Unless San Miguel provides evidence that Mr. Peeler somehow illicitly gained control over Atascosa County's entire criminal justice system, San Miguel's employees can easily avoid the risk of criminal penalties simply by refraining from committing any crimes. Mr. Peeler himself did not take any action, nor did he ask the sheriff to take any action against San Miguel. All he did was inform the sheriff that the parties disagreed about the right to possession of some of his property, and that the possibility existed that a problem might arise between San Miguel and the Peelers at some point in the future. Nothing in this testimony comes close to establishing that the Peelers committed a wrongful act that threatened imminent irreparable harm to San Miguel. San Miguel's only other theory of non-monetizable harm also fails because San Miguel offered no evidence that any possible regulatory violations, should they even come to pass, would damage its reputation. Instead, the response contains nothing more than the unfounded speculation, which is insufficient to survive summary judgment. Furthermore, testimony from San Miguel's own staff establishes that San Miguel already has a long history of such violations, belying the claim that any further regulatory action could threaten harm to its reputation. San Miguel's fuels manager at page 186 of his deposition testified that the Railroad Commission has issued notices of violation to San Miguel. He says, historically, I'm sure there's been a few. He couldn't tell me specifically what they were. And he'd seen a few related to the Peeler property. He also states that typically the Railroad Commission identifies an area that we're in violation and they give us a deadline to complete some type of corrective action. And then once the corrective action is completed, they then assess a penalty and then it's closed. San Miguel's general manager testified that TCQ had brought enforcement actions against San Miguel. And he discusses what it took to resolve those. One, it took a while, and many years. An action for discharge in 2015 wasn't resolved until 2017. When asked how many air emissions violations has San Miguel had in the time you've been at the plant, he said, a lot.
Your Honor, I'm going to object that the air violations have nothing to do with this lawsuit and ask that we move on.
Okay, are you alleging reputation damages?
Yes, Your Honor. But for impact on the mine, not on the plant.
Well, but I can see where that would be evidence in whether there is a reputation damage, but is that a no evidence point?
Your Honor, their argument is that the Peelers lockout letter caused them irreparable harm, and that that an injunction should issue because there is no adequate remedy at law. And their basis for arguing there's no adequate remedy at law is that they might suffer a regulatory violation, which then might cause them reputational harm. And my point is that they've had many regulatory violations for various matters, including their railroad commission permit, their discharge permit, and air violations, which belie any argument that this reputational harm is really something that would be that would lead to a need for an injunction.
I'll sustain the objection. Go ahead.
So, Your Honor, Mr. Kazar also testified that the Railroad Commission permit violations are in fact monetizable. And he explains how the Railroad Commission determines those payments that have to be made. He testified that he recalled that there were between 5 and 10 notices of violation issued by the Railroad Commission, and that they equate to a monetary value for the permit violation based on a table that the Railroad Commission keeps. So because San Miguel is unable to demonstrate the elements to establish a cause of action for injunctive relief as a matter of law, the court should grant summary judgment in favor of the peelers and dismiss San Miguel's cause of action for a permanent injunction. The court should also lift the current temporary restraining order. Your Honor, San Miguel's third cause of action is for breach of contract, and that is only asserted against AM Peeler Ranch LLC. The elements of breach of contract are the existence of a valid contract, performance or tender performance by the plaintiff, breach of the contract by the defendant, and damages sustained by the plaintiff as a result of the breach. The petition claims that AM Peeler Ranch LLC wrongfully attempted to and unilaterally and summarily repudiate and terminate the Peeler lease. San Miguel relies on the letter from Peeler Council dated August 10th, 2018, which asserted that the 1953 mineral lease had ended, but never mentions the buffer zone lease at all. San Miguel alleges that this letter constituted a material breach and repudiation of the express terms of the Peeler lease and the various other agreements. And San Miguel also claims that the letter proximately caused San Miguel injuries that have and will result in actual damage and loss to San Miguel, and that San Miguel is entitled to recover its actual, general, special, and consequential damages, as well as court costs and attorney's fees from and against defendant plaintiff AM Peeler Ranch LLC for breach of contract. San Miguel cannot demonstrate any damages sustained as a result of the August 10th, 2018 letter from Peeler Council to San Miguel Council. The court entered a TRO at San Miguel's request on August 14th, 2018, and San Miguel never has been denied access to any leased property. Nor, after 2.5 years of discovery, has San Miguel disclosed any economic damages sustained as a result of the August 10th, 2018 letter or otherwise. Just 1 week ago, in its response brief, San Miguel added a new unpled, undisclosed damages theory, nominal damages. This court may recall counsel for San Miguel's argument that deadlines must be followed and that the court should not allow new undisclosed damages theories. And yet, San Miguel at this late date is trying to rescue its breach of contract cause of action from summary judgment by adding a new unpled theory of damages. Your Honor, this is San Miguel's disclosure for damages. San Miguel is still determining the amount and method of calculating its economic damages. San Miguel reserves the right to amend or supplement this response if necessary in accordance with the Texas Rules of Civil Procedure. And then at paragraph 49 of its petition, again, it pled actual damage and loss, and that it was entitled to recover actual, general, special, and consequential damages, as well as court costs and attorney's fees. At no point did it plead nominal damages. And Your Honor, the Court of Appeals in Houston recently held that the fact that nominal damages can generally be recovered in a breach of contract cause of action does not create a fact issue as to whether a plaintiff produced evidence of actual damages. The court recognized that nominal damages are available for breach of contract, but also that they were not pled in that case. So without damages, San Miguel cannot sustain a breach of contract cause of action. So for this reason alone, the court should grant summary judgment in favor of the peelers. This is the letter, Your Honor, that is the entire basis for San Miguel's cause of action. And I would ask the court to actually read this letter because it is a notification letter stating the peelers' belief that the leasehold estate was lost on cessation of the use of the Peeler Ranch for lignite exploration, that the periodic tenancy was going to end on August 14th. Your Honor may recall that the peelers did give notice to San Miguel on June 20th, 2018. And within days, San Miguel began massive wastewater discharges over the Peeler Ranch outside the lease boundary. So this letter was necessary to protect the peelers' property from ongoing harm. So, Your Honor, when asked, the San Miguel corporate representative stated that when I asked him, what is the basis for your allegation that the peelers threaten to prevent access to San Miguel's property where those water wells are located? I was specifically asking about the allegations that they were being blocked from their water wells. He testified, I'm not sure what the peelers were going to prevent or weren't going to prevent San Miguel from being able to access. It was not defined. So it's hard to tell you what they envision by cutting us off from accessing the mine area. We assumed that it meant actually preventing us from entering the gates and going into the mine area. So San Miguel based its lawsuit on an assumption without any attempt to confer. Your Honor, San Miguel cannot establish the required elements for breach of contract. San Miguel claims the lockout letter constituted a repudiation of the lease. Repudiation requires a party to demonstrate by words or actions that he is not going to perform to his contract in the future. A denial that certain contractual duties are owed is not a repudiation. Nothing in the peelers did repudiated the mineral lease. More than a decade before the peelers' letter, the mineral lease had already ended by its own terms when lignite production ended in 2004. From the inception of the mineral lease until it terminated by operation of the habendum clause in 2004, the peelers fully performed all their obligations, and San Miguel makes no allegations to the contrary. Indeed, the peelers have continued to perform all of the mineral lessor's obligations to this day. All that has changed is the peelers have refused to accept San Miguel's tendered delay rental payments. San Miguel does not identify any provision in the mineral lease that requires the peelers to continue to accept delay rental payments after the lignite was fully mined out of the Peeler Ranch, or even after production began in paying quantities. The best San Miguel can say is that the peelers' assertion that the lease term has ended is an erroneous construction of the mineral lease, but that does not constitute repudiation under Texas law. Even if San Miguel could establish that the peelers' August 10th, 2018 letter repudiated the mineral lease, the peelers' attempt at repudiation was ineffective as a matter of law because the evidence leaves no doubt that San Miguel did not accept the peelers' alleged repudiation. Under well-settled Texas law, an anticipatory breach requires both a repudiation and an acceptance by the innocent party. When faced with repudiation, the non-breaching party has the option to either accept the repudiation and bring a suit for a breach of contract, or treat the notice of repudiation as inoperative so as to keep the contract alive for the benefit of the other party as well as his own. Under Texas law, a contract cannot be treated as both subsisting and at an end. Under such repudiation, upon such repudiation, the other may make his choice between two courses open to him, but can neither confuse them together nor take both. Because San Miguel did not accept the peeler's purported repudiation by behaving as if the mineral lease were terminated, San Miguel cannot claim repudiation now. Instead of accepting the purported repudiation, San Miguel treated the lease as ongoing. San Miguel promptly filed a lawsuit against the peelers seeking a declaration that the mineral lease was in effect and that it entitled San Miguel to ongoing unfettered rights to the leased premises. San Miguel also sought a temporary restraining order, arguing that it had a strong likelihood of success on the merits because it has a lawful right to access the Peeler Ranch under the mineral lease and amendments, as well as the associated deeds and easement. Notwithstanding the Peeler's purported repudiation of the mineral lease over 2 years ago, San Miguel has continued to possess and use the mineral lease premises. Because San Miguel has treated the mineral lease as ongoing, San Miguel cannot also treat it as ended. The only other acts which San Miguel alleges breach the parties' contracts are the peelers' communications with the Atascosa County Sheriff's Office and the Evergreen Underground Water District. Alonzo Peeler testified that he spoke to the sheriff only to let him know there might be a dispute. Such a communication cannot rise to the level of a breach of the mineral lease. Mr. Peeler also testified that he never contacted the Evergreen Underground Water District prior to the lawsuit, nor would the Peeler's statements regarding San Miguel's water production rights to a regulatory body be actionable as a breach of contract. Notably, the Peeler's communication with the Water District was one of only 2 alleged violations that served as the basis for this court's issuance of the temporary restraining order. The other was the communication with the Sheriff's Office. But when the Peelers sought summary judgment on their communication rights, San Miguel attempted to rewrite history, claiming that San Miguel's pleadings did not allege the Peelers' communications with the Water District were unlawful. Now, San Miguel has changed its tune again, asserting those communications are the basis for its causes of action. In any event, these communications with the sheriff and the Water District are, as a matter of law, not breaches of the mineral lease or any agreement. Finally, San Miguel itself already had breached the mineral lease before the Peelers sent their August 10th, 2018 letter. So the Peelers cannot have repudiated the contract so as to constitute an anticipatory breach. This court already has held the mineral lease does not allow San Miguel to dispose of coal ash derived from lignite mined off premises on the Peeler Ranch. Yet it is undisputed that San Miguel did so long before the Peelers sent their letter. This court has further ruled that such disposal comprises a breach of contract rather than a tort. And as the Texas Supreme Court held in Mustang Pipeline Company versus Driver Pipeline Company at 134 Southwest 3rd 195, a breaching party cannot subsequently enforce the contract. So San Miguel cannot sue the Peelers for breach of contract based on any events occurring after San Miguel began introducing offsite coal ash onto the Peeler premises. Because as a matter of law, San Miguel cannot demonstrate that the Peelers breached either the mineral lease or the buffer zone lease, which is not mentioned at all in the lockout letter, the court should grant the Peelers' motion for summary judgment and dismiss San Miguel's breach of contract claim such that San Miguel takes nothing. The court should also dismiss San Miguel's alternate plea in condemnation. Subsequent to the present alternative condemnation claim, San Miguel filed 3 separate condemnation lawsuits in August 2019 against the Peelers to condemn in fee 6,895 acres of the Peeler Ranch. The special commissioners' hearings took place on July 6th and 7th, 2020. The special commissioners entered a combined award of $38,415,000. If San Miguel deposited the award in the registry of the court, San Miguel could take possession of the property at any time. Although a condemnation petitioner may dismiss his condemnation case after the special commissioners have made an award, the condemner cannot, in an effort to lower the award, dismiss the condemnation proceeding merely to institute a new proceeding that involves substantially the same property owner. That's at the Texas Property Code section 21.019A. In that circumstance, the court must award in the first proceeding as the award in the second, and must award the property owner triple the amount of expenses that were allowed the property owner prior to the dismissal in the first proceeding. That's at Texas Property Code Section 21.20. Both of these statutes are clearly intended to prevent condemners from pursuing multiple avenues of condemnation if the condemner is unhappy with the special commissioner's award. For this same reason, San Miguel should not be allowed to pursue its plea in the alternative after a full special commissioner's hearing was had and awards were made on the very same property at issue. Furthermore, the appealers should not be forced to defend themselves in parallel condemnation cases over the same property so that San Miguel can get multiple bites at the apple in the hopes of a lower award. The Texas Supreme Court held in Brazos River Conservation and Reclamation District versus Allen, which is 171 Southwest 2nd, 842. A condemner has the right to correct its error, to dismiss its proceeding for condemnation, to abandon the purpose of taking the land, but it may not exercise any of those rights to the prejudice of the landowner. The condemnation actions may be for different interests, but only to the extent that one seeks 100% of the property interest and the other seeks, say, 80% of the same property interest. More importantly, the fee condemnation action moots the alternative condemnation. If you get the whole egg, you don't need another suit for the yolk. You already have it. And I think it's important to note how far the fee condemnation has gone, all the way through a special commissioner's hearing, which requires extensive expert work and a multi-day hearing and mini trial. They've basically done nothing with the alternative plea. And San Miguel has provided no law to rebut the property code provisions in the Brazos River case we cited. Texas follows the common law presumption against duplicative litigation in the same jurisdiction. Here, the alternative plea and condemnation should be dismissed. The similarity of the condemnation in fee and the alternate plea and condemnation for lease rights is clear. A determination of the issues in the fee condemnation will resolve all of the issues in the other. San Miguel is just keeping its options open in case it doesn't like the award in the fee condemnation, which is specifically disallowed under Texas law. Accordingly, the court should dismiss the lesser taking that is subsumed in the larger one. And just returning again to the same table, Your Honor, for all these reasons, we believe that the court should dismiss all of San Miguel's causes of action. They haven't demonstrated a right for a declaratory judgment for unfettered use of the Peeler lease premises. They have not met the test for a permanent injunction. They cannot prove breach of contract. They haven't shown any damages sustained, and they should not be allowed to add a new unpled damages theory 2.5 years later in order to survive summary judgment, a damages theory for $1 in damages. And the court should dismiss the alternate plea and condemnation because the condemnation in fee subsumes the condemnation in this case. Thank you, Your Honor.
All right, we're going to take about a 15-minute break. We'll come back at 3:30 and then we'll start responding.
The jail is also asking whether or not they're still needed or not. I think Philip Lampert had Julio Arguijo.
Mr. Lambert, I didn't need him to make a ruling, but we're not going to have a hearing, so we don't need either one of them. They're welcome to remain and watch if they want.
Okay, so I can let the jail know to go ahead and sign out.
Yes.
Thank you, Judge.
And who's going to argue on the other side?
Your Honor, Jennifer Friel for San Miguel.
Okay, all right. Go ahead, ma'am.
May it please the court. This may sound a bit like deja vu all over again, because to look at the affirmative claims San Miguel filed, we are considering whether or not the lease is terminated. And as Ms. Whittle said, this has been briefed and argued before. San Miguel maintains that the mining lease is a no-term lease. And we purport that the language of the lease, as well as common sense, show that it is in fact a no-term lease. Going to share my screen. One moment. All right, Your Honor, I want to go through a few, respond to each argument that opposing counsel made. And here's just a quick rundown of what we'll be going over. First, we'll go through the breach of contract claim and show that there is more than a scintilla of evidence that there has been a breach of the mining lease. Then we'll go over the declaratory judgment count, the injunctive relief, the alternative plea and condemnation, and then just briefly, if we would like to go over our evidentiary objections. In the reply we got yesterday, there were some objections to San Miguel's evidence. We haven't had a chance to respond to those, so I would like to do that briefly today.
Okay.
Turning to the lease language, this is the habendum clause, and it says, this lease shall remain in force so long as the rentals hereinafter provided for are paid and or so long as the coal, lignite, clay, and other minerals, except oil and gas, are produced from said land hereunder or from the lands utilized therewith in whole or in part as herein provided. Now, the appealers will have you ignore this and or language right here. In fact, in footnote 1 of their reply, the appealers ask this court to ignore the and or in the clause, and they say the and or is irrelevant, but it's not. It clearly says here that the lease shall remain in force as long as the rentals hereinafter are provided for. Also, the minerals to the lands hereby leased shall not revert to lesser or his assigns so long as annual renters herein are being paid. Now, this isn't the habendum clause. This is actually section 8 of the original mining lease. Now, in her argument, Ms. Whittle did say, she suggested to Your Honor that San Miguel hasn't pointed to any lease language supporting San Miguel's position. Again, she said, we haven't pointed to any lease language. Well, Your Honor, this sounds pretty dang good to me as supporting our position that titles to the minerals and the lands hereby leased shall not revert to lesser or his assigns so long as annual rentals herein are being paid, especially when moving back to the previous side. The habendum clause shows that the lease may be maintained by paying the rentals or by paying as long as the coal, lignite, and clay and other minerals are produced. So we propose that we have shown the court exact lease language that shows that the lease is ongoing. It's a no-term lease.
Let me ask, what damages for loss of lignite would your client have if the appealers successfully terminated the lease and that was a breach?
So we all agree that the lignite seam on the Peeler mine has been exhausted. But to get the lignite from other lands, there is no doubt that we need continued access to the lease premises. And I do want to go over, and we'll go over specifically the damages claim and why, thanks to the TRO entered by this court, we have not to date experienced economic damages, but there is no doubt that we at any point could. I heard opposing counsel today say they're asking this court to get rid of the TRO as of today, and would assert that the only reason we are asking for just nominal damages is because the status quo was maintained by that TRO. So The plain language again, the peelers have no answer whatsoever to sections 8 plain language that we just read. They ignore the and/or language of the habendum clause. And they also, and this is where the common sense comes in, because I know Mr. Peeler is a smart man, and I know that his predecessors who entered into this lease are smart, good, hardworking folks. And it's important that the peelers have accepted rental payments and loss of use payment for 14 years after mining. If Mr. Peeler thought that the lease had ended in 2004, he wouldn't have continued accepting these rental payments. And I think it's also important that he accepted these loss of use payments for those 14 years. Opposing counsel mentioned the Subsea 7 case, a case where they said that the parties did not act inconsistent to the theory that the breach had happened. Well, here, Mr. Peeler certainly acted in an inconsistent manner when the Peeler family accepted these payments, and specifically the loss of use payments. The loss of use payments, Your Honor, are made to compensate the peelers for land they can't use. So if land is being mined or being reclaimed such that they cannot use it, peelers get paid for that. It's in the lease. Again, these are smart folks. They put in loss of use payments into the lease because they understood that mining would take away land from their cattle operation. And those loss of use payments change year to year. They change based on what acreage is available. There is a fact dispute on when those loss of use payments should be discontinued. San Miguel's position is that when the peelers can put their cattle back on land and graze, we say, then you don't need the loss of use payment. If you're grazing your cattle on that land, the loss of use payments aren't required anymore. They suggest that loss of use payments should be paid through level 3 bond release. And I know Your Honor has heard about bond release before. Level 3 bond release is when the Railroad Commission actually says, yes, the land has been fully reclaimed. But for 14 years, those were paid and cash deposited into the bank by Mr. Peeler. And also, just again, common sense. This is mining. This is digging a hole in the ground, a very deep hole, and taking the lignite out. If the lease really terminates, if it terminates when the last ounce of lignite is removed from the ground, what's that going to look like? It's going to be a big old hole in the ground that hasn't been restored to its original conditions. The lease requires restoration to the original conditions.
Okay, but does that require the lease to remain in effect?
Yes, because it goes directly to access. Because if we're just on the road, Your Honor, if all we get is the road, which is what that lease letter says, and we'll show in a moment, we can't plant grass. We can't refill the pit. We can't put in spoil and then the required level of topsoil. The lease requires 10 feet of topsoil on top, subsoil and then topsoil on top. We couldn't do any of that. If we can't get off the road, the pit's not the road. And then we have to plant the grass. We have to monitor the grass for 5 years. The lease
So
says,
you're saying that on an oil and gas lease, the operator, if production has ceased, can just leave their equipment out there if they have a contractual obligation to remove it and say, well, you know, the lease must still be enforced because we have to have access to go back in to remove our pipelines and the Christmas tree and plug and abandon and all those things?
Your Honor, it's not an oil and gas lease. I mean, oil and gas.
Yeah, but what's the difference? If the operator, the lessee can plead that the lease itself and my title to the minerals is extended by my failure to restore the property, whether that's filling in a pit or just leveling it off and taking away your tank battery and everything.
Your Honor, oil and gas leases have a primary and secondary term. Mining leases are no term because it takes so long to reclaim the property. And you hit right on a huge fact issue in this case, which is whether or not we timely reclaimed. We're going to argue to the jury that we did in all diligence, have done what we can to in a reasonable time period, reclaim the piece of property that has not yet been reclaimed, and that's the final pit area in Area A. The peelers are going to say that we've taken too long. We're going to have experts, dueling experts on that issue, on whether San Miguel is taking too long. That's a fact issue. The lease being a no-term lease, if the lease requires us to plant and sprig grasses, you've got to fill the pit. You've got to regrade to original contour. The lease itself suggests this thing can't possibly end when the last ounce of lignite is removed. It defies common sense, and it has to be read in a whole. And I'll bring you back to provision 8. Title to the minerals and the lands hereby leased shall not revert to lessor or his assigned so long as annual rentals herein are being paid. And we've paid them, Your Honor. And again, the jury's going to be put to the question of whether or not we have timely reclaimed, but the lease hasn't terminated. It is a no-term lease, and it just doesn't make any sense. I do understand in an oil and gas situation, there might be some equipment left behind, but the Railroad Commission won't even grant level 3 bond release until grass has been shown to grow for a 5-year period. It's just completely different extraction of minerals processes, and one just takes more time. It takes more time to restore the land. And I heard, and this wasn't in any of the briefings, so I'll allow counsel to correct me if I'm wrong, but I heard, for what I think was the first time today, the assertion that the restoration rights would survive. That's the first time I'd heard that restoration rights would survive somehow the termination of the lease. Before, I had just heard about ingress and egress and roads. And now for the first time I'm hearing about restoration. It's almost, Your Honor, a concession that San Miguel needs to be on this property. They need to be reclaiming. They need to be doing that very important work that not only is in the lease, but is required by the state of Texas and the Railroad Commission. I want to talk briefly about the fourth court cases. The fourth court, and we did a whole second round of briefing on those cases, Your Honor, so I would invite the court to look at those. But the fourth court did use the term delay rental, but opposing counsel is putting way too much weight on those cases. They were not presented with the legal question of whether this was a no-term lease. That's the question before this court. And again, the language of the lease, the or in the and that Title 8, Section 8 language, along with common sense and how you read this whole thing together. How are we going to sprig grass if the lease is ended? And this idea for the first time that restoration somehow survives termination, I've never heard that before. And again, is almost a concession that even opposing counsel realized common sense says this thing cannot have ended in 2004. And we've heard a lot of expert arguments over experts recently, Your Honor. And I think it was just a couple of weeks ago where we heard a lot about Area B. And my colleague, Lewis Sutherland, was arguing about whether or not grass was sufficiently established on Area B. And there was the picture of the cattle trough, if you'll recall that. Yes. Well, Area B, all that reclamation, all that grass, all of that was all reclaimed after 2004. We've been out there working. Yes, the final mine pit in Area A is a sticky wicket, and we're still trying to solve that problem. But we've been out there doing reclamation work since 2004. And again, it will be a big fact issue for the jury if we've timely reclaimed. But the lease is a no-term lease. It's the only thing that makes sense with its plain language and common sense. So there's a valid contract. If the lease ended after the last ounce of lignite was extracted from the peeler property, you could not add the 10 foot of cover required by the lease. You could not backfill the final pits with spoil and topsoil. You could not plant the grasses as set out in the lease. You could not allow for that 5-year period for establishing grasses. So yes, if the first question on our affirmative claim is there a valid contract? Is there still a lease in effect? The answer is yes. I want to get now to the breach question.
Let me ask it this way. production plant's been closed down, all right? It's gone, or it's in the process of being dismantled, but it's no longer operative, and San Miguel is still in the process of restoring with no intention of anyone mining lignite out there. There's no lignite operations at all. You're saying that the mineral lease is still in effect?
It's a no-term lease, Your Honor.
And if somebody comes along and wants to lease the property for sand or for gravel or for uranium, even though there's no mining operations at all and there's no prospect of them, would your client still say, yeah, we own the mineral rights, stand in line behind us?
Your Honor, by the time the plant is closed, we'll be in that sprigging grass as a period, as I understand it. It does take quite a bit of time to get to the final stage in that end pit. But certainly if the peelers came to us and had someone willing to, an interested purchaser for their mineral rights, it's something we could negotiate. But the lease by its own terms is a no-term lease. And mining
Okay, I mean, I just wanted to make sure that
yeah,
that was a firm position. Okay, go ahead.
Our position is it's no term. And it's just how mining works. And again, the peelers are getting compensated. I mean, there are loss of use payments that are going to the peelers. They aren't as high as the royalty payments. And we acknowledge that. But there are provisions in the lease. Again, the peelers were smart and they got loss of use payments put into that lease. Again, we debate on when those should and shouldn't be ended, but it's allowed for in that lease. So the peelers, they breached it. I found this to be quite shocking when I read it in the peelers' papers. The reality is that the peelers actually did nothing more than send Smecky, they don't call us San Miguel, they always call us Smecky, a letter. The reality is that the peelers actually did nothing more than send Smecky a letter. It's undisputed that San Miguel employs about 500 people. They have contractors. KMG's in this case. KMG has employees out there. And San Miguel got a letter that said if these people did their job, they would be arrested. That's what that letter comes right down to. Because those employees can't inspect the ponds. They can't go to the monitoring wells that are spread throughout the mining lease from the road. And I was quite shocked that opposing counsel put up Mr. Peeler's deposition testimony. I find it shocking that he calls his buddy, the sheriff, to say, hey, just so you know, the largest employer in Atascosa County, yeah, well, they might not be able to go out on the property and you might have to be called out there to arrest them. Now I'm paraphrasing here, but you saw the testimony, Your Honor. He called his friend David and let him know what was happening. He didn't tell him to go out there, but how does that make Mike Kezar, the general manager out there, and his staff feel when they could be arrested for trespass for doing their job? I would like to show you that letter. Tony, I'll stop sharing my screen if you want to share the letter, please. So this is the letter. And we both think it's a very important piece of evidence for this. In the reply, the peelers actually challenge our use of it and object to the use of it, but they just used it in their argument. So I think there's no doubt that it has been authenticated. It's also referenced in their pleading. I want to go to the next page, Tony, and read the paragraph starting as of June 20. That's perfect. As of June 20, 2018, your client was on notice that the term of its tenancy expires August 14th. After midnight on August 14th, Mr. Kezar's sworn declaration says he got this letter about 5 o'clock on the 10th. After midnight on August 14th, your client will no longer have any right of entry to the leasehold acreage. Should your client attempt to enter those lands after midnight without express permission from the A.M. Peeler Ranch LLC, my clients will assert claims for trespass. The sheriff of Atascosa County has been notified of Smecky's eviction from the mineral lease and will be contacted in the event there is any dispute regarding your client's access to the Peeler Ranch. Further, my clients will be installing fencing, signage, and game cameras to protect their property and enforce the boundaries. It's not just, hey, if we see your people out there during the day doing their job, we're going to call the sheriff. We're also going to put up fences and game cameras. So you better not go out there at night either. We'll be watching you and we'll call the sheriff if we see you there. I want to go over this next paragraph as well. Your client has failed to reclaim the Peeler Ranch in a reasonable period of time after mining concluded in 2004. Again, that is a fact issue. Therefore, Smecky will no longer have access to the water control facilities referred to in Amendment 6 after August 14th. Water control facilities, these are the ponds. So when there's mining, Your Honor, as you've heard, not a lot of grass. So anytime there's rain, there can be runoff. So they have these sedimentation ponds all along the Haul Road. Pond 7 is one you've likely heard of. It's a large water control pond. During big rains, when you get a gully washer, you have to inspect those ponds. San Miguel has to go out there and look. And they have, under our Rule 11 agreement, which I'll be talking about momentarily, I email Ms. Whittle every time they do a discharge from a pond. It's part of our agreement. And they do it quite frequently when there's a big rain. You can't access the water control facilities. You can't look, observe whether they've been eroded. This puts actually San Miguel in arguably a very difficult ethical position that you can't control where all this water is storing. You can't let your people go and see these ponds. It's egregious and it's a breach. Yes, they're going to let us on the roads for ingress and egress, but that's not where all the work is required to be done. That's not where the monitoring wells are. That's not how you inspect the ponds. You can't do it all from the road. The other thing I do want to show is the final paragraph, if you would, Tony. It talks about that. There it is. There's a little bit of confusion about this, so I want to spend some time on it. So just what it says here, please be aware that we have notified the Evergreen Underground Water Conservation District that as of August 15th, Smecky no longer has legal control of leasehold acreage, which may impact Smecky's groundwater production rights. San Miguel operates a power plant that burns lignite to boil water in its boiler to turn turbines to make power. It's like telling McDonald's, hey, you may not get beef. This is a breach. This would cause irreparable harm to my client. It would shut it down. We're not complaining about the fact that they called the Evergreen Underground Water Conservation District. It's the fact that they put it in this letter. Be warned, San Miguel, be aware that we're not just going to call the sheriff. We're not just going to put up game cameras to watch you all hours of the day. We also want you to know we're watching your water rights, even though they very well knew that we own the acres that hold the actual water wells, the water wells. So again, Tony, that's fine. You want to stop. Going back to the PowerPoint, all they did was send a letter. If this will. Lost my praise there for a minute. All they did was send a letter. They weren't the one who received the letter. There's also a provision in the contract that says the lease shall never be forfeited, canceled, or terminated for failure by lessee to perform in whole or in part any of its implied obligations, unless there shall first be a final judicial ascertainment that such obligations or cause exists and that the lessee is in default. There shall first be a final judicial ascertainment. Now, in the reply, counsel says, oh, but this is just about implied obligations. But I'm pulling this from the Peeler's motion for partial summary judgment regarding coal ash disposal rights, where they are bringing up implied obligations. There, it's the implied easement of reasonable and necessary surface use. There have certainly been, and you could read into that letter, all sorts of implied obligations. San Miguel got that letter. They had no choice but to go to the courthouse. It was not just a letter, Your Honor. For my client, it was a nuclear bomb. Now, in a few weeks, we're going to be back here, and we're going to be arguing about our affirmative defenses. And I'm going to do a little bit of foreshadowing for you, Your Honor. We're going to argue about whether the Peeler's time-barred claims were resuscitated by Civil Practice and Remedies Code Section 16069. I won't go too into it, but as you know, 16069 can resuscitate time-barred claims from decades ago, if the defendant was first sued by the plaintiff. Your Honor, I foreshadow that you will hear that this letter was sent to entice San Miguel to file its affirmative claims. Smart lawyers. They sent that letter, they got us to file a lawsuit, and now they're claiming they can sue San Miguel for loss of use payments from the 1990s. This is gamesmanship. There's been a breach. It's more, they did more than just quote unquote send a letter.
All right, and what evidence is there though that there would be any concern from the behavior of the Peeler defendants in your client's causes of action if your client prevails on the contract, prevails at court, or there's some resolution that leaves the mineral lease ongoing? What evidence is there that there would be any need for an injunction at that point, that the Peelers wouldn't accept that?
You mean if there is a declaration that it's ongoing, that the lease is ongoing? Yes. You know, the letter was such a nuclear bomb to my client that we also included the injunctive relief, and partly because, and as opposing counsel said in our declaratory judgment count, there are a few things in there that aren't exactly in the lease. There's some clauses that we have added that we think reasonably stem from the lease, but go a little further. And just quite frankly, the pure vitriol that we interpreted from that letter led us to also seek that injunctive relief. So the Peelers also say that the undisputed reality is that Smecky now enjoys and has always enjoyed each and every benefit promised under the mineral lease. And I want to go over that because it's in the briefing. I didn't hear much of it today, but one reason we still benefit from the lease is because of the TRO. So it's disingenuous for the Peelers to say, oh, San Miguel hasn't been harmed by this breach. They're still doing everything just like they did before. Your Honor, that's only because we did get the TRO, which has been extended by a Rule 11 agreement. This came up briefly before we get past the breach question. about a prior material breach. It came up in some of the briefing, and Ms. Whittle did talk about it a bit today. So I just want to go over this briefly. The appealers have the burden of proof, but cite nothing in their original motion saying that there was a prior material breach. In their reply, the appealers made conclusory statements, but only pointed to one cited piece of evidence, and that was the declaration of Anthony Brown. Now, we have objected to the use of that declaration as summary judgment evidence. In fact, we've objected to that declaration in previous motions to exclude experts. Anthony Brown made this declaration after he was deposed. He made this declaration long after the deadline for rebuttal opinions, and we continue to object to any reliance on it. But even more interesting, the appealers have said in other filings that the placement of ash, not of ash burned from lignite from non-peeler property. This is a response to the motion for reconsideration of ash disposal ruling. This was filed in July. And I actually think that's the first time we saw the Brown declaration. We will be arguing this motion for reconsideration. We'll be arguing that in February, I think February 9th. So you'll hear more about it. But in this response, I'll just read it for you. In its motion, Specky states, again, they don't call us San Miguel. In the alternative, San Miguel moves for a no evidence partial summary judgment under the Texas Rule of Civil Procedure 166A1 on the peeler's breach of contract claim to the extent that such a claim is based on the presence of coal ash from lignite mine from outside the peeler property in the subsurface of the reclaimed land. To be clear, the peeler's breach of contract claim is not based on the presence of coal ash from lignite mined outside the peeler property. So if it's not a breach of the contract, then it can't be a prior material breach. Again, they have the burden of proof. They haven't put forth competent summary judgment motion, competent summary judgment evidence, and we would ask this court to deny any assertion that there was a prior material breach that in some way allowed for the breach we see in the lockout letter. So now getting to damages, which I think some of Your Honor's questions have gone to this. So just to go back in time, the court granted San Miguel the requested TRO, and San Miguel got access. The TRO gave San Miguel access. It allowed employees and contractors to go into the leased acreage to do their jobs. Then the parties extended the TRO, and they added to it by a Rule 11 agreement. This has been filed with the court. The Rule 11 agreement does specify that San Miguel can't place coal combustion residuals on peeler property. We agreed to that in a spirit of compromise. They also said we cannot discharge wastewater from Pond 7. And again, we agreed to that in a spirit of compromise. We are allowed to discharge wastewater from other ponds as long as we give the 24-hour notice, which I mentioned previously, Your Honor. So that is the Rule 11. But the Rule 11 also says the parties, the peeler parties and San Miguel agree to extend the terms and effectiveness of the TRO through the entry of final judgment in the case, such that the parties remain bound by, and the peeler specifically agreed to remain bound by, each of the provisions of the TRO. Notwithstanding this agreement, the parties expressly reserve the right to petition the court for an amendment to the TRO or for additional relief upon a showing of good cause. That's typical lawyer language, like, we have this agreement, but we can get out of it. So San Miguel put forward the nominal damages piece in our response, but that could change. If San Miguel, if the status quo is no longer maintained, that will change. And that, Your Honor, is why nominal damages are in our response, because rightly, we got the TRO to maintain the status quo, but if the status quo changes, that will be very, very different. Also, a party need not show any amount of damages or even a request for nominal damages for a breach of contract claim, because the non-breaching party has a right to seek equitable relief in the form of an injunction to enforce the contract. So the fact that we're seeking an injunction is also reason to show that we have established enough proof to get over the element of damages, certainly a scintilla of evidence, and viewing the evidence in the light most favorable to San Miguel.
Okay.
Just going through my outline here. The Peelers ignore the history of this case to claim that they're entitled to summary judgment because we have not specifically pled nominal damages. And they rely on this case, which opposing counsel did put on the screen, of Shihab versus, I hope I'm saying that right, Shihab versus First Service Credit Union. In that case, it was actually a pro se plaintiff, and they had filed suit against the credit union for failure to allow him to withdraw tens of thousands of dollars without advance notice so that he could buy a used car dealership. He pleaded that he'd suffered damages in the form of lost profit because he was not able to purchase the car dealership. There was no TRO in the Shihab case. And the credit union moved for summary judgment on the basis that there was no breach of contract and no evidence of lost profits. Now, in the response to his MSJ, the plaintiff in Shihab argued that he did not have to prove damages because nominal damages were available, but the court rejected that argument because the plaintiff had only pleaded lost profit damages. So in order to prevail on his claim, he had to produce some evidence of his damages in response to the no evidence motions. Now, San Miguel pleaded multiple forms of relief, including actual, incidental, and consequential damages, as well as injunctive relief, and all such other and further relief, general or special, at law or in equity, to which it was justly entitled. So for that reason, Your Honor, there's enough evidence of damages, especially when reviewed in light of that very broad pleading language. I just briefly want to touch on something that an argument I heard for the first time today on our attorney's fees. Opposing counsel put the chart that you saw and that we all saw in the box this morning. And that was the very first time I understood there would be argument today on attorney's fees. Do a control F of the motion, do a control F of the reply. There's nothing about attorney's fees, and we have not made any sort of concession with regard to attorney's fees, and it's showing up on the chart does not make it so. We would ask the court to not consider that argument, given that we have not had a chance to respond to it. So I do want to now transition to declaratory relief, but we'll certainly answer any further questions you have, Judge Wilson, on breach of contract, because these really are two sides of the same coin.
No, go ahead, please.
So here's what we're asking for. San Miguel has the right to unfettered access and use of the Peeler lease without interference by defendants and counterplaintiffs for the purposes of conducting all permissible operations, including ongoing reclamation activities, monitoring activities, regulatory compliance activities, and any other usage authorized by the Peeler lease and the various other agreements, deeds, and easements. Opposing counsel likes to jump on the word unfettered. But if you read this as a whole, we're talking about permissible operations. We are talking about activities authorized by the Peeler lease and those other agreements, deeds, and easements. The Peelers wrongly say San Miguel does not have the right to place CCR on the lease premises. And that's one thing we heard today. That is just flat out wrong. So to the extension, the declaration does discuss placement of CCR. We have put forward sufficient summary judgment evidence to show that they aren't entitled to denial of our request for a declaratory judgment based on this fact. Exhibit 8 to our response is a letter from Alonzo Peeler, where he says that we can place ash in the final pit in Area A. He calls it the dogleg pit. You've probably seen enough maps to know it does look a bit like a dogleg. And that is the final pit that is currently filled with water. That is the pit that is the big issue in this lawsuit. And he gives us the rights to put ash there. Also, the 1953 mining lease, which is Exhibit 1 to the response on the very first page. It grants possessory rights for taking care of and storing the products and derivatives of producing power or products created from producing power. I'm obviously paraphrasing here a bit, but all of that quoted language is on the first page. And when asked, Your Honor, to look at that. What are the derivatives of producing power and products created from producing power? Certainly, Your Honor, that would be coal combustion residuals. And when read in conjunction with the 1990 letter from Mr. Peeler, there is no doubt that to the extent we are seeking a declaratory judgment that we have the right to place CCR on the property, that is within our rights to do so. And again, the Rule 11 currently does not allow us to place CCR there. San Miguel, as I stand here today, does not have an intent to place CCR or a need to place CCR on the Peeler property, but it does need to dewater the final pit, and it does need to fill the void that was created from the removal of lignite. And with regard to dewatering that final pit, it can't do it unless it can discharge from Pond 7. So the current Rule 11 agreement, where we agreed in the spirit of compromise not to discharge from Pond 7, we can't get the water out of the final pit. We can't really begin reclamation. In fact, reclamation has been stalled during the pendency of this lawsuit, and no one could have predicted a pandemic and the trial date getting moved like it has because of a pandemic. But San Miguel has essentially, the status quo means, yes, we've had access, but the status quo because of the Rule 11 means we have not made any progress on dewatering the pit and getting it to the final condition that we will do. We will restore it as we are required to do under the lease and the permit. And often opposing counsel will say, they stopped mining in 2004 and they haven't reclaimed yet. Well, any stall that occurred after 2018 is because of this lawsuit. And those years are adding up. And we need, again, nothing to do with Your Honor. You're hearing us multiple times a week, but we need the declaratory judgment that we're requesting to get these things done. The Peelers complain that we're seeking a declaratory judgment that we can have access to do ongoing reclamation activities and monitoring activities and regulatory compliance activities. It's actually kind of shocking that they are opposed to this court saying, you can do reclamation, you can monitor, you can comply with your permit. But that's what they say in their pleadings. They're objecting to our request for these things. But at the same time, today we heard, but the provision for restoration, that's going to survive lease termination. We, in the lease, say we will restore the property. We have every intention of restoring that property. And it almost defies logic, but we need Your Honor, we need the court, we need a declaratory judgment to tell us that we can do that through ongoing reclamation activities, monitoring, and regulatory compliance. Again, they're objecting to those activities on their own property, which makes you wonder if what this lawsuit is really about. Is it really about reclamation, or is it about their request for $102 million from my client? It does, I mentioned it briefly, but the loss of use payments, in addition to affecting the breach of contract claim, they do have some relevance to the declaratory judgment. So just want to highlight again, those breach of contract, those loss of use payments, they are different. They do get calculated every year. And they're based on activity at the mining site right now. This isn't just a tenant paying monthly rent as a holdover. The Peelers did act inconsistently with the rights they now seek to enforce in the alleged termination of the lease. This was intentional. This wasn't just, like many of the cases they cite involving repudiation, this isn't just about, continuing to take a monthly rent check. The loss of use payments do transform this case into something different. We've mentioned it briefly, but roads for ingress and egress don't get us where we want to go. And there are other roads to get to those monitoring stations that San Miguel needs access to. I did want to talk, before I move to injunctive relief, I did want to talk briefly about this idea of repudiation. And just to say that they really are putting San Miguel in a very strange posture here. The idea that somehow that letter wasn't enough to trigger this lawsuit, and that somehow we had to allow ourselves to be kicked off the property, and I guess, change the status quo such that the TRO that we needed to continue operating, we would not have allowed to happen. The repudiation cases the peelers cite have a temporal element that really isn't present here. It's a lease payment is due at the next month, and so you decide whether or not, well, I'll accept that payment next week. But what's at issue in this lawsuit is access and the possessory interest. And there's no, well, we can just wait and see what happens. Given the letter that San Miguel received, again, it had no choice but to file a lawsuit. And again, I think it's reasonable to infer that it was enticed to file this lawsuit. I want to,
All
before I
right,
get,
ladies, I'm sorry, I just had my alarm go off. I've got to call a recess. I hope it's for about 15 minutes because my wife got called away and I have to be outside when my other son, my special needs son, gets off the bus. He usually gets home between 4:20 and 4:30. So I will be back here as quickly as I can. Again, I had a cell alarm, so I'll be right back.
thank you.
Okay, I'm back.
I'm ready. I see Ms. Whittle.
All right, go ahead.
Right, Your Honor, I just have a few points left. I want to start with why the motion for summary judgment should be denied as to San Miguel's request for injunctive relief. And I'd like to start, Tony, if you could pull up the Dan Cates depot transcript. So this is from Dan Cates, who was the plant manager of San Miguel. This was attached to our response. Question: what current operations on the Peeler lease premises are necessary to run the power plant? Answer: all of them. I mean, it takes the whole area out there, I mean, to run that power plant. We have obligations that we are committed to per our permits, regulatory agencies that we have things in place that we have to do out there to the point that we've got to get reclamation completed. I mean, that's something San Miguel has to do per our permit in our bond. So it takes the whole facility of us getting through access roads and reclaiming land and getting lignite off of different areas that's outside that, and coming up for us to do what we said we were going to do and follow our permits and the guidelines that have been put in place. So you need the entire acreage of the Peeler Ranch in order to run the power plant? Objection form. Well, what are you calling the entire property? The leased property. Within our permit boundary right now is what we need to run the plant, because that's what our obligation is. And our permits are inside that, and this is supposed to be leased acreage. It's in the errata. Leased acreage out there. So that's, to me, that's not the whole Peeler Ranch. It's the area that is permitted per the Railroad Commission and we work with. So, Your Honor, looks like summary judgment evidence to me. Taken in the light most favorable to San Miguel, if San Miguel is denied access, it will affect their operations. It will affect their ability to run their plant. It will affect their abilities to comply with their permit. And if the lockout letter is taken at its word, it could cause San Miguel personnel and contracting personnel to be arrested. It's interesting. Opposing counsel says, well, pointed to Mike Kezar's testimony that said, yes, we have had 5 to 10 violations from the Railroad Commission in our history. They've been mining since 1980. Yes, they have had some violations with the Railroad Commission. You would expect that, and we have experts who will say this is within the range of normal. But the idea that somehow we can be denied access to the leased property and just rack up violation after violation after violation for not going to our monitoring wells, for not investigating ponds, sedimentation ponds that fill up with water every time it rains, from really just being able to only stand on the roads and the acreage that we own that has the water wells on it. I mean, this is irreparable harm. I think Dan Cates' testimony gets us there. So why have we shown that injunctive relief? We've met our summary judgment burden. Access to water wells, their own reply says you can't get to at least one of the water wells from the haul road. You got to go off the road to get to at least one of our water wells. The drag line walkway, this is a huge operation. The drag line has to move from different property owners out and out of Skagit County. And the Peelers quadrant is right in the middle. The Peelers sold the power plant, the land where the power plant sits. So when that drag line moves, it has to, well, I guess it sounds like it's a fact question because Ms. Whittle says she believes that the drag line is an on-Peeler property, but Mike Kezar's declaration says that it is. And I would suggest that it's reasonable to infer that when the Peeler Ranch is smack dab in the middle, that moving that drag line is going to require access onto that Peeler lease. We do have our reclamation duties. The lease requires us to restore the property. And right now, no reclamation is getting done on Area A. I can tell you that because we're not dewatering. The status quo has been maintained, and we can't reclaim right now. There could be a permit rescission. The idea, I don't think it's ever been tested by the Railroad Commission that a leaseholder would just flat out deny access in an entire permitted area. But I think the possibility of rescission is certainly a fact issue. Will it end power production? If the permit is rescinded, it certainly would be suggested that it would be. Yes, Ken Donahue's testimony has been excluded. Your Honor made that decision last week, but the power production and the issue of grid reliability is in the Mike Kezar declaration, which is attached to our response. And again, I mean, it comes back to the letter. The letter, they say, is just a letter. We say it threatens arrests of our people. We need injunctive relief to make sure we can keep doing our jobs. We can fulfill our obligations in the lease, and we can fill our obligations to the state of Texas. Turning to the alternative plea and condemnation, and I'm getting really close to the end here. The two condemnation actions are seeking different things. There's a big difference in taking fee simple and taking lease rights. The fact that the special commissioner set a value for the real property has nothing to do with the value of the lease. There's also a suggestion that somehow we're pursuing the alternative plea and condemnation because we were displeased with the commissioner's award, but the alternative plea and condemnation have been on file at least a year, almost two, before the commissioners even made their award. So it's not as if we're pursuing the alternative plea and condemnation somehow because we're upset with the commissioner's award.
And just out of curiosity, where does the condemnation case in front of Judge Ellison stand?
My understanding, and opposing counsel might know more, is they're trying to set some dates. They are contesting the value that the special, San Miguel is contesting the value set for the property. There's also going to be hearing on the right to take, whether or not San Miguel has the right to take under the relevant statutory provisions for the property, which leads me to an argument opposing counsel made in suggesting that there was no irreparable harm, and that she suggested, well, the fact that they can condemn shows that they can get what they need without an injunction because they can just condemn the property. But I was a little confused by that because my understanding is that San Miguel's right to take is in controversy. While we maintain we have a right to take, my understanding is the appealers' position is that we do not have the right to take. So the condemnation in no way should jeopardize our ability to get the injunctive relief we seek in this lawsuit. The alternative plea and condemnation is again just an alternative. I think we've suggested to Your Honor how important those rights are to our operation, and if for some reason the lease were to have terminated, we would need to condemn those to do what we need to do to make power for the state of Texas and comply with our permits. And then the evidentiary objections, I know we're getting close to 5 o'clock, but we did object to two.
We had delays on my part, and I don't quit at 5 o'clock anyway unless there's something going on, so go ahead.
I appreciate that. We did object to two Peeler exhibits in our response. I will rely on our briefing on that. I did mention the Brown Declaration already this afternoon. We do object to evidence in the Peeler's reply. I mentioned that earlier. They attached a great deal of evidence to their reply that did not meet the 21-day deadline, including the map that was attempted to be introduced earlier. Exhibit 4 to their reply is a declaration from Mary Sitton that is dated from just 2 days ago, clearly outside the 21-day window. And I will suggest that opposing counsel worked really hard to get this heard today. She put it ahead of KMG's supplemental motion, and it's outside the 21-day window, and there are consequences to that. With regard to their objections to our motion on our response, they object to the rental refusal letter even though they cited in their own pleading, the lockout letter, even though they relied on it today, a collection of correspondence, the 1990 letter from Alonzo Peeler, and an RRC order. Starting with the easiest one, in our briefing, we say that that RRC order, the court can take judicial notice of an administrative order. It's in footnote 8 of our response. With regard to the correspondence, in regard to all of this, the Peelers aren't saying it's not authentic. They're just, in fact, using it themselves. I don't think there can be a dispute that it's authentic. There's also something maybe perhaps the Peelers missed, but Exhibit 7, which is that correspondence, it was proved up in Dave Burris's declaration, which was attached as Exhibit 2. So we did prove that up. That was in a footnote. So perhaps the council missed that we proved up the correspondence. The 1990 letter, the Peelers offered the exact same exhibit in support of their own coal ash MSJ. The Peelers live pleading references the rental refuser letter, as I mentioned. That's in paragraph 201. It's also proved up on page 85 of Mr. Peeler's deposition, which is attached as Exhibit 17. And then the lockout letter, again, I don't think they can honestly stand here and say that that isn't competent summary judgment evidence. So with that, I will just ask the court to deny the request for summary judgment on San Miguel's affirmative claims, viewing the evidence in the light most favorable to San Miguel. It should be denied.
All right. Ethan, and from anyone else other than the Peelers? Sometimes people want to.
No, Your Honor, not from
not
Keywood.
chirping.
Not from Keywood.
All right. Ms. Whittle?
Yes, Your Honor, just like a short response. Share my screen. So, Your Honor, just going back through the chart or the table of the causes of action, Your Honor, even if the Peelers are wrong about the term of the lease, San Miguel's causes of action should all be dismissed as a matter of law. For the declaratory judgment, San Miguel is asking for an extremely broad declaratory judgment with no end in sight, asking for rights that were never granted under any agreement. And they have presented no evidence demonstrating a right for a declaration that would extend its former mining rights into perpetuity or grant new rights never included in any agreement. For the permanent injunction, again, even if the Peelers are incorrect, it's not wrongful for them to state an incorrect legal position about the term of the mineral lease. San Miguel has not demonstrated that it needs the mineral lease premises to keep the plant in operation. Speculation, argument, that's not summary judgment evidence. Terminating San Miguel's possession of the mineral lease premises will not cause rolling blackouts in the state of Texas. That is hyperbolic and nonsensical and requires several actions that cannot all be linked back to the Peelers' refusal to allow San Miguel on the lease premises. None of the facilities necessary to operate the plant are being blocked by the Peelers in any way. And any regulatory compliance failure is attributable to San Miguel's decision to delay reclamation. Furthermore, all of the harms that they have claimed are easily monetizable. You can pay fines for regulatory violations. You can buy replacement coal to keep the plant running and provide power to the state of Texas. And arguably that actually would be far more efficient for this plant. So we don't think they have demonstrated.
I'm going to object that that's facts, not an evidence. There is nothing in the record suggesting that coal from Wyoming would be more affordable than coal right outside their door.
I'll sustain the objection.
So, Your Honor, they have not proven a right to a permanent injunction. They haven't met any of the 4 prongs, certainly not all of them. And so, and that's true even if the appealers are wrong about the lease term. Again, for breach of contract, San Miguel has not met all of the elements it's required to meet. And again, this is both a no evidence and a traditional motion for summary judgment. There's no evidence that the appealers failed to perform under any contract. We'll go through the lease provision. The Second Amendment has the restoration obligations. Those are all lessee obligations. There's no lessor obligation. So it's unclear to me how the appealers stopping San Miguel from engaging in restoration activities in any way breaches the appealers' obligations in that lease. And again, informing San Miguel that the lease had terminated is not a repudiation. And even if it was, San Miguel treated it as ongoing. And Ms. Friel did not address that argument at all today. In addition, there's no evidence of any damages at all. Nominal damages were unpled and cannot be added at this late date. Again, as San Miguel argued, deadlines mean deadlines. They can't plead new damages of $1 2.5 years later just to try to survive summary judgment. And San Miguel did drop its attorney's fee claim, and that is referenced in our motion, and I'll go to that in a moment. And again, for the alternate plea and condemnation, the court asked how far along that is. They are in discovery. They have divided the case into 2 trials, one on right to take, and then also separate trial on the actual amount of condemnation, and they are setting all of those. It's well underway and would certainly be finished before any alternate plea would be taken up in this case. And just on the right to take issue, that goes, it's this, similar argument to the injunction argument. There's no evidence that they would lose their mining permit by being locked out of the Peeler mineral lease premises. And even if they did lose their mining permit because they didn't complete reclamation activities, those aren't due until after the plant is closed. So they cannot demonstrate irreparable harm.
I object again to facts, not in evidence.
That isn't evidence. That's very much in both.
We have to begin. We might not finish reclamation.
Okay. Well, let Ms. Friel finish her objection.
Facts, not in evidence. The evidence will show we may not finish reclamation before the plant's closed, but we certainly will be beginning reclamation as soon as we are able to discharge from Pond 7, which I went through in my argument.
Your Honor, we have attached lots of evidence from San Miguel's depositions that the plant is intended to close in 2037 and that the permit doesn't require even the return of the Peeler Ranch to approximate original contour, which isn't full reclamation until after that date. So they couldn't violate their permit until after the plant has closed, which I think is clearly not imminent harm, and it's not likely to cause any actual plant outage because the plant will already be closed. So I'll turn to here, Your Honor. This is page, I think, 10 of our brief. We state in our statement of facts that San Miguel dismissed its attorney fee claim for its breach of contract cause of action because such a claim cannot be maintained against AM Peeler Ranch LLC, which is not a person or corporation under Section 38. And here we reference at note 17
that San Miguel, in its briefing on mental anguish damages and attorney's fees, stated San Miguel will not pursue a claim against A.M. Peeler Ranch LLC for fees under Section 38. So Ms. Friel appears to be attempting to revive an attorney's fee claim that San Miguel has already stated it does not have. And in any event, I think Texas law is clear that you can't get attorney's fees under Section 38 based on a nominal damage award under a breach of contract. So here, Your Honor, I want to go through Section 4 of the lease. While I've said that the Peelers don't have to be correct on the lease term in order for the court to dismiss all of San Miguel's causes of action today, we are correct. Paragraph 4 has the rental payment scheme. This is from the original mining lease. It sets the rentals at a sum of 50 cents per acre, and that was later increased to $2 an acre. These 50 cent an acre rental payments expressly include any royalty payments generated before production sufficient to independently sustain the lease is established. In other words, until royalty payments exceeded the 50 cent per acre threshold, the lessee receives a credit toward the 50 cent an acre rental obligation for any royalties it does manage to generate. This allows the rental scheme to persist after exploration and development of the premises lignite has begun, right up until production is sufficiently established to sustain the lease on royalties alone. Paragraph 4 mandates a one-time switch from rental payments to royalty payments at the moment when the royalties first equal the threshold rental value of 50 cent an acre. It establishes.
Tell me exactly what language you're looking at in there that does that. I have
it says has. Yes, Your Honor. It says has not equaled. So the royalty payable hereunder has not equaled. And that's the one-way ratchet. So, so the rental payments may be made if and only if the annual royalty payable by the lessee has not equaled 50 cents per acre. So once the payments have exceeded 50 cents an acre, it can never again be true that the royalty payable hereunder has not equaled this sum. So the language the contracting parties chose creates a condition which, when met, cannot be reset. So paragraph 4's payments can only be made unless and until the royalties payable under the lease have ever reached an amount equal to the annual rental threshold amount. And after that, rental payments are no longer applicable. And this is a sensible and traditional lease provision. Rental payments are available during the primary term, but cease to be relevant or desirable once production in paying quantities has commenced and the lease has transitioned to the secondary term. That's why the and/or clause in the habendum clause is irrelevant, because reading the lignite mining leases paragraph 4 and the habendum clauses, annual rental payments of 50 cents an acre may be made each year to maintain the lease in lieu of production only for so long as production has not yet generated enough royalties to meet this threshold amount. And this testimony is attached to our motion. This is from Mike Kezar, the general manager. I asked him, what is a delay rental payment? And he said, a delay rental payment is a payment that was made under the lease prior to the time that mining actually took place and royalties were paid in order to hold the lease. And do you believe that you can return to paying a delay rental after the coal is mined out? He answered, delay rental? I said, yes. And he said, no. I asked, do you believe that the Peeler mineral lease has been reverted into a ground lease at this point? No. Do you believe that $2 an acre in perpetuity is a reasonable sum to hold acreage under a mineral lease when the minerals have been mined out? And he answered, I mean, I disagree with your statement. I'm not sure where the $2 per acre is coming from. Those are delay rentals that would have been paid before mining began, not after mining. So Mr. Kezar's understanding of the lease is the same as ours. And then and just to to talk about the term no-term lease. It is a no-term primary term lease. It is not a no-term lease forever. It isn't a ground lease. This was a mineral lease. It has a no-term primary term. But once that condition in paragraph 4 of the original lease is met, the primary term has switched to the secondary term, and you can't return to those rentals in the habendum clause. Now, section 6 of the second amended lease has the restoration provisions. These are all express requirements of the lessee. These are obligations of the lessee, not the lessors. And what San Miguel is arguing is that the peelers locking San Miguel out so that San Miguel cannot complete these obligations is a breach of the lease. But these are lessee's obligations. They haven't pointed to any obligations of the peelers that they have violated. There's nothing in this lease that says the peelers have to allow San Miguel to comply with its regulatory obligations, or that San Miguel has to be allowed to do this work. These are lessee obligations. The peelers have not breached any of these obligations. And then, Your Honor, I'll just turn to the objections.
So would San Miguel be in breach if they don't carry out the restoration because your clients don't let them?
We believe they're already in breach because they didn't comply with the restoration obligations, and we believed they were engaging in harm that was going to be irreparable, such as the discharges over the massive wastewater discharges that needed to be stopped. And once there was a pause in those operations, there could be a discussion about what goes forward. The idea that the letter was somehow to instigate San Miguel to file a lawsuit, I think it's pretty clear we were intending to file a federal lawsuit, and that didn't happen. In any event, on the objections to the evidence, Your Honor, the Anthony Brown declaration was filed in the record many times, and at this point, Your Honor has already overruled objections to it in the STEC motions for summary judgment on their contract and tort claims. So those are already in the record, notwithstanding other parties continuing to object, and they haven't. Their basis for objection is just that they're dated after the date of disclosures. But again, we can't put our expert reports into the summary judgment record. It has to be a sworn statement, and we don't depose our own experts. So an affidavit or declaration is the best way to do that. There's no evidence or suggestion that any of his opinions are new. They were all disclosed in his reports and his deposition. The other objections they made are attachments to Mr. Fagan's evidence, or Mr. Fagan's affidavit, which again, we responded to all of those in our briefing. Our objections to San Miguel's evidence is that it's not a properly sworn summary judgment evidence. And again, we made those in our pleadings. So that's all, Your Honor. We ask that you grant the motion and dismiss San Miguel's claims such that they take nothing from the peelers.
Okay. All right, Mr. Guthrie, are you still wanting to go forward this afternoon?
Your Honor, I can, but I can also reschedule it.
How long do you think you would need to take?
I think it will take an hour. With response easily, and maybe an hour 15.
Okay, what says everyone? I need to have a copy of it sent to me.
It's not I'm not arguing, so I'll defer to Ms. Whittle and Mr. Guthrie.
Your Honor, I'm planning on mostly responding that we have already argued all of this. So I think my argument will be 10 to 15 minutes.
Well, I think mine will be probably 45 to an hour, and I plan on responding that no, we have not argued most of this. So for what that's worth, we're talking only about Johnson's opinions, and I'm going to try very hard not to cover ground that was covered in the joint motion. This is KMG's supplemental motion, but there are a number of objections that we have to opinions that relate solely to KMG.
Well, again, I don't have any of the pleadings because it might be I just need to reboot my computer, but everything is downloading at a crawl.
Well, again, Your Honor, I realize you had a long day and a disrupted day. So, I mean, I'd like to take these up sometime in the near future. Perhaps we can do it when we reschedule the rest of the hearing on the
Last Thursday?
Yes.
All right. Is there an objection to that?
No, Your Honor.
No, Your Honor.
Okay, then. All right, so we can do that. And hopefully my computer will work, my email will work, and my other son won't get sent home permanently. He just went back to school for the first time today. My older son, my younger one got sent home, as y'all know, at lunchtime. So. All right, then. So do we have any more this week?
No, Your Honor.
Y'all are set on the Thursday date, the 21st, I believe.
We are.
Yes. What's today? I'm so sorry. I'm on the wrong week. No, I don't have them this week. Today was the last. No, they're not set this week.
I don't think we have anything until the 9th.
And do I have anything set on the 28th? All I see is Judge. I don't see anything.
Let me look real quick, Judge.
Grand jury.
You're at the grand jury, so just Judge Ellison is hearing the civil cases and the one criminal case. And I have a question before you sign out
Yes.
on our YEHO. We didn't get a reset from Mr. Lambert. He called, but
All right, I'll make a ruling on that, and then they can ask for a setting if they want it. Okay. Anything else right now?
I don't believe so, Your Honor. Not from Keywood.
Okay.
Not from the appeals, Your Honor.
All right. Well, I will see y'all soon. And so all I have Thursday is the impaneling the grand jury.
that is correct, Judge. And I think, let's see, Tuesday, tomorrow.
Right, that's fine. I'm just gonna say, don't schedule anything else for me on Thursday and Fridays, so I can look at some of the motions I have here and try and get them knocked out.
Yes, you don't have anything else on Friday, sir.
All right, let's keep it that way. Okay. All right, I will see y'all soon.